Okay. So do you
All right, Mr. Alston, if you'd get us on the record, please.
Good morning. My name is Christopher Alston. I'm the reporter assigned by Vertex to take the record of this proceeding. We're now on the record at 8:42 a.m. This is the trial taken in the matter of Chris Ibezims and Tia Ibezims versus Waters Edge Group Incorporated et al. On February 1st, 2023, at the Superior Court of Fort County, State of Georgia, Judge Robert McBurney presiding. Will everyone in attendance please identify yourself for the record?
Larry Stewart for the plaintiff.
Brendan McLeod for the defendants.
Kevin Dorsey for third-party defendants. Stephen J. Kyle for Tyler Community Management.
And Danielle Wilson for third-party defendants.
Thank you.
All right, thank you. Good morning, everyone. Sorry, we're starting a little bit late. I had to manage something in my home chambers with this murder trial where they still don't have a jury. But I think today they'll get that done and get started with that case. We convened early because Mr. Dorsey indicated he might have a Rule 702 argument that he wanted to make. Interestingly, after Dr. Spots testified rather than before. I know we've litigated to a certain extent Dr. Spots and his affidavit and his ability to testify. We won't relitigate that, but now Dr. Spots has testified. And so I guess it is understandable that one or more parties might want to revisit the question of his expert testimony and what the jury ought to be able to do with it and maybe what they ought not to be able to do with it. So at a minimum, we're covering that. I think we also need to talk about attorney's fees, meaning can Mr. Stewart testify about that? Is that something that's before the jury, or is that something that I'd be working through, assuming there is a verdict in favor of plaintiffs? But let's start with the 702 issue that you wanted to discuss, Mr. Dorsey. And you're welcome to, one, stay seated if you want to, stand where you are. You can also go to the podium. If you're going to go to the podium, I'm going to slide over a little bit so I can see you because this monitor sort of blocks that. And good morning, Mr. Stewart. I'm not hiding from you.
I'll step over here when it's to my turn.
Okay.
And Your Honor, yes, there's those two issues, and I'd like to address some of the testimony actually come in as well before we get started. Starting with this first issue of Dr. Spots, I'm not challenging his qualifications in any manner. We would concede that he's qualified to testify. And I think that was, there's been, as you mentioned, some briefing and litigation over him earlier. However, I think yesterday, given his testimony, there's some question about the other two prongs of his testimony. And that's testimony is based on methodology and sufficiently reliable under the Daubert standard, and that it'll actually assist the trier of fact because he have applied principles and methods reliably. And I think the testimony showed yesterday that he failed to do both of those things. One, having sufficient data to analyze this issue. I think I asked him, did he speak with the board? Did he speak with the management company? Did he view it while it's raining? This is a water runoff case. It was dry. He didn't know if it had rained recently. Yes, some of his opinions were based on the sogginess of the soil. He did not speak with the developer. He did not speak with contractors. As far as testing, he did not test the soil. Testified that he could have. He did not take soil samples. He tried to memorize the color in hopes that he remembered it correctly. Understand, we are basing this opinion on his memory alone. And that's really important testimony because at the end of the day, we kept showing him that picture of the downspout. That was a huge issue for him. And that's exactly how it looked at that time when he went. And Your Honor may have picked up on the fact that indeed that's not how it looked at the time he was there. In fact, those integration systems had been implemented they were all tied into the storm drain, and the work that he said would resolve these problems had been completed. So I think that goes and flies in the face of his memory being credible, which is the only thing that we have to base his opinion on. He does not know when the pictures are taken, when the videos were taken that he viewed. That's highly important and highly relevant because this is a nuisance case. And nuisance isn't a fixed time and place, it's ongoing. And he agreed with that when he said erosion is also ongoing. All of these issues are ongoing, but he went out there one time, took a peek at it, relied on his memory, didn't take any photos. There's nothing for the jury to use. And I think that we have an interesting insight, given your honor's practice of allowing the jurors to ask questions. They were confused and they questioned why he didn't employ these scientific principles and methods. And it's very clear that the law requires an expert in his litigation practice to employ the same measure of skills and scientific reliability and testing that he would in his actual day-to-day job. And I think that we can all agree, and he had testified that he would have never written up a project for a developer or an inspection or approved something back when he was working with the governmental offices without employing those items. The other thing is there was a litany of testimony about what the pictures from the El Nino report looked like and how he saw standing water and all these issues. He has no clue whether it rained that day, rained that week, what was going on. And he testified, and that's very important because water's going to drain naturally, and there's going to be standing water when it rains. And if I may proffer, Mr. Smith was actually present during that inspection, the El Nino, and it was raining that day. So his testimony just is wholly, it just misconstrues the evidence. It's confusing for the jury. It's highly prejudicial for my client as well, because he went back and forth in his affidavit. He says, well, the builder's at fault. Then he says, well, maybe maintenance, but I don't really know what maintenance was. He was testifying as to pictures that were 50 feet away from the Ibezims residence, have nothing to do with the backup of water to their residence. And I think allowing his testimony to stand in this trial after seeing the lack of evidence that he has, the lack of testing, the lack of reliability, would be highly prejudicial, and he failed to meet the Daubert standards. I think the way we also sum that up is, could another soil expert come in here, take his data and test his hypothesis and his theories? The answer is no, because there's no notes, there's no data, there's no photos, there's no tests, there's nothing other than him saying, well, I saw it, and that's kind of what I think. And again, we're not challenging his ability to testify, his credentials, but the implementation of his testing and his testimony, I think, fails to meet the Daubert standards. So we'd ask that his testimony be stricken.
Okay. Mr. McLeod, anything, you didn't make the motion, if we're going to call it that, yesterday. The sense I got was after you heard the testimony and saw how the jurors were processing it, let me take a step back. You indicated before we started the trial, but once we were gathered in 9J, you might have a motion after Dr. Spots testified, or maybe even partway through his testimony to exclude. You didn't say anything yesterday, and I took that not to be you being forgetful, but you having processed everything he said and the way the jury was absorbing it, to say, actually, isn't it so bad for us after all? Because in closing, you can basically say everything that Mr. Dorsey just said, and that all goes to the weight that the jury would give to Dr. Spots' testimony, which might be very little weight because there were no pictures, because much of his testimony was based on pictures taken 2 years before he was there. I'm assuming someone's going to show this jury that the downspouts actually, by the time Dr. Spots was there, were integrated. And so there would have been no heartburn when he was there with that metal downspout only going 2/3 of the way out on the cement pad. I don't want to preclude you from doing anything. I just am noting for the record, yesterday, you actually seemed at peace with how that testimony had gone. It didn't say, I want it excluded. That doesn't mean you can't today. So now's your chance.
Yeah, thank you, Your Honor. I mean, having slept on it, I agree with basically what you said. That I think I am going to join in the motion with Mr. Dorsey, and for these reasons. The big problem I have is, and I'll cite the court to the Smith versus CX Transportation Inc. case. That's 343 Georgia App 508. And one of the big issues I had is that, and I do appreciate that Your Honor has the discretion to decide this issue and has a lot more experience in this matters. But in what that case says, it says in deciding whether an expert employed a reliable method, the trial court has discretion to consider whether the expert has adequately accounted for obvious alternative explanations. And I think that was a really big problem with his testimony. The fence has been an issue really since day one. It was an issue when he went out there. It should have been something that the plaintiffs discussed with him. The testimony was that it was not discussed with him, and that he did not consider the effect of the fence on the issues at hand. He didn't do any testing. He couldn't opine really what caused a lot of the issues conclusively.
What do you take from his testimony as his affidavit is in the record, but it is not in evidence in the sense that the jurors will read it. He's testified. If you were boiling down into a couple sentences, Dr. Spot's opinion was?
That goes to the second part of what I was going to say. I think there's also a general causation issue versus a specific causation issue. And, I think that this case, as we have previously cautioned against confusing general with specific in expert testimony. And I think what he did was try to offer general causation testimony. And if I had to boil it down to your Honor's question, I would say, having looked at the thing for 2 hours, my opinion is that it was partially a defect design, partially a maintenance issue. And aside from that, I think that's really what we got out of this testimony.
And if that is the net takeaway, how is that partial general, partial specific, or it's partly faulty design, partly maintenance? How is that outside the scope of his expertise and inconsistent and maybe impermissibly drawn from the very, very limited nature of the work that he did there?
Yeah, well, I think that's the point. I don't think he did enough work. I think that he should have, he couldn't even tell us the angles of the slope that he said he thought would have been helpful. With regard to the issue of the slab, he testified that his concern was the water was flowing over because of the pipe, the drain, the downspout. When the pictures that are going to come in or can be proven that, he obviously missed that on his inspection because it's very clear that those downspouts had been piped underground. And he even referenced that he did see the drainage inlets, yet he didn't do any type of testing to see what type of effect those were having on the drainage system as well. He was just concerned that pine straw might have clogged them. So I just feel like he really stopped short. And he signed an affidavit that was basically drafted by his counsel prior to getting there to really get to one conclusion, to support the plaintiffs in this litigation, not to make his own really independent investigation regarding what the conditions were out there 2 years prior to the time that he went out there. I think that's another big issue. He was out there very late in the day to really know what had changed and what the causes for that change were. And he testified he couldn't tell what some of those changes were. And so I'm concerned about his opinion that the drainage spout was causing all of these issues, and that was a big concern to him when
it wasn't there when he did his inspection.
Correct. And it had changed, and it had been changed for over 2 years since he went there. And his opinion was really based on the fact that he thought that condition existed when apparently he just missed that when he was out there for a limited time.
Or he's just misremembering. And there was the awkwardness of the pictures that he was shown predated his visit by 2 years and had become inaccurate. They were accurate when El Mina's engineers took them. But what I'm hearing you say, I'm not adopting it as true, but it sounds like you believe you could prove, and presumably you will, or Mr. Dorsey will, that in February of 2021, you could not have taken a picture like the one we spent so much time on with the brown downspout that extended about 2/3 of the way onto that cement pad and then stopped. And then we had the algae that everyone wanted to talk about. That pad is still there, and there may be a downspout, but it doesn't terminate in the middle of the pad. It now somehow is directed underground. But no one showed those pictures to Dr. Spots to say, well, you know what, actually, here's a picture circa January 2021, and you were here after that. So how does this change your perspective?
That's good.
Okay.
That's essentially correct. And I just think that overall, when we get to, and I do want to address his affidavit for just a brief second. I know you said we're not going to litigate this issue. And it's good that it's not going out to the jury, because I really feel like I would have had to renew my motion. In that affidavit, drafted by Mr. Stewart, it blamed the builder for all the seepage issues. He testified yesterday that he did not know what the cause of the seepage issues was. And so there is an inherent conflict between his testimony yesterday about that and his affidavit. That was one of the reasons, well, he is qualified as a hydrologist, no doubt about that. But as a lawyer and interpreting warranties and who they apply to, that sort of stuff.
I know we had lots of litigation about his ability to read the warranties and whatnot. And
So my concern about that would be on appeal. Well, you know, I mean, I guess it's not coming in. I don't know if there would be an argument that it should have come in. We've all agreed about that, but I certainly think at least that portion of this affidavit should be stricken as well. But
like you said, we're not relitigating that, because right now the affidavit is in the record, but it's not going out with the jury. And he didn't testify. I don't recall anyone examining Dr. Spots about the contents of the warranty or anything like that. In fact, his testimony yesterday was, your recollection is similar to mine, that he wasn't in a position, he didn't opine. Well, I'll tell you who's at fault here. It'd have to be the builder or Portrait Homes, or some people are calling them Patriot Homes. Or it would be the HOA, just someone, this swale isn't doing what it's supposed to do. And whoever put that check dam, gosh, look, it's lower, closer to the house. And that wouldn't help the situation.
right, and those pictures that he's relying on at the time, but may or may not have been an accurate representation of how it existed back when the issues occurred 2 years prior.
Nor how they looked 2 years later when he was there.
Correct.
Understood.
Yes.
Okay.
So in sum, I think that it did not do enough to prove the specific causation for the plaintiff's issues. And that's what I think was required of him. It was just a general, well, I looked at it and so I'm not sure.
But why is that? Because I'm going to hear apparently from Mr. Kyle also, and then from Mr. Stewart. If in the end, what Mr. Stewart's able to argue from Dr. Spott's testimony, not his affidavit, but his testimony, is that I brought in this expert and he looked at it and that's all he did. He can't say anything more than that. And you'll be able to say, he didn't do this, he didn't do this, and he wishes he had. He wished he had a camera with him, and he wished but he didn't. And he wasn't asked to. He would have if he was asked to, but you got a lawyer who had already written an affidavit and just wanted this guy to eyeball it and sign off on it. But it wasn't any set of eyeballs. It was a very, very qualified set of eyeballs who, given it that once over that he gave, and I'm simplifying it because he said he was out there for a couple hours and hiked up the hill and this and that. But his eyeball assessment was, there are some defects here. And he, unlike anyone else in this courtroom, is qualified to give it the eyeball once over and yield the not particularly compelling, but it's what he argued. I think the issue was the swale gets kind of level and there's this downspout. And you're going to be able to show, okay, at some point in time, there was a downspout. Of course, when he was there wasn't even a downspout issue. Why is he not qualified? You haven't said he's not qualified to do that, but given that no one can argue that his opinion, based on his experience and training, was also informed by rigorous scientific tests, but it was I gave it a once over. I looked at it and here's what I thought. That's as much weight as Mr. Stewart can make it bear. He can't say anything more about it.
Well, and my concern is that he's going to say, or could say, or argue that you heard Dr. Spots, he testified that the downspout was the issue that really caused this issue, and yet he never considered the alternative of the fence and what happened when the water backed up against the fence and if it should have been cut.
Well, but he did, and you asked him about that, and he said the water hits the fence and would go to the left, I guess, if you're got your back to the fence. You were able to examine about that. He talked about it, and I'm remembering his testimony, perhaps incorrectly, but I'm remembering it to be, look, the fix is you just angle the right, which is not inconsistent with at least one of the reports that's rattling around out there where there was no mention of the fence. But that's just one guy who didn't take any measurements, is misremembering the situation, and he said you don't need to move the fence. It doesn't make it dispositive. It just, the jury's going to give it whatever weight they're going to give it, and you already know some jurors' perspective of the weight of his testimony with the questions they asked.
But I was concerned more about the inside of the fence where he was testifying that it should have been raised.
Mhm.
That could have made a difference with the impact. That's where I have the issue with what he did not do out there with regard to testing. He testified that he was really concerned about the downspout because it was putting water into the backyard on the inside of the fence, but yet he didn't talk about, I figured out what would have happened if the fence had been raised, and he didn't add that part to the equation of the overall issue.
Okay.
That's the alternative explanation that he did not consider as to how that was called, whether that would cause an issue, because.
But doesn't that go to the weight and impact of his expert testimony that he supposedly is the whiz-bang scientist amongst all of us, and he didn't even think about another option that seemed pretty commonsensical to others, and in fact was something that El Mina came up with?
I will concede that's within your honor's discretion, but I do think the CSX case makes clear that that's something you need to consider as whether you consider reliable alternative.
Got it. Okay. Understood. Thank you. Mr. Kyle.
May it please the court. I want to look at this thing from 30,000 feet up. I'm looking at through the lens of Como and Daubert. Daubert says there are two factors that the trial judge must consider as the gatekeeper. The first is qualifications. I don't think there's any question that this man is qualified.
Right.
But the second two prongs are relevancy and reliability. It's clearly relevant because he's talking about this case. The question is the reliability. Como talks about the scientific method that an expert must have his hypothesis be able to be tested by other experts in the field. The first thing is you must make an observation. You made an observation. You must ask the question, what caused this drainage? You form a hypothesis or a testable explanation. You make a prediction based upon that hypothesis and then you test the prediction. The problem is there's no way that another expert can come in and if they listen to the transcript of Dr. Spots, be able to replicate that opinion. In other words, he cannot confirm it. The argument that I think we need to make is it reliable? And there are questions. An expert can give factual observations and can give expert opinions. Because of their specialty and expertise, they're allowed to give their opinions. The problem with this testimony is it's so jumbled with observations.
Well, I agree with most of your analysis there. I'm viewing, and I perceived Dr. Spots as more of an opinion giver than a fact finder. There was no hard science in the sense of I took measurements and did some math and shoved some soil into a machine and it made some whirring noises and said moisture content 32%. None of that happened. No question about that. So that part could not be replicated. Partly it couldn't be replicated because your dueling expert would be coming out 2 years later. And so it's going to be a different situation. I mean, inherently in this, unless all the experts showed up on the same day, to Mr. Dorsey's point, if it had rained 2 days before Dr. Spots was there, the soil moisture would be different than if you hired Dr. Jones and she went out there in the middle of August and it hadn't rained in a week, the soil might be very different. And so different results wouldn't mean the swale is still a good swale. But I didn't hear Dr. Spots making lots of factual conclusions.
I agree.
He in fact said I couldn't because no one asked me to bring my tools. No one asked me to take pictures. And so I'm giving you my opinion based on my expertise. And so that's the category of expert I'm seeing here. It's someone who might look at a photo of a lesion on a patient's face. I never met the patient, but I got a photo of it. That looks like a sarcoma to me because I'm a cancer doctor and I'm an oncologist. And so I looked at it, and you could show a picture taken a few weeks later and the light is a little bit different. And another oncologist would be equally qualified because of her background and training to look at it and say, I don't think that's a sarcoma. That's something else. I don't know that I ought to exclude either of those opinion experts because the methodology it flows through their training and experience as opposed to the classic Daubert. Well, you use this formula and you use this tool, and you don't use a tool that you built in your garage from coat hangers that hadn't been tested before. And that's not what happened with Dr. Spots. And so it's why I'm pushing back a little bit on the notion that his testimony should be excluded under what we might call classic Daubert, because he was much more of an educational expert. Let me tell the jury how swales work and grading and this and that. But he wasn't able to give, I think, a particularly compelling, he didn't give any factual opinions or conclusions. I looked at it and this was my field from.
Let me gently push back,
Please.
okay? The thing about the sarcoma, another doctor could look at that same photograph and give an opinion, contrary opinion. What Dr. Spots didn't do was take no photographs. He did no testing. If there are scientific tests that could have been performed, his statement that he didn't think about it or didn't have a camera, that falls on him as an expert. And it falls on Mr. Stewart as the attorney for not instructing him to do that. I mean, he could have come back. Mr. Stewart could have asked him to come back when it was raining, but he didn't. And the problem is, if you compare scientific data, which is absent from Dr. Spots, with another expert who could take a look at that scientific data, the soil composition, the colors, the photographs, and say, I have a contrary opinion, then Dr. Spots' opinion would be reliable. The problem is, it is just not reliable. And as the gatekeeper, we would ask that you consider that and exclude his testimony.
Okay. Mr. Stewart.
We've patiently listened. I'm going to start with a question and then you can add what you want to add. How could either Mr. McLeod's team or Mr. Dorsey's team have obtained an expert to try to rebut Dr. Spots's findings? That would have been a meaningful rebuttal because there were no pictures taken of what Dr. Spots examined and what the situation looked like at the time.
Very easy. Dr. Spots is the exact same thing I thought would be their three experts. They had three that people out there for the day and look at it. The first two did the exact same thing Dr. Spots. They evaluated the situation, identified the swell wasn't working right, the two identified the slab wasn't working right, and they wrote the report, gave it to them. The third expert, Elmino, did come back twice and went on a rainy day, so therefore they had pictures on the rainy day that Dr. Spots saw. Dr. Spots went out there, did the exact same thing they did, laid it out. You know, they said, oh, this is, you take out your testimony. They didn't take his deposition. If they take the deposition and challenge it, they need to go back on and look at it. If their experts come back out and they find a circuit court that, oh yeah, we looked at it in 2021, 22, and we're going to add all these other things because when we did the work, it fixed it. That's how it happened at all. They went out there in 2019 and 4 years have never provided any more expert testimony. 2 years later, Dr. Spots goes out, far more qualified than the three experts, and he does evaluation and he evaluates what was done after their experts gave their opinions and their workers did the work. And he went out there and he saw it. He saw that wait a minute, El Nino said you're gonna realign it or take the fence down. We didn't take the fence down, but HOA, which is not just testimony, said you should realign it. It's not realigned, it's still water flooding on the fence. Two, both other experts, they only had one of the experts said, this slab should be taken up and redone and fixed. He went there, it was not taken up, refund, that's still a problem. Now they're going to testify that when they did some work, it's not what the Albino told them to do. And the third issue was a pipe that came halfway across the drain. That was there for a year and a half from the time they closed in March 2018. And that was a problem. And they said from day one we had the water problem. So that was a problem. Albino said you should connect it in. They did connect. It was connected. Dr. Spots went there 2 years ago. He signed his affidavit. He didn't bring up anything on the drain at that time of a pipe.
We sure talked about it a lot yesterday, and
I wish he
frankly,
hadn't said a word about it. but
he talked
did.
about it like that's how it looked when he was there, and that's confusing to the jury.
And that's what they argued to the jury. But he was there 2 years ago, and now he sees the picture, and he don't remember exactly about the pipe. The same thing as what you saw in that picture. Pipe comes down, goes halfway out and stops in the picture. The difference now is the pipe came down, turns that way, and goes 6 more feet, and then sticks in the ground. That's what he didn't remember, and he got wrong. And that's for cross-examination. The things they mentioned, like.
So tell me what you intend to argue Dr. Spots's opinions were. When you're gonna share with the jury, here's why you need to find Water's Edge Group liable. And Dr. Spots supports that in the following way. What does he say that you
Dr.
think?
Spot supports the fact that El Nino told them, there's no problem with swing around the alignments. He said they could do that, El Nino said that they do that, they didn't do that. Dr. Spot says, yes, they can fix that slab, and they got to take it up or else. And they didn't do the geotech, they didn't do the grading or anything like that, but they did do, and that's still a problem, because he himself went there and kicked under the ground and saw, it bent down and saw that there was still a hole up under there, and the water's coming out. He saw the videos of the water was coming out, things of that nature. And my client was there, right there beside him, said, yes, we still have the water coming out from under there, because that hole hadn't been fixed. And that's what he's going to testify. That's what he testified to. The fact he didn't talk to the board or to other people, things of that nature, that wasn't the purpose of his visit. He wasn't out there to determine.
No, and that's not, I mean, he's can talk to who he wants. It expands or it decreases his range of knowledge, but it's not a scientific principle that you talk to the homeowners association. The science involved would be assessing the slopes and the grades and the soil content. And it wasn't his job to say who was responsible for making the changes he recommended or who should have made them before. So I'm not troubled by that.
Okay, but his testimony was, he went out there, he compared what El Nino said it was, looked at their picture and said, it's pretty much exactly the same. He got it wrong, that they did put the pipe in they talked about, but everything else is still a problem. The fact my client tells you that it's still flooding like that is not a surprise to him, because El Nino and his evaluation from 2019 to 2021 is the same. As far as I didn't take photographs and that all goes to the later that they say you should have done that, but their experts didn't think they should do that. In fact, their experts aren't coming. All they did is introduce the reports. And say he didn't come back. If their experts come back, he would have came back if he needed to. But you assume, like most lawsuits, they're going to take the deposition and they're going to have their experts write their affidavit and contradict him, and then I would have him do something if we needed to rebut their experts or whatever. But that's even then, that's not a Daubert motion to go to the dispute between experts for the jury to decide themselves. They had 3 experts, we had 1 expert. Big difference, our experts are much more qualified. Our expert came back after their 3 experts and made the recommendation. They've done all the work that they told them to do. My expert looks at 2 years later and said, they only did part of it and it didn't work. There's no reason. They said, well, you didn't come out and see, maybe it's changed. There's been no testimony anybody did anywhere else. Well, the whole under the concrete slab changed in the last 2 years. His opinions are all met the Department of Daubert. Every argument they make goes to the way that it's not admissibility. clearly it's inappropriate to be filing after the testimony that what they should have done before. Like I said first, Your Honor, if you go back to that wonderful order you wrote, 3 pages about his experts and qualifications. The fact that he didn't do more things,
Goes to the weight of his testimony.
well, it goes, wait, and that's not what we hired him to do. They asked him a lot of questions about, well, what would they fix it? What did you tell them to do to fix it? He wasn't there to fix the problem. He was saying if you do what you tell me on report, it wouldn't fix it, but you didn't do it.
Okay,
Thank you, Your Honor.
you're welcome. Are all our jurors here? I'm gonna take this under advisement, but we'll talk about it again today. Nothing needs to happen today about this, but we'll resolve it today. Appreciate everyone's input. I want to get started because the jurors are here. Mr. Stewart, can you put up witnesses other than yourself all morning long? So we don't have to worry about this attorney's fees thing yet?
I was gonna be the second witness. So I put one witness other than myself and do it at the break time maybe, or
Well, I'm going to direct you not to testify until we work through that issue, and we'll work through it when we can,
I
okay?
have 1 minute. What's the problem? He testified. I've done 100 times.
I don't know. You were supposed to talk about it with the other lawyers after we ended today, yesterday. So don't ask me. I'm not the one objecting to it.
I've never-
And now isn't the time we're going to do it because our jurors are right here. So my direction to you is don't call yourself as a witness until we work through. I don't know what the concern is. I don't think you're not entitled to attorney's fees, but I don't know that that necessarily is what comes up with contingency fee situations. So that may be the concern. We clearly need to work through it. Why it wasn't brought up before trial, don't know. That's how these things have been going in this case.
Other thing I want to say, I apologize. I did not hear us say we were supposed to get together and talk about the attorney's fees. I didn't know what the problem was. I've done, yeah,
All right.
I would definitely talk to them, say, what's the problem if they didn't tell me that.
Briefly, because I think this might delve into some of the testimony coming. In opening statements, there was a lot of remark on how this has affected the kids and things like that. Kids are not parties to this suit, and while I understand that wanting to keep them in the yard and give them a place to play is a purpose for building the fence, I think it needs to stop there, and I would ask that there not be any more harping or sympathy factor thrown in there as far as the effect on them and how it's affected their ability to go outside and all those things, just because they are not plaintiffs to the suit. It's nothing more than trying to drive sympathy to the jury.
But is the nuisance impact on Miss Ibezim not a factor the jury should consider?
I see where your honor's going, that the impact on the kids is in turn an impact on her.
There's a line to be drawn. Mr. Stewart shouldn't go too far with it, and I'll tell him to move on to something else if we're going into 50 questions about, well, what about this son and how's that? Because you are correct, it's the impact on Mr. and Ms. Ibezim and not their kids directly.
Yes, Your Honor.
But of course, it's sort of like Lasso Consortium. The impact on the children could have a direct impact on that. I can't get my work done because I can't have my kids go out back because I don't think it's safe back there.
I understand. I just want to make sure that is.
It's on my radar, rule of reason, but I don't think it's off limits. Mr. Stewart, you'll just need to be thoughtful about how you explore that.
Well, I'm not putting a record, that is incorrect. That is not the law. The law is a nuisance parent can cover for the whole family. They don't have to be named parties, and there's case law that says.
So send me the case law before you do it.
No, well, I never heard of anybody objecting for it.
Well, someone just
Oglethorpe
objected.
says that. And that's
Pardon
what
me?
Oglethorpe,
Okay, I need a citation. And so you get me a citation and that's fine. Anything else before we bring the jurors in?
oh yeah.
Okay,
One thing, Your Honor, I want to submit 2 other charges I'll bring in tomorrow. Will that be all right?
so what you should do is email them to Ms. Niles and all the other lawyers. And I'll let you all know, Ms. Niles is overwhelmed by the charges you all have submitted. They're all over the map. I'm not a big fan of non-pattern charges. I don't make your arguments for you. So don't be surprised if during our charge conference, a whole lot of what the parties have submitted is not in there. It's not my job to make your legal arguments. That's your job. If it's defining the law or making plain some principles, for example, Mr. Stewart, I'm not disagreeing with you. I'm not a nuisance expert. If it is appropriate for jurors to consider the impact of the nuisance on all family members, that's something I tell the jury. I don't need a 52-line jury charge to do that. But a whole lot of what was submitted is more argumentation than here's the judge instructing the jury about the law. So if you're submitting additional ones and they're basically arguments you want to make, Ms. Niles is going to put them in that file of, Judge, I don't think you need to give these. Okay. All right, let's bring the jurors in.
Maybe. I'll have to see if I can find the video in the phone itself. I should be able to.
All right, adjourned. I'll do it, the president.
Thank you, Deputy Gordon. You all can be seated. Good morning, ladies and gentlemen. Happy February. We've been together for 2 months now. Probably feels like 6. I appreciate you all being on time. We actually got here at 8:30 this morning, and boy, there's always a lot to deal with lawyers when there's 2 sets of lawyers, and I've got 3 sets of lawyers. So I've got an extra 50% of, Judge, we have to argue about this and that. So we were working through some things that we needed to, and we will continue with the plaintiff's case. Mr. Stewart, if you'll call your next witness.
I'd call Sean Smith to the stand.
Mr. Smith.
I do. Sean Smith.
What's going on with the screen?
It had some pop-ups on it.
You made them go away?
They're gone.
Thank you.
Yep.
Good morning, Ms. Smith.
Good morning.
Ms. Smith, you're the president of the association, is that correct?
That is correct.
You also member of the board of the association. What's the difference between the president and the board? Member of the board.
I guess you can say I have the board works all together. There's 5 of us total. At the end of the day, I'm the one that would sign something that we all vote on it. So everyone, president doesn't mean that it's just Sean's opinion of things. It means that we all work collaboratively, and then I'll be the one to send something back to the management company.
And you are a member of the architecture committee as well?
Correct.
Committee is the same as the board members?
In our community, it is. Yeah,
All members of the board, all members of architecture.
correct.
So when Ms. Tia went on portable to send that ACC form application, that came to you or to all the committee?
If she did it on the portal, it would have gone to the management company. And then the management company, our manager at the time, would have sent it to us.
That'd be Mr. Todd.
Correct.
All right, so as the board president and member of the HOA association, what is your relationship with Backyard Realty?
So we hired Backyard Realty to handle the day-to-day operations. So when we talk about things like landscaping, paying water bills, collections, collecting the HOA monthly dues, they handle the business end of it, but all the decisions come through the board.
Tell me what what is the association relationship with all the units? You heard it was 174, was it about 174 people on the board or whatever?
So there's 174 total units in the community. And I think they talked about it with a condominium, every owner owns. So basically it'd be 174th of every property. So, you know, whatever that equates to of my front lawn is owned by the Ibezims. I own a piece of theirs. Cooperative.
Do you yourself live in that?
I do. All board members have to.
Okay, so you live in there, and I think I heard yesterday you're a volunteer, you're not paid for yourself?
Correct. We are all volunteers.
So you talked about 174 homeowners who individual units. What about the driveway, patio in the back, dividing fences that will hang with the property and that?
So the driveways, the patios are considered limited common elements. And it would be weird to have everyone have access to everyone's patios. So, you know, common elements are for everyone, limited common elements are for you because it would be your unit, your patio. You and your family should be there. I shouldn't be, you know, you shouldn't open your back door and I'm sitting there having a beer, you know, so.
All right, so when you walk out your back door of your condo, or you call it condos or townhomes? But
It's condo, townhome. It really doesn't matter.
walk out the back of your condo, that patio right there, that's actually part of the common area. But common element, and they got control over that area. Their actual deed to the property is not included with the patio in the back.
So the concrete pads, the front sidewalks, that is all responsibility of the homeowner.
Right? Responsibility about who owns it.
Who owns it? It would be technically, I mean, it's part of the land but the responsibility, I guess you can say the condo owns it, but the owner is the ones that will be responsible for maintaining those.
Right? As far as there's a say that he sold their unit, next person moved in, but there's a big crack in the middle of their patio. Is that something the association would come in and fix?
No.
That'd be the homeowner.
That is something that the homeowner would be responsible for.
But still, the association actually owns it, but they.
Yeah.
That part of the covenant.
That
they
part-
buy?
That part of it, I believe, I mean, that's, you know, wear and tear. It's not something that that the association has caused. It's just like the driveways. You know, certain things are covered by the inside of, you know, the driving pad in your garage. That's caused by me, you know, or my car. So therefore I would be responsible for that.
What about association takes care of all the common areas like the swell area, and there's swimming through the subdivision of that nature? What about the grass within, around the patio or the common element? Nobody goes in that area.
It depends on what the situation is. If it's after the fact that you've done an ACC request and say, for example, say I installed a fence, I am responsible for inside of my fence. And I think it says it on the ACC application that if you choose to lock the fence, that becomes, so we've made it standard practice because a lot of people have dogs. I'm never going to ask a landscaper to go behind someone's house and, you know, put themselves in that position. So we've made it the responsibility of all homeowners throughout the years to make sure that you take care of the inside. And
So they put a fence up and they leave it unlocked. Will the association come and cut the grass?
no, it says, I believe locked on the thing, but we have made it across the board and specifically because of dogs. We're not going to take that chance. And I mean, I have seen people put signs up. If you come back here, you'll be shot.
Once you put that fence up like it's did, whether it's locked or not locked, your association common area maintenance folks are not going to go inside that.
No. No.
Tell me what your understanding is prior to where did it buy the 54 units and still by geo sound whatever. What was your association's role with had ready lot, no units to the village?
So when I moved into the community, and I've been there for about 12 years now, where I live is, and you'll see some pictures that I'm sure that it's on the Elmina report, which I can kind of show you in relation to the lots where I live. But I'm towards the back of the community. So pretty much all of the remaining lots were on the back end of the community, including the Ibezims. We had no relationship to those lots whatsoever. Mill Creek we did not own the lots. We did not manage the lots. We were told not to go on those lots. When I first moved into the community, the wild basil, which is where the Ibezims unit is located, was chained off. A lot of people used to hang out back there, which became a problem for the community. So the police had to get people out of there. We had no control over those lots whatsoever.
Okay, you heard an open statement that pertains to the association, I think, February 2018.
I believe so.
Building 30, glass, off their unit, March, the next month, whatever. What happened in February 2018? Changed over the association.
So just to give you a little bit of background. So basically, we chose to keep one association in the neighborhood. There could have been two, which would have been extremely awkward considering there's only one pool. And how do you govern who's coming in and out and everything? So we decided, okay, for the benefit of the neighborhood, it's better to have one association over everyone. So in February, what they were doing as they sold the units, they would submit another building to us. So February came along and they submitted that building, which is a building 30, to us to bring into the association.
In February, the building 30 came over. How many units were built?
I believe those two buildings were two of the last buildings to come in.
30 and 30.
30 and 31 on Wild Basil. And I think there's a total of 10 or 11 in there. So we would have been looking at 164, 165 units, something like that.
I'm asking about building 30, they had 6 units.
Mhm.
February 2018, how many of those units were filled when it came over to the association?
That is a good question. In February, I couldn't tell you offhand, but I know there was, I want to say 2 or 3 in there at the time.
Prior to those units, the whole building 30 coming over, who's responsible for defects in the swell area and whatever things within the county? Who had responsibility for that?
That would have been on Water's Edge and GeoSam. I don't know the inner workings of their agreements, so I'll refer to them both at the same time.
All right, so March 2018, my clients bought their unit. Who had responsibility for common area behind the swells at and their back patio?
So at that time, it's a complicated question because there's no way. First of all, because I've heard testimony regarding the grading and everything. Keep in mind, these were the entire lots. There was machinery over everything. I'm not going to say like the guys didn't come in and say, oh, here's the end of their patio, so don't take your machine over this divided line here. Everything was just back there. Sorry. So when we talk about responsibility, the issue of water, and I think we talked about it yesterday, the ultimate responsibility was on Water's Edge to make sure that the property could handle the amount of water that was spilling off of the buildings. I think you heard the gentleman yesterday talk about there was no water coming off the hill, which there wasn't. I've been out there more than anybody on this planet in the pouring rain, watching as it's raining, what's happening. And the water spilling, you're talking about hundreds and hundreds and hundreds of gallons spilling off of the buildings. And Water's Edge, it was their responsibility to make sure that that area was developed to handle that amount of water.
Okay, so March 9, 2018, my clients closed on the unit. And shortly after they discovered that there was flooding problems that existed, there's been nothing changed. The day they closed, the first time heavy rain showed us flooding problem. Was that something that's covered because you now have a warranty? They have a warranty, or you're in charge of maintenance? Who's supposed to take care of that?
So due to the extent of the issue, I was out doing routine maintenance one day and just walking the property, looking at the new buildings. That's when I couldn't tell you, but I know that there's an email because it was the day I met Chris. And as soon as I got home, I emailed them and let them know it was nice meeting you. You know, we talked about the warranty issue and all that. But my advice to him was to go back to Water's Edge and have that conversation with them, because this is not something that the association created.
So was it a defect at the time of closing that already existed versus something after closing would be a warranty issue that something breaks afterwards?
Based on the amount of time that had passed, I would have to consider it a defect, because there wouldn't have been enough time. We talked about erosion changing over time, and yes, I've dealt with erosion issues constantly being in a neighborhood, but the Grand Canyon wasn't formed in 2 days. It took a lot of effort to get that way. And it's the same thing with, it would have taken years for us to get to a point where water was affecting them the way it was.
Right. And so we heard an open statement, defense lawyer saying that this is just a warranty issue. Closing happened, warranty, and that's all HOA. It's not us at all. How do you distinguish between the defect that existed at closing that they didn't do right, get the CO, the warranty after they kick in after they close for a year?
The warranty, we wouldn't have known anything about the warranty that the Ibezims got. I still don't know what the warranty is because I didn't purchase it, nor did I offer it. The HOA had nothing to do with, when I tell you the HOA had nothing to do with any of this, the HOA had nothing. We weren't involved in a sale. We received nothing except some extra patio furniture for the pool, which would make sense. We've received nothing. We had no, so the whole warranty thing, I can tell him, go to your warranty, submit a warranty, because I know we talked about it. But I can't speak for what Water's Edge was going to do or what the warranty was going to cover, because honestly, we did not know. We just knew it was not an issue that the HOA created.
So when you were back there walking around and raining, building 30, you saw the flooding problem, things were not looking good and all that. Did you go to Water's Edge and say, hey, this is a defect at the time of closing, you're responsible to fix it?
So I believe, if I'm correct, I think eventually Chris submitted a work order. And I think that's when it went to Mr. Tully and Backyard Realty. We talked about it and everyone was in agreement that, yeah, this should be covered by Water's Edge. And I believe I'm pretty sure you guys have all the emails back and forth and everything, but there were conversations had between, I think, mostly Backyard Realty and Water's Edge Group. And Chris and I had, at the time, we were still interacting a good amount as well.
Chris Knight?
No, Chris Ibezims.
Oh, Chris.
Ibezims.
Okay. You see, we all agree this is Water's Edge problem. Who's all we?
Me, Backyard Realty. Yeah, that was pretty much, we spoke about the board as well. When I say all of us, we sat down, we talked about the issue. And everybody agreed this is not something that was created by the association. Therefore, we would expect the builder to handle the issue.
All right, so we know a lot of emails went back and forth. September 2018, 6 months afterwards. They were having problems, they say, from day one, I think that March 2018, when they closed over. September 2018, roughly. Ballpark, how many times did you go behind building 30 and see it? That 6 months.
So I can tell you that, and it would not have been just their building, but as president, I'm probably one of the most active presidents in a community. So especially since we had brand new buildings, and as you can imagine, things happen with a brand new buildings. So it's important to keep moving around and checking out things. I can't give you an exact number, but I mean, I used to walk the streets every night looking at things. So it would have been a good amount.
Give me a range behind building 30 in March 2018, September 2018. Say 2 times, 4 times, 8 times.
Oh no. I
2
mean,
days.
30, 40 times probably, just walking around the area, checking things out. But again, you don't see everything that's going on. I'm just looking at, for major stuff that needs to, because I mean, during that time we find, you see nail pops on buildings, you see roof shingles lifting up. There's a ton of different things and then we'd reach back out to them and they would handle it. So.
My understanding, you're saying now that 6 month period behind building 30, looking at that 20 to 30 times.
Not looking at that issue, looking just walking around, because keep in mind between March and I can't even tell you when the month that we met, but all of this did not start really escalating until later in the year. So between June, I mean, to be honest, I can't say that I was going out there specifically to look at Mr. Ibezims' issue.
What was the rain situation during that period? Was heavy rain, light rain, as far as like that?
I mean, it's varied. I mean, there's heavy rains, there's light rains. I've been out there in light rain, and I've been out there, in torrential rain.
What do you call that 2018? Was that a normal year? Was it less rain than that?
To be honest, I can't remember back to 2018's weather. Yeah.
All right, from your personal viewing, went back there on rainy days, you actually saw water coming down. It was not going all the way to the end of the property.
So when we talk about that, in regards to, are you talking about the fence? In regards to the water moving, or what are you talking about?
From the time it closed in March, the fence went up in July. Did you go back there and see how the water was running?
No, we didn't have any reason. I mean, we walked back there, but we didn't have a reason to walk, to look for how the rain was going. Because there was
March, July, those 20 and 30 times, none of those times were you back there.
No, not looking at that. I mean, we didn't have a reason to look at that because there was I didn't see anything going on, and nothing had been really ramped up yet, I guess you can say.
When did you first partially see water rain, see the swell area behind the building?
Let me think. So we started to look at the issue, I would say, as we got closer to the end of the year, I would say, is when it became more of we have to start considering the fact that the builder wasn't going to do anything. Now we have to start thinking long-term. And that was when, as a board, we started putting pieces together. I mean, for months and months and months, Chris had been emailing, we had been going back and forth, we had been talking in person, we had emails back and forth, you name it. So it's hard for me to pinpoint the date when, because there were so many conversations, and like up until I think it was March of 2019 or February 2019, where his March 2019, where his warranty, where we were certain that the builder and the warranty weren't going to cover a thing.
All right, so March 9th, 2018, closing, May 22nd, 2018, in that 2.5 month period, you see the application from Tia, build a fence. What was your knowledge between the time of their closing and the time you saw the application about concerns or if there's any water problems?
I wasn't aware of any water problems before that.
So when the board looked at it, your knowledge on the board members said
No.
So when they submitted that application, May 22nd, they'll AC form and things like this. What's the process they went?
I mean, we follow a typical process. So we have Pennington Fence Company, who's very, very known, very capable company. We made it so that, everyone has to follow the same procedure. We have 2 types of fences in the neighborhood. Preferably, we like white vinyl, but because of the location of theirs, which backs up to a wooded area, on those, the builder had already put up wooden, I guess just the one-sided hideaway, so give the patios a little privacy. So we allowed on those, since they backed up to the woods and nobody would see them anyway, we allowed wooden fences on that side. So the board sat down. Usually it's a pretty quick process for ACC requests of this nature anyway. They submitted it, we sat down. At the time, we didn't see any issue with it. And I guess I could say I still don't. Sat down, approved it, sent it back to Mr. Tully. Mr. Tully would have forwarded the letter or the email to Tia, to Ms. Ibezims, and that's pretty much it.
Okay, when they submitted that application form, they submitted plans as well. What all did they receive from Ibezims, the association? What details did you get?
It's hard to remember, but what we usually ask for is a design from the builder. So usually they just do it's just a basic. I mean, we've had people submit them with just drawings. Here's the edge of the house. The fence is going to go down this many feet, over this many feet, and back up. Usually we have the fence so that it has to be the boundaries of the same exact length of your unit. Like it can't be short 2 feet because it'll end up looking weird. So, and if somebody wants to join into it, it'll fit perfectly. So outside of that, once we review it and we know that the builder has a certificate of insurance, business license, they're good to go.
In their particular situation, you know exactly, but you got the plan they planned to do, everything you wanted, you got what you need.
Correct.
They didn't go back and say, hey, we need this, and they said, no.
No.
And the 54 units with water jets, how many times before had you approved fences and so on?
I want to say they were probably one of the first.
And there are other ones?
We have had, to be honest, they might be the only one that actually, there is another one on their street. No, there's probably a couple on their street now, but in the other building. So, but I mean, everybody's required to follow the same process.
Right. In fact, about having special needs kids thing, was that a factor at all in enforced?
No, because I don't think, to be honest, I didn't even find out that they had special needs kids until much, much, much later. And how it actually happened was probably while we were still interacting with each other. I just came over their house and I was just outside playing with one of the kids and he just ran off suddenly. And I was like, oh, did I do something? And then that's when they told me, oh, no, he's good.
I'd like to use her deposition. Still a copy there for him. I got a copy here.
No one gave me any depositions, so you don't have anything.
Okay, they've been filed for court. I know that. Well, I've got a copy here.
Okay.
But I'll have it.
Do you have copies for opposing counsel, or how are they going to know what you're referring to?
I do not. They took them. I assume they have copies of these depositions.
Well, why don't you confirm that before you share it with the witness?
Do you have copies of your deposition? Mr. Smith, both of you?
I don't have my copy.
Don't have it with you, but you have a copy.
So you'll just need whatever page you're going to be showing Mr. Smith, show it to Mr. McLeod first if you don't have a copy for him.
You have a second copy with you, Kevin, that you can give him?
I don't think I, sorry. I'll share.
Your Honor, I can make notes.
Okay. You're okay without the,
I'm okay with just making notes for what we're talking about.
okay,
And I'll just cover that later, just so. we can move on.
thank you. All right, Mr. Stewart.
Yeah. Right. Go to page 32. You would, let me read along with you.
Okay.
Before you do any of that, I guess I lost track because of this paper shuffling. Is there a question that you already asked Mr. Smith and the answer is such that you now need to show him this, or what are we, what was that question and what was the answer?
Question was, you didn't know about special needs. I didn't have any impact on why the board approved it.
No.
We look at on page 32, line 13, I asked a question, or I didn't, the defense lawyer and the third party defense. Did you have any understanding at the time you approved the request regarding the reason why they wanted the fence? 16 through 19, read what you said.
Well, let me see what I said because.
Right, you're free to review that. That may refresh your recollection.
Okay.
And then you can share your refreshed. If it doesn't, you will need to read whatever it does say there into the record.
Yeah, I said I know it was because they wanted some privacy back there for one. I said, but also they have a special needs kid. I do know that. So I believe it was, just to enclose the area for safety. All I stated was that I knew they had a special needs kid as well. But I think the last sentence makes it very clear. I said it was just, I believe it was, just to enclose the area for safety. That was my summation of it. I didn't know that they had, I can tell you the exact event when I found out. I just told you the exact event when I found out they had a special needs kid, and that was not until much, much, much later.
Well, okay.
I was just stating a fact that I know they have a special needs kid, and me with 2 kids, if I had special needs kids, I would probably want mine enclosed as well.
But did you know, you understand at the time, why you approved of the request regarding the reason they wanted the fence?
And I answered that in the final sentence.
Don't talk over each other. So let Mr. Stewart finish the answer, but he's already read what's in there. So you can do what you want with that answer with the jury later, Mr. Stewart.
Right, at the time you said, at that time, why did you approve? You said, well, I don't have special needs now, and it's for safety. What you said is why it's been, and you knew that at that time.
Can I read it to them again, please?
Well, yeah, read the question.
Because how you're saying it is not how I meant it. So I said, I know it was because they wanted some privacy back there, for one. I said, but also they have a special needs kid. I do know that. I was strictly saying that, yes, I know they have a special needs kid. Then I said in the summation of that, so I believe it was, just to enclose the area for safety.
So your deposition was when? It's
My
on the front.
deposition was
Flip that thing open.
March 22nd of this 2022.
So in March of 2022, you knew that the Ibezims had a special
Yes.
needs kid.
By then, yes.
At the time of the fence application, you did not.
No, I
And
had
you've got
no
a
idea.
specific recollection as to when you learned that. If we were to do the chronology, fence application, later you learned special needs kid. Later still, there's a deposition at which time you knew.
Yes.
And testified as such.
Yes.
Okay. I understand.
And if we're going by the application, I didn't even meet the Ibezims until after that fence was installed.
Let me read the question on this. I'll go through your answer.
You know what? We're moving on. Next question.
Well, you clarified, you misstated the question that was asked.
Why don't you read the question again and then let's move on.
Question was, do you have any understanding at the time you approved the request regarding the reason they wanted the fence? That was the question.
Okay, that was the question. Your next question is.
All right, when they approved the fence, they put it up. They paid for the fence. Is that correct?
Correct.
And that was done by fence, fence stuff like you requested.
Is that a question or a statement?
Question.
Correct.
That was you told them they needed to use Pennington and they used Pennington. You didn't have any problems with the fence once it was put up. You walked out back there, several times, and said, looks like what we approved.
Correct.
Now, tell me about what you saw in the rain as far as how did the grading and the property there.
So I wasn't there yet for, while it's pouring, because there was no purpose for me to be there yet. It wasn't until after all of this started coming up until it started becoming apparent that the builder was not going to handle any of this. That's when it made sense for me, because we could see the direction things were going in. That's why it made sense for me to now start going out here. I wouldn't have just gone out randomly looking at people's fences. I'd have to be crazy.
All right, so you went out, particularly with look at the swell and the drains and that, and you agreed that the grading was horrible in the
Thank you, Deputy Gordon.
The answer to your question,
Let me see.
okay.
The rain was horrible in the back, and that was the cause of the Ibezims quarter runoff problems. You saw that at that time.
I could tell there was an issue. To the extent of the issue, no, because I'm not an expert, and at that time I had not visually seen enough for me as just I'm just like you guys. I'm a normal guy who's just volunteering to do a job. So I don't have the training and all that to make that kind of assessment yet. That my knowledge of this will come from as time grows and I'm able to see what's actually happening. So over time, but initially when I went out there, I couldn't tell what was happening because I'm not a trained individual.
The fact is, with the blank scan, you went back there several times, you viewed it, and you said it was a terrible situation, it was horrible. You made that conclusion at the time, didn't you?
I made the conclusion that the end result was, but that's not what you just asked me. You asked me in regards to grading and everything else. I'm not in a position to make that call.
Is it true that you went back there repeatedly, and just from a common sense standpoint, water, this had nothing to do with the water, absolutely nothing. Grading was horrible in the back. They built a little makeshift dam out about 20 stone. Was absolutely no way that the fence was impeding the water. I believe we have received comments from the experts that say that.
Yes.
What you really said.
Now, what I said, what you're talking about, you said initially when I went out. Initially, I didn't have I didn't even have enough information to make a common sense choice because I'm just walking up to a puddle of water. So as time went out and I, spent the time sitting there and watching the water, because I did specifically sit there at the edge of Mr. Ibezims' fence. And, it's weird, but I'm sitting there knelt down at the edge of his fence to see is water coming out from underneath. And yes, water was coming out from underneath. I think everybody in this room knows that water will find a way to get through whatever it needs to get through. So a fence, unless it's a solid fence, solid wall or something, water is going to find its way through. And it definitely, blades of grass is not going to hold back water.
In your opinion, went up there and you saw that fence that put in, the fence had nothing to do, but there was a horrible water condition that you observed.
I observed, the only thing I can say I observed is water in his back. There was water back there.
It was a horrible condition and the fence had nothing to do with it.
From my observation, the fence had nothing to do with it.
And that's went on. Did you see videos and photographs of the plant?
Chris did show me some videos and he did show me, I think, he showed me the videos because he had taken plenty of videos at that time.
You saw the video show where there was puddling behind the swell area that it wasn't running properly and things like that. Sure. Was that after or was that put in the check dam or before?
That is a good question. I honestly could not tell you. I honestly don't remember. I honestly don't remember. And it's been a year since my deposition. So if you have the answer, if you want to tell me what I said, I just don't remember, to be honest with you.
Well, let's ask this. When you did go back there, what was it like right behind where the fence was at? Was it swell? Was it flat area?
By Chris's, it's more flat.
The time before anybody did any work from March 2018 and purchased to the time you went and looked at this September or whatever. It's flat. Nobody had done any work.
No, nobody had done anything. And I mean, the way, so if I go to the end of Chris's building to the first person, it is higher. You can visibly see if you're standing here and looking down towards Chris's unit, you can visibly see that the land goes down until it gets there and then it kind of comes back up, which would explain why the water was stopping there and not at the unit that was next door.
Plus, it went down in kind of a swell area, and then the swell itself flattened out right in that area.
That I'll agree with.
That was done that right at the time of closing, you understand? Because HOA, you're not.
Correct.
That guard really had not done anything there, so that was the time of closing.
Correct.
So look at the video, things of that nature. Talk to board and say, hey, there's still a problem here.
To be honest, I don't remember every conversation that we had. I know Chris was talking to Water's Edge. I know there were conversations between Tully. I personally do not remember having conversations with any of the guys at Water's Edge pertaining to this, because due to the nature of the issue, as a HOA member, if any of you have ever served on an HOA, it's much better to have the professionals handle that kind of stuff than to put yourself in a middle of a situation that you really don't deal with on a normal basis. So I believe there was a lot of conversations between Tully and Water's Edge.
But you personally sent email September 8th.
Did I?
Stuff.
Okay, then, like I said, if you have the deposition, if you have it there, I don't remember. I can't remember the last 5 years of my life. If you want to show me the email and refresh my memory.
He'll just show you what he wants to show you, but you've made clear that maybe he needs to start showing more instead of asking, because you're not remembering every detail of 5 years ago.
Page 48. And I'll ask the question.
Okay. Reach page, which one?
Page 48.
48?
Read 49 as well. So we got it here.
Okay.
Mr. Dorsey?
Just to the extent that this is proper impeachment, this email says that it's from Water's Edge to someone else. I think the question was, did you send an email to Water's Edge? So I just want to make sure we're very clear about.
Sure. No, that was the question. Are we dealing now, Mr. Stewart, with an email that Mr. Smith sent to Water's Edge, or are we dealing with some other email?
This emails that you either sent or you were copied, you were part of the email exchange, correct?
I'm gonna answer your question. Just ask it right the first time, please.
That's right.
Because in here, it clearly says that the email was not to me, that it was to Tia, and that I was on it. But just because I'm on it, I definitely would not remember an email from years ago that do you guys remember?
You don't ask your questions.
Sorry.
But I do want to streamline this, because this is getting a little bumpy. Ask your questions, make sure you're asking questions that are based on what's in the deposition. So let's just reset. Next question.
Were you copied on the emails that when the Silverstone wrote back about the fence being the problem, we're not going to take care of it? Were you aware of that? Were you copied on those emails as they showed?
I guess I was.
You was realizing Silverstone, you have one legislation saying, we're not going to fix it because it's not the fence problem.
Yes, but at the same time, I have enough experience as board president to know that vendors all the time say, I'm not going to do this, I'm not going to do that. That's not the end all. There's still way more discussions to be had. So
What, as a vendor, if they the builder of the subdivision, saying from the builder saying, we're not gonna do anything about it. We think it's just a fence. You disagree with that?
yes, we disagreed with it. I had no reason to agree with the fence after I saw that visual confirmation that the fence was not the issue.
What happened after Silverstone in September said, we're not gonna do anything more with it because it's a fence. So it's a fence. You didn't agree with that. What did you do as a board president at that time?
I believe discussions were still going on. There were still arguments being had. We had originally told Chris, I believe he was told by them to go through his warranty company. So between that time and March, when the warranty would have ended, there really wasn't, you're right. I guess we're going to get to that point. What happened in those few months, I don't remember, to be honest with you.
How did you learn about Chris? Did you personally talk to him about the file with the warranty?
Chris and I, at the time, we were still talking and everything, still communicating with each other. I didn't communicate much with Tia. It was mostly with Chris. I think Tia was present for maybe 1 or 2 meetings with us, or maybe 3. But that was the extent of it. I mean, I know we told them and I know there's emails from me telling Chris, do the warranty thing. And like I said, we have no clue. All I've been told is I have a home warranty. So in our minds, we're like, okay, we'll just go handle that with the home warranty. If they're not going to handle it with the home warranty company, and then come back to us once that runs out, and then we can jump in at that point.
Okay, so we had a conversation with Chris sometime. You're aware that he's going to file for home warranty. Did you also learn that the home warranty came out and said that's not part of our contract? That's not covered by warranty?
Eventually, I do believe that we heard about that. I can't tell you a date because I honestly don't know.
Did you learn about that before April 2019? Hired the experts to come out and evaluate?
Yeah, because by the time we got that information, that's when the HOA pressed the go button and took action to take care of the issue ourselves.
Okay, so it closed on March 9, 2019, a 1-year 210 warranty. All of the work calls for the March 9, 2019, warranty runs out. You're aware of that. You were aware that the warranty people said we're not going to fix it. The warranty ran out March 19. What did you do after March 19, 2019? Or we're not going to fix it. You realize it still was a problem.
So at that point, the HOA, keep in mind, we've been building up to this. So conversations were had during the months. I couldn't tell you every detail of those, but we realized, okay, after a while, common sense just kicks in, and that we're getting close to a deadline. We need to start making preparations. So Mr. Tully, we spoke, the board spoke with Mr. Tully and asked him to start collecting some useful quotes that we can at least have some professionals tell us what the cause is, what the fix is. And so at that point, that's when vendors were asked to start coming out.
That was in April 2019. That started happening. Where 6 months earlier, Board's Edge group had come out to check dam, started working with it. Did you evaluate? They were making business behind building 30 and see if the rain after they put the check dam and did whatever they did? To be honest, the check dam, it looked like a 5-year-old playing outside. Come on. We saw the picture of it yesterday. It wasn't going to do much. So, yes, I had been out there to, I could see what's going on, which is why when the time came, we told Mr. Tully, go ahead and start getting the quotes. So you told him that April 2019, you knew there was still a stormwater runoff problem impacting the plants. You want to get some estimates what the association did that.
Correct.
Do you feel that association's responsibility to do that?
No, but at the same time, my responsibility and I'll say this more so than anyone else on the board. At the end of the day, if you guys are my neighborhood, I represent you. Every dime that you pay into the HOA, I can't just frivolously spend it just because I want to. So it didn't make we started looking at how do we we have to make sure the owners are taken care of, but we also have to make sure that this issue gets taken care of, because honestly, it'll start affecting the property more and more and more. And that's why we made the decision to, okay, now we have to jump in after it became apparent, after all the back and forth, the builder's not going to handle it. We're just going to have to bite the bullet and handle it. Simple.
So let me ask about the builder not handling. Organized group, we know August, September 2018, put in that check down and said they did some other things like that. That is in the common area.
Mhm.
Do they have the authority, organized group, to go work in the common area? Did they get approval from the association?
They did not get approval from the association. There was never a conversation had, never a question asked about, can we put up this check dam in the common area? I understand the thought behind it, but before any of that was done, the association would have asked someone to give us a valid reason why this was being done, and then ask another professional why, what's the effect that it will have downstream, which is where the Ibezims are. I literally came out there one day and there was a check dam there.
What is your understanding as far as responsibility to authority between the WEG, the owner who sold the actual condo, or the group who actually built it, into common areas? Now, after the CEO's issue, it transfers over to the association. Who has responsibility for the swell area? Is it watershed?
If
Or both?
in the association's mind, it's still, the initial issue was not caused by the association. We're not talking about an issue that was 5 years, these properties have been here for 5 years. The association, by all means, right away, we handle it. We're talking about a building that had been there for a few months. And in fact, if we're talking about from the time the occupancy, certificate of occupancy, we're talking, 2 months, 3 months? They moved in March. It was in February. So it's only been a month, technically. So that would be one thing.
March. What happened a month after?
No, they moved in March. So what I'm saying is, because I believe they said that this issue started happening sooner than when we found out about it. So there was, if the issue had been going on for years, that's one thing. But if it was just caused and the association did absolutely nothing to cause that issue, I would think it would be pretty obvious where the blame lies.
So the association, August, September 2018, when Forsyth did some work in swell, you did not order or have any kind of work done yourself in swell in 2019?
No. In 2018, you said?
Right.
Yes, correct. No, we did not.
Backyard brick did nothing either?
No.
Backyards.
No.
What happened in April after warranty ran out? What did you tell Mr. Tully?
To go get some quotes from some professionals. We started with, I believe, Alan Duckett, who was, he's also our landscaper in our community, a part of Atlanta Landscape Group, very reputable group of landscapers. And Alan had done some previous things for us in the neighborhood.
I'll give you the 3 reports. So April 11th, 2019, that's Ray Engineering did a report. Month later, on May 8th, 2019, that's warranty. May 9th, 8th, 2019, hit Alan Duck out there.
Okay, I'm reversed.
And then Elmina went out on May 20th, went back a second time. June. And they wrote a report on June 10th, 2019.
Okay.
All right, so they go to the first report was Ray Engineering. Mr. Tully got that report. Did they give it to the board? Did you see what?
Yes, Ray, he would have forwarded that one. Ray does work for us as well in the community.
What kind of work has Ray done?
We've just had some issues with units settling as they get older. And Ray had come out and usually he'll do a report because the one thing, I mean, it's a prime example. The one thing the board always does is make sure, is the issue caused by something that we've done, or is it something that's just over time? And then we can assess who's responsible to get it done. So Ray, in a lot of these cases, we have come out. If we see a crack in the foundation, we need to have them come out and assess the situation. So I'm very familiar with Ray.
Right, so Ray came out, he evaluates the swell, we have testimony, basically he talks about undergrowth and trees and things in the swell. What's your understanding about trees and undergrowth growing in the swell?
So to me, this part here, because he says, let's see, the stormwater from this slope that extends the entire length of the building is designed to be collected in a swell. Swell extends to a storm drain yard inlet at the rear corner of.
So I'm sorry.
I just
don't read directly from it. It is in the record. It's not in evidence.
Okay.
You're free to look at it if it helps you refresh your recollection.
Okay.
Mr. Stewart's not supposed to ask you questions that get you to testify directly from it because that's not in evidence.
All right.
So why don't we ask the question again? And don't look confused. It's not in evidence. You knew that. It's in the record.
I'm confused, but yesterday the testimony went in great detail about what's in that report that's in the evidence.
You're mistaken.
Okay. Refresh your memory from that.
Okay.
What, does he address the issue of the swell?
He does.
You talk about trees and undergrowth and some of that. What is your knowledge about tree and undergrowth being in the swell?
So my knowledge of this, if I'm looking at this and
Forgetting his report, what did your personal knowledge, your visits out there?
from visiting, so there wasn't really anything in the swell itself. I mean, it's just land. So there weren't any trees. I personally did not see any trees or any underbrush in the swell area. I did see, because the only area that has trees is, I believe, the last page of your Elmina report. Everybody probably knows that picture. In that area where and I don't know all the terminologies for all this stuff, but I'm guessing that's the inlet storm drain.
I think we were calling the manhole.
The manhole, yeah. That area does have trees around it and everything. So that's in an area where, yes, it does flow through some trees. And you're talking about an area that's maybe from the end of here to the end of the curve right here. So 15 feet.
We saw some pictures yesterday in the Elmina report that purported to show the swale at the time that report was done, which would have been, I guess, in May, June 2019. In terms of there being trees or underbrush in the swale, is that how it looked in those pictures? Is that pretty much how it's looked every time you've been over there doing the research or inspection you've been talking
It's
about?
pretty accurate.
Just those few feet right outside,
Yes.
either the cement pads or the Ibezims fence.
Yes, and actually the area in the Elmina is about 40, 50 feet from the fence that you see in that last picture is actually from the second building. That's not the Ibezims fence.
All right, so to get this report, April 2019, give that to the report to board review prior to getting the second report, get 2 or 3 at the same time.
As we get them, as they get them, we get them.
Okay. So you saw that in April 2019. After you review that, did you ask for to do another report?
Yes, we never get just one report. That's not common practice. So usually we'll have, even when we get landscaping quotes and everything else, usually it's always 3. One, because I have a responsibility and the board has a responsibility to make sure that we're getting the best service for the money. So that's pretty much practice.
Okay, so when you first talked to Tully, did you tell him to get us 3 reports?
Yes,
That's
yes.
the plan from the very beginning. All right, so he gets the second report, Mr. Ducker. All right, May 11th, 2008. This report is May 8th, 2019. You got that report, you reviewed that as well. Did you review that prior to the third report?
Yeah, we would have. And the getting to, I guess you can say, semi-conflicting was all the more reason more to call in the big guns and get somebody, a specialist, I guess you can say, an expert.
You look at the first, second report, and they're conflicting. What did you find conflicting about?
I think Alan seemed to be more landscape based. And I mean, this does as well, but neither from observation, plenty of times, neither seem to be addressing the actual cause of the issue. And I can tell you, being out in the rain, and we talked about it, seeing all the water dumping off of the buildings, it became pretty apparent where the sources of the water was coming from. So
You said that once you reviewed Exhibit 17, this doctor's report prepared for you. Board got prepared on May 8th, 2019. He has 4 bullet points there. Just read those, fresh in memory.
okay.
All right, so he does talk about the slab and the water problem and that, things like that.
He does.
You get the recommendation how to fix the problem, how to take up the slab, things like that. Is that the first time you heard that when you read it?
I believe so at this time.
Then the third report was when Domino went out there, May 20th, it says you were with him at the time. Tell me about the El Nino. Who did you meet with from El Nino? May 20th, 2009?
I cannot remember his hand off. Well, actually, hold on. I think his name was John.
Was that the first time you ever met him?
I believe so. John Eschen, I believe. I think that was his name.
What did you?
So we were out there in the rain. That was a specific request. All this going outside and looking at stuff when it's dry serves us no purpose.
He says on May 20th it wasn't raining. You met with him on that day. Do you remember going out there first on the day when it was not raining?
If we did, it wasn't to do anything meaningful.
He said when May 20th came out, you did inspection, met with you and met with.
I might have explained kind of what was going on.
Do you remember Chris Ibezims being with you at the time?
I'm trying to think. First time, I'm gonna be honest with you, I don't even remember meeting with John the first time.
Time was raining, so that's what you do.
Yes.
Tell me what you did the day it was raining.
So we walked, starting with the highest property, the one at the end of the building. I remember going up there, looking down, seeing, okay, water is coming from this drain pipe going to the next patio, which I believe you saw a picture yesterday of the patio that had moss on it. It was there because at the time in that picture, the water was washing onto the top of that constantly. So we walked all the way down to Chris's, and part of the conversation was, how can we preserve our residents' fence, which they wanted, but still accomplish what we needed to accomplish. So that was the objective. We were trying to make it work for all parties, make it work for the HOA, make it work for Mr. Ibezims as well.
And you say he was PE, a professional engineer.
Yes. Yes, correct.
You went down, you walked, you said it was rain, light rain, heavy rain?
It was pretty heavy. I mean, it's to the point I needed an umbrella, so.
Was it heavy enough to see the water running down?
Yep.
Okay, and when you got to the defense discussion with him that day in the rain, you told me one private observer, what did he tell you?
He said he would have to do his thing and figure out, once he had all the factors and everything, it'll paint a better picture for him what the possibilities are. So he knew the objective, and once we got the information from him, it was clear that yes, we could work with the Ibezims and keep their fence and still accomplish everything that needs to be accomplished.
So his report, he sent out June 10th, 2019. You received it.
Correct.
You read what we put on the screen as far as two options.
Mhm.
You modified, taking out part of the fence, from realign the swell around it.
Correct.
You chose to do this. Realign the
We
swell around.
chose to do the realignment, and I don't know if it's a realignment necessarily visibly, but it's a realignment underground. So where you have, and we looked at the pictures yesterday. Sorry, when the expert talked about the downspouts not being there, the downspouts were in the downspout extensions go from the downspouts, and the downspouts go underground at the corner of each patio. So all those, and they go into a big pipe that was placed underground the length of the building. There are drains at the back of the building. I want to say 1, 2, probably four great drains. So all that hundreds of gallons and everything that was coming off of the buildings, it now goes underground. And then it goes all the way to the manhole that was in the last picture. So you wouldn't see visible water on top. And I have been out there in torrential conditions. You'll see normal rain on the top, but nothing near, not even close to what was happening before.
So we focused a lot yesterday on that one picture that had a brown downspout that went about 2/3 of the way across the concrete slab.
Yes.
If we went there today, and no one's going to take a field trip, we're only getting evidence here in court. If we went there today to look at that concrete pad, you're saying that the downspout now travels all the way across the pad, and while contained, goes underground.
It goes right underground.
And then that plugs into a big old pipe that takes it all the way down to that manhole cover.
Exactly.
So it's all subterranean.
Yes. So the only thing you would see if you were to go back there right now, if you go every maybe 15 feet, you'll see a grate, a drainage. But other than that, it's the best way, because keep in mind, no matter if we kept the water on top, you're still going to have water flowing, still thousands of gallons of water combined between the 6 unit, I think it's 6 units that are in there. That problem is eliminated. There's no more water. Everything that comes off of those roofs now goes underground.
When Dr. Spots paid his visit, which would have been February of 2021, would that concrete pad with the downspout that only went 2/3 of the way and then the water just rushed out and it looks like it hit the Ibezims fence, et cetera, would it have looked like what we saw in the picture?
Not at all.
When did the downspouts get integrated into this pipe that directs everything away?
I can't tell you the exact date, but I believe July of 2019 is when we got invoiced for that work, I believe.
But calendar year 2019.
2019 is when the work would have been completed. Thank you.
Okay, let me ask you about that. That carpet continues like that collects the water on the roof. Correct? It does nothing to collect the water that's raining down within the swell above the 6 unit and the patio and all that. That water's still coming down the swell.
No. The water should not be coming down the swell, because the water, if it's at the top, the first unit, if we start at the first top unit, that first part of the swell, the water is eliminated. It goes into the drain, which goes underground. If I think you guys know that it would take a meaningful amount of water to create like a stream. The stream never starts because it can't. At the very top, there's a drain. So that first drain pipe goes into the ground. At the third unit, there's another drain, I want to say, and I'm just approximating here, but that water goes into the ground. So there's not enough to ever create, not from the swell.
Okay. You say you've been on the rainy days.
Mhm.
Have you seen that the gutters on the roof there, where you got those pipes on down? They're filled most of the time and they overflow and they don't actually go down the pipe. You've seen that when they talk? Work as designed?
This is the first I'm hearing about cloud gutters, because that would be just a normal maintenance request for cloud gutter.
You've ever been in the rain, you see the water running over the gutters instead of coming down the pipe.
I see that all the time. I mean, I'm the president of an HOA, so that happens all the time. In the fall time, we do cleanings, maybe twice a year. So if someone does have that problem, all they have to do is submit a maintenance request to have it cleared. But that's not the swell issue.
Water runoff onto the plaintiff's property.
Yeah, but that wouldn't be falling off into the swell, which is way over there. It'd be falling off at their gutter, which is right here.
Right onto their patio and the backyard, things that nature. Your system is called not working properly.
But what does that have to do with the swell? We were talking about the swell. No, but we were talking about the swell.
Well, right now I'm asking about the gutters. You explained the swell by saying inlets, all those things.
Okay.
But if the drains, the gutters aren't working properly, water's coming off the side, that's circumventing one of the purposes of the pipes you put in connecting to the drain.
If a drain is not working properly, then yes, the water wouldn't be making it to our system. But in regards to a resident, if your gutter is not working, you just need to submit a maintenance request for it, so we can send someone out to unclog your drain.
You got 6 different units and they have this problem. Is that something they're supposed to go do all 6 of them? Or is that something the association, when you walk around, you see there's a problem, you'll fix it?
When it comes to maintenance requests, everyone has access to the Tully website. I go on there and submit maintenance requests all the time for my gutter. Recently, I had my gutter, the water wasn't even making it to the gutter, so it was coming in between the gutter and falling down. I submitted a maintenance request and that was fixed. But I mean, it's everybody's responsibility. I believe it's in our bylaws and covenants. It's your responsibility we do what we can as a board, but it's the homeowner's responsibility. If you notice a shingle on your roof coming off, don't rely on the HOA, we'll fix it. But if you see something wrong, you need to let us know so we can fix it. I can't speak for the other people in the building. If they have issues, because I have not been made aware of any other issues.
Right, but the ones up in the stream, unit 4, 3, and 2 have water running off that way. They don't report it. It runs down if we go to that Ibezims property, correct? They don't report it as other neighbors.
We would still be able to see if water was running down.
You can see if you're out there on a rainy day, correct?
I mean, if you're saying you've seen it, I would have to contradict you.
Objection, Your Honor. I think this is a proper hypothetical and it suits facts.
Yeah.
The evidence. Just ask the question, but there's no testimony.
There would be testimony about it later.
Well, we'll address it then. You've asked this witness. He has said, been out there in torrential rains, doesn't see water flowing.
So you're saying, well, they said you need to realign the swell, make it go around the fence. Dr. Spot said it didn't realign it. You're saying they didn't need to do that?
The entire pipe is now underground.
You got that?
So it's like, yes, ideally, we could have gotten a bobcat and dug another ditch. But the ideal situation was to eliminate any water. Their situation, and I think Dr. Spots understands that, because he mentioned it yesterday when someone asked him about the water on the hill. And both he and I came to the same conclusion. The water on the hill with the trees and leaves and everything, there's no water coming off that hill. It gets absorbed into the ground. When you talk about, he also mentioned the gallons of water that are coming off of the building. Regardless, that would still be flowing through the backyards if we realigned the swell. We chose not to realign the swell, but to actually build the swell underground. Now there's still the swell, but the water is eliminated. And the water that they talked about coming off of the patio and all that stuff, that neighbor didn't even want to talk about it because there hasn't been an issue reported by that neighbor. So I understand your question. Did we realign the swell? The actual problem, the actual purpose for the swell was put underground now. So collecting water is not really an issue. Now, if you're referring to water off of the roof, which I'm assuming now because you brought it up, that's apples and oranges. That's two different issues.
Water to the Flames house. That's the issue we're talking.
Yeah, but you
Okay,
brought
well,
up.
What's your next question?
That report, I mean, in great details about tearing out the concrete slab and fixing that. You have a geo-engineer come out, tamp it down and evaluate it, act like get a really qualified person who will fix it underground, make sure it's solid. We heard testimony that the hole's still up under there, it hadn't been fixed.
Okay.
What did you, the association, do with your repair job to fix the neighbor's slab?
The neighbor's slab. So I'm going to address this as a whole question because, so you talk about the El Mino report and there were two alternatives that were given. The only difference between alternative 1 and alternative 2 was that we did not cut the, in alternative 2, it said cut the slab of the neighbors by 2 feet, I believe, test the substrate soil and all that stuff. Keep in mind, at the time when this was all happening, you had all of the and he said it yesterday, all these gallons, hundreds of gallons of water coming off buildings. That was eliminated by our option. The way the El Mino report is, if we had done option 1, we could simply come back and do option 2 if the problem was not taken care of. The problem was taken care of, and we haven't heard a peep since this problem was taken care of. There hasn't been a work order, except for a recent one. Everything went silent. Now, understand, building up to this for how many years, we've been getting emails and from everybody. We've been getting lawsuits and everything. We take care of the problem, everything goes silent. There was no reason for us to come back and say, oh, let's go still cut his, because we had eliminated the water flow that was even creating the issue in the first place.
Let me ask you about that. It went silent. Did you not send an email to Tia Edison saying, do not contact us, do not come to the board meeting, we've done what we're going to do, never contact us again?
And who was that signed by? Me, correct?
You
Exactly.
sent an email to her. Is that true? Did you send an email to her saying, do not contact us?
I absolutely did. And they don't need to contact me to accomplish anything in our neighborhood. They contact the management company. The management company collects the work orders, not Sean Smith.
But they want to talk to you about the El Nino report and what you want to do. And the option, you were doing 2 instead of 1, and you wouldn't talk to them about that, would you?
100% untrue. And if anybody is saying that, I'll even go so far as to say it's a lie, because the entire board sat with both Tia and Chris. Mike Tully was actually present. It was actually at the firehouse in Beaufort, across the street on Gravel Springs, right across the same firehouse that's by the DMV in Beaufort. We all sat there together. We read through both options. And then we sat there and we told them, this is the option we are going with.
Yes, they were there, they talked about it, and they still had problems. You had people come back and forth with her, but when Tia reached out afterwards and said, wait a minute, we still have a problem, you told her, don't contact me. We don't have one any more contact, don't come to our meetings anymore. You told her all that, didn't you?
And since you're going there, The reason was never, I deal with 174 homes. The reason was never for us not doing what needs to be done as a community. The reason Sean Smith submitted a restraining order, I guess Gwinnett called it, was because Sean Smith had been trying to be intimidated by homeowners. That's something I will not tolerate. And it got to a point where Sean Smith had to go up to Gwinnett County and say, how do I file restraining orders against a resident who has taken things way too far? That's why. But me taking care of my responsibilities to protect me and my family has nothing to do with the fact that they, as residents, just like me as a resident, I don't contact Sean Smith when I need something done as a resident in the neighborhood. I contact Tully Community Management. So Mike's name was not on any of that. They had the option to submit work orders. They had options. They had options to probably go by the office. They had options to email Mike. There's been plenty of emails, phantom emails going around the neighborhood with a lot of mistruths, a lot of lies, blatant lies. So somebody knows how to email somebody. But we did not get anything as an association saying, oh, there's a continual problem.
Okay, that's the first I've heard. You took out a restraining order against my client?
It was the thing that you got. I went up to get a restraining order and they said, oh, unless there had been some physical altercation or something. So they gave me a form, which is the form you have.
What form? I do not have that form. I've
Okay,
heard it.
it was all submitted in discovery because you just brought it up that I told them not to contact me. So it's all in discovery. So both of those, one to Tia and one to Chris.
See, the email said, do not contact. I have not seen the restraining order.
They were attached to the same email.
Okay, you applied for one, but you didn't get one.
I went up to Gwinnett County and told them what was going on. And Gwinnett said, unless you have been physically threatened at this point, you need to go up, just fill these forms out and you personally send these to the residents, which is the only time I've ever had to do that.
So when you say, oh man, the planes just went silent. You told them to stop and you threatened to get a restraining order. You think it's shocked that they didn't continue when you had talked to them repeatedly? You said it just a while ago, you and Chris had communicated off and on repeatedly.
I'm pretty sure that document, it was pretty clear that it was, and I say it again, this is from Sean Smith. If Bill Gates tells you, don't contact me, I'm pretty sure you can call Microsoft's 1-800 number and still reach somebody. There's no reason, that's not how this thing works. He was told, which was a protection for me, for Sean Smith. That has nothing to do with where you live and the procedure for you to get something done in the neighborhood. They had the option to go and submit work orders. That has nothing to do with our board. There was 4 other board members.
Mr. Stewart, we're getting close to break time. Are you almost done with this witness or do you have, because if you're, okay, well, we're going to take our break. Ladies and gentlemen, I'm going to try to get you back in here a little before 11. That's about 10 minutes. If you need more, tell Deputy Gordon. Otherwise, we'll get you back in. I know you all had asked about coffee. We don't have a cup. Someone sent me something saying there's a coffee machine back there, but you actually need like coffee grinds. What I have in my courtroom, where I'd like us all to be, is one of those K-cup things, and there's a big box of K-cups, and you do your thing, but that's not here. So Deputy Gordon maybe can brew some coffee or tell you where coffee can be found, maybe on the 7th floor or something. I don't know. Okay, I don't drink coffee either, but that's not your problem. You can ask him to ask his colleagues. Enjoy your break time. Don't talk about the case. No outside research. We'll see you in a few minutes.
Thank you.
Snacks arrived.
they're happy now.
Yeah, all right. That's important. All right, we're off the record apparently, but take a 6-7 minute break. I'll come back out to talk about a few things. I will also observe that when I come back, it's going to be almost 11. It's Wednesday, and you had me tell these jurors they'd be done by Friday. So I trust you all are thinking about getting through with things. I can't guarantee that jurors will come back on Monday. I can't guarantee I'll put this back on my docket in the next few years if we don't finish it this time. So be thoughtful about how you're working with witnesses and who all is going to be called. See you soon. We're not on the record, so you can ask if it's nothing you want on the record.
It doesn't have to be on the record.
Okay.
Trevor Schunkweiler is here, and he was withheld. Can he sit in as the corporate representative of Wagner Creek?
Do you plan on calling him
Do I plan on calling him?
as a witness?
Yes, I do.
Okay,
But just like I plan on calling Mr. Silverstone.
right, but Mr. Silverstone has been in here as the corporate representative.
There's two defendants, Your Honor.
Oh, there's the, and Mr. Silverstone is the WEG.
He's the Water's Edge group.
Okay,
Trevor, who does not live in town, is able to come today. He is the Wagner Creek representative. I don't want to create any problems, but that's.
okay. If he is a representative of one and Mr. Silverstone is of the other, then I don't have an issue with that.
Thank you, Matt. Alan.
Sure.
Hey Larry, do you have an iPhone charger? Do you have like a USB?
For the iPhone?
I'm gonna try to find that video.
Yeah, something about.
Is that the same one?
No, signing up for regular USB address. So this is USB-C.
Oh, my
This is
goodness.
to the iPhone. You don't have a USB-C?
Yeah.
Okay, yeah, give me the one with the.
Is this one?
No, because you can't plug
Oh,
it to the
okay.
computer. You don't have USB-C, you got USB. That's not the regular one. You need the
Oh.
Yeah, so I can't hook it up with the computer directly.
Oh.
You can try, I don't know how big the video is, so you can try emailing it.
That's too big. You got somebody with an iPhone.
Yeah, unfortunately, I don't have the ability to hook it up.
So we'll try to.
Yeah, no worries.
They changed it with the latest one. They made it slimmer or something.
Yeah,
I don't know
this is
why.
a USB-C connector versus a regular USB. It's because they're faster, the
Oh.
transfer speeds are quicker.
Computer's language.
Yeah, it's exactly it. I never heard that.
Call her and explain, period. Maybe she can send papers, period.
Don't worry, yes, this one, yes. Oh, this one's back, you guys.
I don't think you can finish. Yeah, we said, choose when you come back.
No, because he said to them.
My calendar. also tell the jury that it's sitting too fried. It's not be pissed today. Yeah, I heard you tell you that yesterday. No.
I've almost drifted off a couple of times.
Yeah, I'm sure.
Wow.
Yeah,
I see my secretary has a hair appointment. She puts those things on my calendar.
Beautiful. Like, I totally need to know this. Blow my nose before we get started again. I don't know.
I did work.
Okay, period, send letter. Period. Today. I mean, June 5th. That's recycled contacts. That's the same time. Organization. Or. And he's still presenting. Finishing up.
You must go on and take the issue of that, which is whole phone.
Yeah.
You better pull up and read it. Show the video, they got family video. They did put that board up.
That was maintenance. So that's a way.
No.
And this is, he told me about the door and all that stuff. He never told us to come in. I'm gonna never not come.
Welcome back.
Yeah, I remember having this
Sure.
this computer stuff. If you want me to send you the email every night with this new information.
Yes, that'd be fantastic.
easier?
Yeah.
I need to get your email.
Sure,
So
yeah.
let me-
I've actually got a picture. I don't know if it's gonna change at some point. If it's not gonna change, I already have the ID and stuff, but
It actually changes.
anytime somebody,
every
yeah.
day.
Oh, interesting. The one from yesterday still worked this morning, so,
Oh, really?
yeah.
I thought it was a new.
Unless I'm logged into a different meeting.
Well, let me get your information.
Sure, yeah, either way. It's info, INFO, at Two Tails Tech, TWOTAILS So Two Tails Tech. I have two dogs.
Well, I was like, Jill is in dog.
Yeah.
Okay. Okay, great. All right.
Perfect,
So
thank
I'll loop you in on that, so you don't have to ask.
you. Yeah, I appreciate it. Thank
Yeah,
you so
no
much.
problem.
Okay,
The deposition, I would say, okay, say yes.
okay. I'll make a,
But it's not directly.
yeah, yeah. Okay, okay. Thank you. Thank you, thank you. And I don't mind you if you need me. Okay, 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 okay.
I'm not gonna be held. I ain't dressed like it. I ain't never dressed like it.
I hear you. Nah, that's not in my not on my bucket list.
Their education.
I need to address, I need to be on top of that to say, we need a yes or a no or a maybe. You can't do anything about it. You're stuck. All right, thank you. We've got everyone here. Let's get back on the record.
And we are back on the record at 11:04 a.m.
All right, Mr. Stewart, anything before we bring the jurors back in?
Oh, yeah.
Okay, Mr. McLeod,
There you are.
Mr. Dorsey.
Nothing, Your Honor.
All right, Mr. Smith, in answering questions, it's important that whatever your answer is in word form rather than or the jurors probably heard and understood what you meant, but the record is going to be largely inaudible. So your answer doesn't have to be yes or no. It could be maybe, I disagree, I don't know, but try to use words.
Okay.
You've been using lots of words, which is fine.
Okay.
But start with words too.
Not
All
a
right,
problem.
Mr. Stewart, you can come back up. Let's bring the jurors in.
All right, to the jury. I'll do the present.
Thank you, Deputy Gordon. Everyone can be seated. So no coffee, but it sounds like the snacks made it there. So it's a compromise. You may have a dry mouth if you only drink coffee, because then there's nothing else. But that's the least we could do. We do have a little stash of things. It used to be smart food in the mix too. I tend to take that when I can find it, but they hide it from me. So if you got smart food, I need to know where they're hiding that. When we took the break, Mr. Stewart was in the midst of his his examination of Mr. Smith, and we will continue with that. Mr. Stewart, when you're ready.
Report dated June 10th, 2019, El Nino report. Did you share that with plaintiffs after June 10th, 2019?
It was June 10th, the day we got it. I don't remember.
The date on the exhibit, it says June 10th.
Yeah, we had a meeting with all of us and we sat down and went through it at the firehouse. And we discussed option A, option 1, option 2, and why the decision was made to go with option 2, I believe.
Was this plaintiffs at that meeting
Yes, they were there.
after June 10th when you got the El Nino report?
If it was after we got the report, yeah, the meeting happened after we got the report.
I'm just talking about the date on the report that you introduced, 2019, you're saying that after that, there was more communication before you told them, before you got, now get the technical. There's more communication after the Nino report.
There was a meeting with them, with the entire board, not just me.
This is the one in the firehouse?
Yes, the one at the firehouse, where we sat down, we went through everything with actually all 4 of the family were there. The 2 boys were sitting over there in the corner. Tia and Mr. and Mr. Ibezims were over here. The board was over here. And Mike Tully was present as well.
How long after that did you go for the protective order?
I don't even remember the date of the protective order. I just know things got out of hand in a way that I think any smart individual would have gone and done the same thing.
Was the protective order before they filed the lawsuit?
I don't remember when all that happened. I'm gonna be honest with you.
You already introduced this in exhibit 20. Look at that, read through the preventative maintenance, if you hired to fill out to complete the work that's in the report. Is that what that is?
Correct,
That's the
correct.
proposal, and what's the price of that?
$6,184.
Read through the 16 they say they're gonna do.
Let's see, excavate the grade line to approximately 16 inches deep to the rear of 3278, install a PVC drain line, 3x3 or 3 of those 18 by 18 catch basins connecting all downspouts into the basins, backfill ditch and compact, grade area behind building, installing a swell to drain surface water to new basins and storm drain, clean up area, remove all construction debris, seed and straw where system has been installed.
Okay, so document report and El Nino talked about taking up the slab and neighbor next door and fixing all that, but they didn't have anything to do with that.
No,
Right, so that 6,000 is due to the things we discussed.
correct.
But the slab, someone did come and work on it, didn't they?
On which slab?
The neighbor slab with the water running out from underneath and going near the electrical line.
I'm not aware if they did. If someone submitted a work order for it, I don't know. I don't like every work order doesn't come through the board. It doesn't need to. There are certain things that the management company is just okay, they're authorized to do. If I got every work order and I wouldn't be on the board because I wouldn't have time to do it.
Let me refresh your memory. Then that, I guess, third party event had a video they listed that showed the guy who came out to work on that slab, and you're standing there watching him do the work.
On what work was being, I honestly don't remember.
So is that possible that when they did the slab next door, they put the 2x6 board up there, that Remember them doing that? You there when they did that?
I do not remember that, to be honest with you.
All right, so let's not go now. Sometimes you have to check on it. Then they filed a lawsuit. Ibezims.
Mhm.
Chris and Tina were named plaintiffs. But in Gwinnett County, the named defendants is you, John Smith, Mike Tully. Is that correct?
Yes, correct.
They didn't actually sue Waters Edge Group.
No, they didn't.
Individually. They didn't sue WEG, WEG, or any of that. They sued you individually.
Mhm, correct.
And then they went and finally hired me shortly thereafter. The lawsuit got dismissed in Gwinnett County. And I filed a lawsuit here in Fulton County a little bit later, within a couple of months. And that was against Mr. Silverstone.
You are getting to a question mark?
Yes, I am.
Okay.
Okay. So the two defendants we named here, the two defendants, they sued the other two defendants, the third party defendants. And you and Mr. Tully also were named as defendants, also, correct?
We were.
All right, and so you were defendants, third party defendants in the business, and they got dismissed, right?
Correct.
So plaintiffs originally sued you individually, got dismissed by my choice. And for whatever reason, later on, you got dismissed and it's also been defendants.
Well, I believe in the depositions, there were clear questions asked both to everyone actually in deposition that said, did Sean Smith, did Mike Tully, did Ian Silverstone have anything to do directly with any of this? And the answers were no. And that's why the people were released.
Thank you very much.
Mr. McLeod, do you have questions for Mr. Smith?
Just a couple here.
That's two. I bet that's not going to be the actual count. Yeah.
Good morning.
Good morning.
We've met before. We've had fun occasions. Wanted to just cover a couple of things. You testified earlier that, I'll tell you what, let's talk about the drainage systems in the community. You're the president, you've been the president for about 10 years. Is that
Yeah,
correct?
going on 10 years. Yeah.
Okay, so the drainage systems, those are located in the common areas. Do you agree with that?
Correct.
Okay, so let's go back to 2006 when the community was developed. The Ibezims residence where it's located now, that was not originally submitted to the association, correct?
Correct.
So back in 2006, the drainage systems at that time that had been submitted to the association, those were under the purview of the homeowners association.
Correct.
Do you agree with that?
Yes.
And so at that time, once the drainage systems had been submitted to the association, they became the responsibility of the association, correct?
Again, I wasn't there in 2006. I'm assuming that that's how it went. I also don't know because it was new construction. I don't know all the ins and outs of what the previous builder, because I'm sure they probably had a similar issue as this one.
Okay. So let's talk about the phase 2 property back then. Maybe you came along a little bit after that. But at that time, the developer still owned that property, correct?
Correct.
And so as the owner at that time, the developer would have been responsible for maintaining that property, correct?
Correct.
Okay. So then we move along, the developer's foreclosed on by Wells Fargo. At that time, Wells Fargo takes over the property. They're the owner of the property, correct?
Correct.
So they would be responsible for maintaining that property, correct?
Correct.
And then GeoSam buys the property from Wells Fargo. So at that time, GeoSam would have been responsible for maintaining the property where the plaintiff's property is located.
Correct.
Correct. Okay. So the next owner of that property, would they also be responsible for maintaining that property?
It really depends because the next owner was the builder. And like I said, I don't know all the ins and outs between the builder and GeoSam. my no issues, everything ideal world, yes, the next owner would take on the maintenance. Under these issues, I think it's a totally different situation because the issues that were had on that property came from the construction.
And did you believe at the time that Water's Edge Group became involved, that they owned all of the phase 2 property, including the common areas?
Like I said, I don't know. All I know is Water's Edge is the company that showed up to meet with us. I don't know all the ins and outs of the GeoSam Water's Edge relationship, but I know how it was presented to the board. I think it was Ian, and I had forgotten that Trevor, but Ian reminded me in the deposition that Trevor was there as well for our first meeting. So all we knew was Water's Edge is here to develop these lots. We'll see how it goes.
And is that what they were when Water's Edge showed up? Were there concrete pads even, or it was just dirt?
It was, as far as I can remember, no, there were no pads. I don't think there were pads. It was just dirt. Just dirt with the pipes sticking up.
But you see, so like the green pipe and the white pipe, someone had done some basic plumbing drainage.
Exactly.
In that respect. And that's what was acquired and built upon.
Yes.
Not already a building, but it didn't get finished because people ran out of money. Basically dirt lots with pipe stuff.
Exactly.
And those lots had already been graded, correct?
No. The lots, it could not possibly have been graded because even where you guys put your trailer, there were mounds of dirt over there. Behind the trailer, there were mounds of dirt. So you guys came in, or when I say you guys, Water's Edge came in, and if it was already graded, there's a lot of machines that wouldn't have been necessary when they showed up. There was a lot of grading that had to be redone because you just named off the succession of all of the builders. I moved in at the GeoSam phase. So I think the first date you said was 2006.
That was the beginning.
That was the beginning. So a lot of that land had been sitting there. I don't know who was the last to grade it. All I know is there was a lot of grading work that got done when Water's Edge came in.
Okay, let's get back to the ownership of the actual land issue. You don't know exactly what, and at the time that all this happened, you don't know what land Water's Edge actually owned, do you?
No, the only thing I was told, like I said, I don't know who created what businesses to cover what and everything. I don't know all the ins and outs because that was your side. That was the Water's Edge side of it,
But at some point, the association took a deed from GeoSam to the common areas, correct?
Correct.
And you actually worked with GeoSam to actually have the building of the plaintiff's residence and the common areas submitted to the condominium. That's correct.
I don't know if we worked with them. They submitted the paper. I mean, I don't remember what the process was. I remember getting, I think at the end of the day, it just takes an approval from us. I don't remember all the submitting and all that stuff.
I'm going to show you what's been marked as D11.
Do you have a hard copy of your exhibit? I know you emailed things, but it would be great to get a hard copy of your list like Mr. Stewart provided.
Here's a copy.
Thank you. You said 11?
D11.
Okay.
And, I will share this really quickly.
I wouldn't put anything up yet because it's not in evidence yet.
You need?
Yeah. Have you reviewed that document?
I did.
Are you familiar with that?
I remember this briefly because back in when did we become board? 2014.
You can look at the date on the document.
Yeah, it's 2017, but I'm just trying to think. I remember it briefly. It's been a while.
Okay, could you just describe what that document is?
So this is declaration of the easements, covenants, and restrictions for Mill Creek Lakes. And basically, and I haven't read through this just now, but and it's been years. So I'm just looking at one line. It says GeoSam desires to submit a portion of property to the association.
Okay, and so if you'll flip to the very last page.
Okay.
Okay, and the legal description on there, it says that it's.
So do you want to tender it before you start getting into the contents of it? Defense 11, Mr.
Objection.
No objection from Mr. Stewart. Mr. Dorsey?
No objection, just to the document.
It's admitted.
Fingers.
No one should be touching any cables right now.
Okay. There we go. So, Mr. Smith, this is a supplemental declaration of the condominium, correct?
Correct.
And this declaration was done to add building 30 to the condominium, correct?
Correct.
And so, and the date of this document is November the 28th, 2017, correct?
Correct.
And it was recorded, you can see up in the top right, in January 2018, correct?
Correct.
So as of January 2018, prior to the time the plaintiffs purchased their residence, the association and GeoSam had actually submitted this document to actually submit their building to the terms of the declaration, correct?
To submit the land, you mean, right?
To submit the land. to
Correct.
the declaration.
Correct.
And so what was the legal effect of that, if you know?
But offhand, I can't even remember all this. It's been years.
Would you agree with me that this document was necessary to submit that land to the terms of the recorded declaration of condominium?
I believe that's what we were told at the time.
Okay. And if you'll turn to page 4,
Mhm.
and the number 4, in fact, and I'll read it to you, it says, the approved property shall be added to the condominium and shall be submitted to and subject to the terms of the declaration, correct?
Correct.
Okay. And why was that necessary?
Well, I think I mentioned it earlier. I can't say why it was necessary on you guys' end, but on our end, our only amenity in our neighborhood is a pool, which is gated and at the time was serving 121 units. It wasn't worth us having one association with 50 units and another association with 120 or 120 and then 54. So it made more sense to bring everything in under one, especially since it's the same property. Like we'd have to have 2 landscapers, 2 of everything, and it just did not make sense. So I believe that's what this was for. Am I right?
Close enough. Would you agree with me that until this document was recorded, you could not start collecting dues from
That too.
the purchasers?
Yes.
So this was necessary for the association to start collecting dues
Yes.
from the purchasers, right?
Yes, correct.
And so because of this document, when the units started closing later, you started collecting association dues, correct?
I believe so.
And those association dues were used to pay the common expenses, correct?
Correct.
And that would include for maintenance of the common areas, correct?
Correct.
Okay, so would you agree with me then that as of January of 2018, the association became responsible for collecting dues for the common areas of Building 30?
Correct.
Okay. So we're not in disagreement that you
No.
guys, as of January, prior to the plans purchase, were responsible for the common areas?
Yes, correct.
Okay. So you testified earlier that you said that you thought Water's Edge was responsible for maintaining those common areas, correct?
I mentioned that Water's Edge was, in our opinion, was responsible for that common area, that one piece of common area. We've only been addressing one. So, and the reasoning for that is because, and I think you mentioned yesterday that the common area was never touched. Common areas absolutely was touched. In building, it was touched. In grading, it was touched. And it was not touched by the association. It was touched by you guys, by Water's Edge. We've discussed, Mr. Stewart asked me about the check dam. Unfortunately, life can't pick and choose what rules you want to follow. Either you're going to follow them or you're not. The check dam didn't have approval. That was on common area. So if we're going to argue it one way, we need to argue it the other way too. So in regards to the problem that was created, that was initial development. That had nothing to do with any efforts by anybody on the board. It didn't have anything to do with the Ibezims. That was on Water's Edge.
Okay. Back to this document, you actually, is that your signature on the
It
back
is.
of this document?
It
So you
is.
actually signed this document.
I did.
To submit this property to the association,
Correct. Correct.
You were involved in this process.
Correct.
So with respect to your belief that Water's Edge was responsible for the common areas, do you have was there any agreement with Water's Edge that they would be responsible for that between Water's Edge and the association?
I don't think we had any written agreement, but I think if you're a builder, I mean, it's kind of like a car, BMW makes a lot of cars, but they also do recalls. Every car company does a recall. When they realize that there's a defect, the builder is the one that fixes it. In this case, Water's Edge, it obviously was a problem, and it wasn't created by anybody but Water's Edge.
That's your opinion.
Well, I mean, even the expert yesterday mentioned that, because if we're talking about Water's Edge's responsibility when it came to the water flow off of, obviously somebody did something wrong, and it was not on our end, because we wouldn't have the problem with the water right now if everything was done correctly.
Well, it's clear that you felt Water's Edge was responsible, and I think it's clear that Water's Edge felt the association was responsible. Water's Edge actually notified you guys. There's no dispute that Water's Edge notified you guys.
No.
That they thought you guys were responsible for maintaining the common areas, correct?
No, there's no dispute on that.
Okay. So did you seek any legal counsel after Water's Edge notified you to ascertain who was legally responsible for those areas?
To be honest, I can't remember all the steps that were taken. Honestly, there was so much going on at that time in the neighborhood with all of this, and then, finishing up the neighborhood and everything. Sorry.
Okay.
So I honestly can't answer that question because I just don't know.
But you don't recall seeking any legal counsel for this particular issue, correct?
Like I said, I don't know. I honestly don't remember it.
Let me ask you this drainage issue behind this particular building, pretty unique drainage issue to the whole community, correct?
That one I will say, to those last two buildings, I'll say.
When I want to make sure I understand. When you say last two buildings, meaning 30 and 31, or last to the Ibezims unit and the unit right next to theirs?
To that entire street, 30 and 31.
Got it.
Okay, so and I guess my question is with respect to any of the other buildings in the condominium community. Have y'all had to take such remedial repairs before?
We have, but it was after, I'd say 14, 15 years of the neighborhood being there. Since I've been board president, I want to say we did the first, well, actually, I mean, if I'm being honest, my unit had some water issues. We had some erosion issues, but that was after 2-3 years. Yeah, I think so. Yeah.
Did it get the immediate presidential fix? Because
It
was
did
your
not.
unit?
It did not. It actually took many years and many steps to get it done properly. And actually, in regards to mine, the previous CMG management was the management at that time. There were a lot of Band-Aids put on, and it got to a point where the entire corner of my unit, I could crawl under it and lay down and take a nap because there had been that much erosion. So it took years, but after getting, just like we did with this, after getting the proper people to come out and everything, we were able to get it fixed.
The drainage swale and drainage, storm drainage inlet that is behind building 30 and 31 that serves both of those buildings. That drainage system has been there for years, hasn't it?
I mean, it was just flat land. It was just land.
The drainage inlet that was there.
Oh, the inlet. Okay. I apologize. Yes, that inlet had been there for years. That was put in, I'm assuming, when they did the piping for the dirt pads that were there.
Back at the beginning of the development.
I'm assuming so. Yeah.
And would you agree with me that that inlet is connected to the entire drainage system?
I honestly couldn't tell you because, to be honest, if you look in the Elmina report, one of the pictures there shows a wooded area next to the building. There is a stream that runs right through there. So I don't know, because that drainage, I can't say that it's connected to the rest of the neighborhood because it may not need to be. It might just be connected to the drainage right there. And later, when that picture comes up, if you need to see it, just let me know. I can show you exactly where it is.
The Water's Edge did not design or install that drainage system.
No.
That pre-existed there, your involvement with the property.
Yes, that part did, yes.
After you submitted the property to the condominium, did you guys inspect the drainage system at all?
No, that was not after we submitted the property itself, we still, I mean, just because they were submitted, we still didn't own those properties. Is that what you're talking about? Like,
yeah, I'm gonna hand you what's been
Okay.
marked as D13.
okay.
I've never seen that document.
To be honest. This was dated 2018. Is this the one for the building?
If you look at the back, the legal description of the deed.
Okay. I see lots 178 and 177.
Right. And
If you
what?
89, okay. These were two
open space
described as open space, okay.
for phase 1 and 2.
Okay, for phase 1 and phase 2. Okay, so I guess what was,
Are you,
it kind of jogs my memory,
Okay.
yeah.
so tell me what you believe that document.
I think this is just the, I'm guessing what brought over,
So we need a different witness.
Yeah.
It's okay,
I don't want you
because
to
if you're having to guess, he's got the wrong witness for that document.
Let me ask you this. When property is submitted to the condominium,
Mhm.
are you in charge of keeping those records?
I'm not in charge of keeping
You're
them.
not-
We have a secretary who keeps that stuff, and copies also go to our management.
Okay, so I just wanted to, have you ever seen that document before?
To be honest, they all look alike to me, but I'll say I partially remember conversations about this, but I don't remember the document exactly.
I'll give this to somebody else.
Okay.
But you would agree with me that at some point, the association took a deed for the common areas, correct?
Yes, yes.
Do you have any recollection as to when the association took a deed for the common areas of the drainage swell behind the plaintiff's residence?
That I don't know. That I don't know.
But after they did take that deed under the covenants, would you agree with me that the association became responsible for maintaining the common areas?
Maintaining, I would say yes. The problem with the term maintenance, I wouldn't consider construction maintenance, initial construction. I believe it also uses the word upkeep. So if we're upkeeping something that was done by you guys, like we shouldn't, that's not maintenance. That's you guys, Water's Edge created the initial issue. So it's like if someone came in our neighborhood and did, say someone with a tractor just came in our neighborhood, decided to tear up the grass and stuff. Sure, we're supposed to be responsible for it, but that person's the one that caused the damage, and technically there should be damages against that person, not against the association. So to me, it's the same principle would apply in this, because we didn't have engineers out there. We didn't have Gwinnett County out there. We didn't do anything.
You don't know what grading Water's Edge did.
No, I don't. I just know that it was done.
In terms of maintenance or upkeep, when you were checking things out behind building 30 or 31, is it building 30?
30, yes, correct.
Behind building 30, if you had noticed in the swale that little trees were growing up and that was causing the water to move more slowly or whatnot, would removing the saplings or whatever we want to call them from the swale fit into your understanding of maintenance or upkeep? I hear you that it's not regrade. If the hill is the wrong hill, that's not maintenance. That's redoing, like your example,
Yes.
of a hole that was dug. The swale is the swale, but if stuff starts growing up in it, or the pine straw washes away, that sounds like, but it's a question, that would fall within the purview of the association maintaining or upkeeping, keeping up the, yes?
Correct.
And so likewise, if there was an issue with the storm drainage manhole, that would have been the association's responsibility to maintain or correct. Would you agree with that?
That I would say yes. Yes.
Okay, so just to be clear what you're saying that generally it is the association's responsibility to do maintenance. It's just your opinion that Water's Edge created some sort of grading issue that maybe it was their responsibility to repair. Is that fair to say?
I think it's a multifaceted answer. If we're using the answer for the manhole, you guys never touched the manhole. So therefore, I could honestly tell my board, hey, they didn't do this. Like, this is on us. We need to unclog it or whatever. That would make sense. What the judge said regarding the maintenance, little stuff, that makes sense. You guys wouldn't have caused the sapling to come up in the swell. But in regards to what was actually done, at the end of the day, we're dealing with, I'm left with two options to think about. Either you messed up, and when I say you, I mean Water's Edge, or Gwinnett County messed up. Because there's no way possible, even with the swell, we can talk about perfect scenarios with the amount of water that was coming off those buildings, and the doctor mentioned it yesterday. Somebody didn't do something correct, and it wasn't the fence. At the end of the day, it wasn't the fence.
But so are you saying that you think there was a design defect in the grading for the drainage system behind the unit?
I think the proper drainage on the units was not sufficient to collect the amount of water that came down there. I also think that the swell itself was, and yesterday, actually, when I heard from him and I looked at the picture, it was way too close to the buildings. I mean, you literally step off of your patio into a swell. And I just think somebody didn't do something. But the one fact that remains, the association had nothing to do with creating this problem. That is a fact.
I'm not disagreeing with that specifically because you guys didn't design drainage system. But you did take ownership of that property where the drainage system existed. You would agree with that, correct?
I would agree with that as much as I agree with taking ownership of a car and then that car failing me, when the bottom line is there are companies have warranties and things in place to cover things like that for a reason.
And so at some point, you took that property, not from Water's Edge, but you took that property from Geosam.
Which is correct.
No further questions.
All right, I have one, so stay there in case you want to follow up on that. Mr. Smith, as I understood your testimony, once the downspouts were integrated into a pipe that the association paid to install, basically became an underground swale, which means it's not a swale, it's a pipe. Once the downspouts were integrated into the pipe that I'll say you installed, you guys, your observations were the water issues were abated, they went away.
Yes.
Okay. Who, from your perspective as president of the HOA, was responsible for making sure that the downspouts that ended apparently prematurely onto the cement pads weren't causing the problem that they seem to have caused? Is that a Geosam issue? Is that an owner issue, as in each individual owner, because it's my downspout and it terminates on my cement pad? Is it an HOA issue? Is it we're finding someone and we'll sue them issue?
It starts off as a owner issue, because with 174 units, like we walk the property pretty well, but we don't see every little thing. So we rely on owners. If there's an issue, it's very easy process to jump on the Tully website, submit a work order. And I mean, within minutes, within seconds, it pops up in the manager's email. They send it to us right away. And then we can tell them, okay, just call so-and-so to do it. Usually for something like that, those problems don't even make it to us, like something like a downspout, because they're authorized to do certain things initially. Does that kind of answer your question?
Well, I think leads to a follow-up, which is, so that sounds like the HOA's view is that it's an HOA responsibility to fix once it's reported. So
Yes.
Owner says, hey, my downspout only goes to the edge, not over the edge of my concrete slab. And so water goes everywhere into my neighbor's yard, my yard. You guys need to do something about it. If nothing is done about it, that's on the HOA. If the HOA addresses it, which ultimately it was with this new pipe and everything, then that's the HOA. I think it seems to me effectively saying it's our responsibility once you bring it to our attention.
It is.
Okay.
It is. If we see something as well,
Sure.
we accept responsibility for that.
Okay. So did you, based on that, did you want
To
to follow?
follow up on that, yes, so with respect to the remedial work that you performed, which I think you were kind of alluding to. In this lawsuit, at one point, the association claimed that the Water's Edge was responsible for that drainage system. Do you agree with that?
I believe so. Yes.
But the association dismissed that claim.
I believe we did after, well, this was all during when everybody was suing each other and all that. I mean, eventually it got withdrawn, just like the ones that got withdrawn on me, Mike, and Ian. So yeah.
But the association is no longer claiming that Water's Edge or WEG Creek is responsible for that drainage system, right?
I mean, our beliefs are our beliefs. We've stuck to our beliefs constantly. The problem is, at the end of the day, as president, do I believe that wasting my community's money to fight something that I can spend $6,000 on? At the end of the day, it wasn't worth going through this over $6,000.
Nothing further.
Just for the record, that was a long couple of questions. Yeah. Mr. Dorsey?
I'm sorry.
My advice is don't tell us the number of questions you have.
I won't.
Good.
Mr. Smith, I'm again gonna kind of bounce around. I want to talk about a few of the things. I want to start with Judge McCartney's question that he asked you. And you, I think, answered it pertaining to individualized and kind of a general sense, but I want to ask it more specifically. With regards to integrating the water runoff from this development, whose job was it to make sure that the water that was displaced by those roofs was integrated into the existing drainage system?
I would say that's going to be Water's Edge and Gwinnett County.
As we talked about at the outset, there's a host of cast of characters, right? One of which, I apologize, I call it Patriot Homes, it's Portrait Homes. So if you're wondering who was wrong, it's but hopefully everyone got the point. And I would simply want to know whether or not the HOA, the association, or the management company, Tally Community Management, hired, retained, sought, or in any way engaged any of these companies. I'm not this, okay? So
Okay.
yes or no?
Okay.
GeoSam,
No,
Portrait Homes,
no,
Wells Fargo,
no,
Water's Edge Group, or its acting entity, holding company, any of those?
no,
Any of the grading contractors prior to the remedial work that was done stemming from El Nino and preventative maintenance? Prior to the issues, any of the grading contractors or installers of the drainage system or sewer integration system?
no,
So the HOA in essence had no relationship with any of this.
none whatsoever.
And that is what we're seeing on the thing right here is simply them declaring it into the condominium association.
Correct.
It wasn't anything that y'all engaged in.
No, no.
If you don't need, can we take that? I want to take it away from Mr. Dorsey if he's going to use it. You're done. Let's take that down. Thanks. Get back to our witness.
I want to be very clear about one thing as well. Once the land was deeded to the association or adopted into the covenants, we'll go a little bit earlier, January 29th. You agree that the maintenance, which we clarified, thank you, Judge, for maintenance, you agree that was your issue, correct?
Yes.
That was something you were responsible for.
Yes, correct.
But it's also your position, I believe, that this maintenance was not what was causing the water to back up from that drain spout 50 feet away, all the way up to their property, correct?
Correct.
So it sounds like some of these reports and stuff, we're trying to address all of the issues we could find, not just theirs. So they might have addressed some things downriver, we'll call it.
Correct.
Okay. I was really hoping that we wouldn't get into this, but unfortunately the door was kind of slid open. You were asked earlier about the restraining order and some steps you took in your personal capacity, not in your capacity as the HOA president, the association president, right?
Correct.
And if I remember your testimony, it was that you felt, one, you wanted to direct everyone through the proper channels instead of me just picking up the phone and calling you, hey, will you do this? Instead of going through the portal. That was part one, correct?
Correct.
And I believe I heard you say that there was some concern about your family and just making sure your kids are safe.
Correct.
And how old are your kids?
Let's see. Right now, 14 and 12.
Okay.
At the time, 10 and
18,
yeah.
something like
Yeah.
that. Were there any reports or anything about mannerisms within the neighborhood that gave you those concerns?
So I had received, Chris and I, just to give you a little bit, when we first met, everything was cool. We had no problems. It was, Chris, help me to help you. It started getting to a point where everyone thinks that the HOA is not doing anything, which I get. But at some point you have to trust that your HOA, we're communicating, we're telling people, hey, this is what we're planning on doing. It just devolved into something that, quite honestly, I just wasn't willing to deal with anymore. There was I received phone calls from people about Chris walking around with a rifle on his back through the neighborhood. I had to call Gwinnett County to make sure everything was okay. You know, I remember an officer being outside of Chris's unit, and I pulled up to make sure everything was okay. And the words were literally, "Look, officer, he drives a BMW, so he's stealing money from the association." As if that's so unattainable to drive a BMW. Like there was so many letters going door to door with just lie after lie after lie. I understand being disgruntled. I totally get that. We've all been there where something doesn't go our way, but I'm not going to slander individuals that are trying to help. We had our annual meeting, and I mean, literally, they were there. He says, "Oh, Mike, you almost just called me the N-word." What is almost calling somebody the N-word? Either you do or you don't. And we're all sitting there like, where's all this anger coming from? I believe there was even, if I'm correct, there were times, because I had spoken early on with Water's Edge. I know vendors came to the house, and I believe Water's Edge even said that the vendors said they were like being intimidated or treated badly. And it's not, trust me, this is not a conversation I wanted to have, but Mr. Stewart opened the door for it. This isn't just a Sean thing. And in regards to what I'm talking about now, it's not just this is a general treatment, intimidation, constant use. I mean, just, it got ridiculous to the point that me, a grown man who can handle his own, has to go up to Gwinnett County and say, I don't want anything, any parts of these individuals contacting me anymore direct.
All right, next question. All right. Mr. Stewart, do you have brief redirect?
Oh, thank you.
Okay. Mr. Smith, I appreciate your testimony. You
Thank
are
you, sir.
able to, oh, wait, no, we have two juror questions. Almost forgot. Ladies and gentlemen, if you have any questions, write them down and Deputy Gordon will collect them.
We have one.
Any more questions? Yeah. What's up?
You got the right idea.
You'll be able to do the same when we go out. Do a little hokey pokey. Thank you, sir. We got all sorts of new colors today. All right, you all can be at ease for a few minutes. Counsel, I'll see you back in chambers.
Yes. It is. Oh, okay.
Oh, yeah, it's still that one.
I want to say it's ESHUN. I believe UN. Yes. Yes, no problem.
Crackers there. I know that that's like, yeah, I bought a little, well, this is a little, Uncrustables, some peanut butter and jelly little snack. And I bought some fruit, a little fruit salads. And, what, I think I had some nuts and raisins, and I said, by the time you
I did. What was that? I did say something forwarded to the management company. I know we talked about, was it towards the end?
I know.
So he asked me, I'm trying to think what we, it was, it was the one copy, it was the second copy that he had. It was a Gwinnett County document. The management company, you mean? Oh, Tully. Tolley. Yeah, no. I appreciate you.
I go to the pavilion to my husband. We make come to the pavilion. You know, the pavilion. Where's the pavilion? People there and everything.
Everybody's friends.
Okay, you're not. I'm still learning my way. Still my learning. You know, we just moved down. This guy's 7 years now.
You have all our.
I just turned. Just turned 90.
Did you get a missed call?
Now my daddy.
They young.
Oh, that's right.
Just don't talk about the trial. We're not gonna be. We still know they have it. One of my sheets. Are we on? Let me see, we're not gonna be February 23rd. February 23rd. Wait. February 23rd is a Thursday.
You sure? No, the 25th.
The 25th.
Oh, no.
Okay.
My grandmother a long time ago.
Pound sign.
I used to say you were in your own mind. When I was 5 years old.
I don't come this way at all myself, child. Everything is in Fayetteville for me, living in Union City, my husband shop at Walmart. All these over there, separate. Oh, yeah, the Kroger too, we do that Kroger. And Publix sometimes. Publix and top of take that roll. Yeah, but you know, they got Ashley Park down there. It's crowded down there. I mean, it's a lot of traffic. Okay. But we can go Ashley Park. We got they don't have it. So you got to go to the. What's that you know, it's like you're going out of town instead of
You vibrate one. I get
Y'all brave. So mine is on mute. Was right, so I worry about the watch, but I put it on. Well, you know what? Somebody was calling yesterday after I went on mute. I was like, "Girl, you should have called." I'm stressed about contempt of court for being late.
I'll sit here for the next 3 trials.
April Jam.
I know.
Right, you living your best life.
He having a fun time. I'm trying to cut the music off. Now I got music on. That's all I need is this.
Well, my husband told me that yesterday because I didn't get home till late leaving here. That, you know,
I got some.
that's what I told my husband. He said, "Oh, I'm concerned." I said, "Well, you ain't got that concern. You ain't called and try to find. You ain't called. You ain't gave me no message on my phone because I did have my phone yesterday." He said, "Well, they just said it on the news." And I said, "Well, where was that judge?" I said, "We got a pretty private judge." I said, "We would have got us up out of here and told us what to do."
Yeah.
I said, "We because somebody took this little conference
Yeah.
and he had to get that screen." Me too. I left out of here. I was trying to merge with 75 and all that traffic. I was a hot mess.
You don't remember having this party at
Like 911-833-4730. Yeah, it was. I started to go somewhere and shop because I know I had a look at the items covered, and I said I could refresh, so I could have something brand new. I said I'm gonna have to make do with the scrap. It was.
Yeah, a lot of people come back like, oh, we went to Sandals or something, or Cancun, and they have to and they want to order it.
What is a juror number? Yeah. Are you gonna remember that?
True. So you gonna invite us to your sneakers? We're gonna have to wear some black sneakers.
I'm only doing fun. I want to do fun stuff in Atlanta. I want to do fun. Right. Sneaker party.
Gotta do the sneakers.
I've never in town a lot, but that'd be fun.
So what is your district? Is it southeast or Midwest or?
So I have all of Florida and all of Georgia. So I have like 9 reps, most of them in Florida.
Okay, well, you got the sunshine state.
Wow, I know, right? But I'm not. Well, I live there.
912 964. I'm sorry. Oh, I'm talking on the phone in the house number. 912-656-5522. Michelle.
Yeah.
25th and then this month.
Next month.
All right, you get started.
Let me make sure.
Loud like that.
Got me on.
All right, Mr. Smith, a few more questions. Is there anything, if you know, in the covenants that require a new homeowner, someone who is buying into the community, doesn't need to be a new unit, but I'm new to the community, I buy it, to pay a fee at closing to the HOA? So not the monthly dues, but welcome, give us X dollars.
Yes, they, each homeowner, when you buy, I believe I can tell you the exact cost. So right now our dues in our neighborhood are $212 a month. You pay 3 times, so 3 months of dues. So we'd be at what, $636 would basically be what they would need to pay in initially.
And does that credit them for 3 months, or that's your initiation fee and you owe 212 the very next month?
They also pay, I think 2 months down or something like that. So that's their just capital contribution to get into the association.
Anyone buying a unit is going to pay 3x the monthly assessment.
Yes.
That's contribution to the larger welfare fund, if you will,
Exactly.
to pay for things like a drain.
Exactly.
Okay. As president of the board, do you have veto power over a board decision?
I do not.
Is there a written policy that governs how the association chooses vendors for particular projects?
No, there's no written policy. The best practices though, and I believe it's for property management industry, is to usually get 3 quotes on everything. That way it makes my job easier as a board president when things are presented to me, because we can sit down and have some usable data, figure out, which one makes sense, who's offering the best value for the best dollar.
Building 30 has been the building we've been talking about the most. Do you know month, year when that building was completed?
It was brought in, I believe, in February 2018. So it would have been, I want to say probably between November and December, I would say. You figure they might have had some pre-sales, so it might have been faster, but.
You say it was brought in, meaning building 30 became part of the community in January, what did you just say?
I believe it was February 2018.
So it would have been built before then?
Yes.
You're saying maybe
yes.
November of
I'm
2017?
thinking like November, maybe October, November.
Okay.
Fall
2017?
Yes. Yeah.
And you were already a resident of the larger community by then?
Yes, correct.
Did you observe any water runoff or drainage or any kind of issues prior to around building 30 prior to its completion?
No, we never had anything like that.
Did the HOA receive any other complaints from other building 30 occupants about water runoff?
The only complaint that we received was from the first unit, which is in the picture, the one that had the moss on the patio. And that was specifically just, hey, like water splashing up onto my patio. Can we do something? But his issue was nothing like, his was just more of a maintenance thing. I think in the picture he had initially, I don't think he had the little, I don't know what they call it, little thing that the drain hits and then flows down. I don't think he had that. So it was just creating like a little hole under his drain or whatever and splashing and stuff. But I believe we put that in and he didn't have any problem after that. We didn't hear from anyone.
Are owners allowed to rent their condos, turn it into a rental property?
They are. We have a rental percentage that we are held to. It's either 20, I think it's 25%. So usually what happens is, in this example, I guess as it pertains to the relationship between us and Water's Edge, we had reached cap previously. So there were no more rentals to be had in the community. But of course, when you add 50 something units, you can add some more rentals. So we had a first round of sales where we were issuing rental permits for them. So if we're at cap and somebody wants to rent out their unit, if it has to be a hardship, we've had a lot of reserve soldiers having to move, and we do allow them because of service to move. So, but usually you would have to wait for someone to fall off of that list before you can rent your place.
But it sounds like from that answer, the vast majority of occupants are owners.
Yes.
75%.
Yes. Yes.
Are the drains regularly checked throughout the different phases to see if they're clogged?
Yes. Throughout the phases, in front of each drain that was undeveloped, well, all the drains were developed, but the ones that weren't really being used for the lots were just dirt. So they put like this, and you may have seen them before. It's just like a black long black tube. They put it in front of it to keep anything from going in there. So the drains were pretty clear. There was no usage whatsoever on those back streets. But yes, there was regular maintenance. It's not that we necessarily had to do it, but I can assure you there were plenty of calls at the time to GeoSam, especially in the beginning, because they needed some work to do. So,
But for developed units, so now building 30 and all these other buildings, are the drains routinely inspected for clogging?
Yes, definitely.
Does the HOA have an inspection or maintenance schedule for swales behind the different buildings?
So we have, and I think Mike talked about it, Mr. Tully, we were working on a reserve study. And so the reserve study kind of lets us know when things are going to be necessary, kind of gives us at least an outline of, in 5 years, you guys are going to need to do this. Like I said earlier, I'm very active, so I pay attention to a lot of the stuff in the community that nobody does. So, but we do, we definitely have plans in place for things like that.
Okay. So that is right now, they aren't routinely inspected or?
Oh, no, they are.
Okay.
They are, yes.
Right. Did the HOA inspect the common area around building 30 prior to admitting it into the association?
So the area around unit 30, and I wish we had a picture of it. You could see the end or the beginnings of the hill. It basically, and I think he did show you an aerial view, but it basically just goes up to the next neighborhood. It's just a hill with pine straw and trees on it. So visually inspection, yes, like we did walk around the building and things, but ultimately the visible issues, because we've had nail pops and things that you see, shingles and areas that didn't get painted. Water's Edge did come back out and do those things. So there weren't any issues there. But in regards to, I guess that, I don't know if that was through warranty or what, but yes.
Does the Architectural Review Board receive or has it received any training to be aware of what the Gwinnett County building codes are so that they're not blessing something that has to be torn down?
Realistically, most boards probably do not get that type of training. It's, like I said, it's a volunteer position. I manage a high rise in Buckhead, and there's a lot of training that we wish everyone could have. But when you're dealing with a volunteer board, it's hard to tell somebody you have to go to class for this, especially when, we're voting on a board and 5 people stand up and we need a 5-person board. Like, it's not like we just have to take what we can get right now, So.
Is there anyone from building 30 or 31 on the board?
No.
Does anyone on the board have any building as in home construction experience?
Let me see. One on the board, I know she works on, she builds Captain D's. That is construction, but
I don't wanna live in a Captain D's, but
exactly.
It's got walls and a roof.
Yeah,
Okay.
but that's the extent of her.
Got it. Okay. Were you ever inside the Ibezims unit?
No.
Is new pine straw put down in the common areas every year or more frequently than that?
Yes. And I'll note back there is pine trees as well. So there's regular pine straw back there.
Nature provides its own pine straw.
Exactly.
All right. Are you aware if there's a standard that dictates, as in a county regulation or a city regulation, that swales be a certain distance from a property edge, whether that's a fence or that concrete slab?
I'm not aware of any standard.
Ballpark, how many foundation issues? You mentioned you could take a nap under your slab or wherever it was. How many issues like that have been reported through Mr. Tolley to the HOA?
I can think of 3 or 4 throughout the time that I've been president, which is almost 10 years.
Okay, so it's not common.
No.
Do you know if the certificate of occupancy for buildings 30 and 31 would have been issued to Water's Edge or the homeowners association or GeoSam?
That's a good question. It definitely would not have been to the association. Like I said, I don't know the relationship, the interworkings of their relationship with GeoSam, but it would have, I'm assuming it would have been Water's Edge who would have gotten the certificates.
Okay, you're not sure, it's not you?
It's not us.
It's not the,
Yes, it's not the
HOA.
association.
Okay. Did the HOA ever reach out to Gwinnett County to say, how was there a certificate of occupancy granted given this water situation?
I'm going to say I believe a call was made because I remember hearing something about this. And I'm just going off of what I was told. I was told that an inspection wasn't done.
Okay.
At least that was the end of the conversation, but I can't verify it because I didn't hear it
All
firsthand.
hearsay.
Yeah.
Okay. You've described to the jurors a meeting at the firehouse where the board was there and the Ibezims were there to talk about the 2 El Mina options.
Yes.
And someone from the board explained, this is the plan we're going to move forward with. What was the plaintiff's response? What did the Ibezims say? That's great. We object. How did that meeting end?
It didn't end in a negative manner. I think everybody was of the understanding that here's the option that we're starting with. This is the reasoning behind it. After this is done, if there's more that needs to be done, by all means, we can go to the other options. Because I think it says on there specifically, the only difference between these 2 is step whatever.
Okay.
So, but I thought the meeting went very well. Yeah, I mean, it wasn't a negative meeting at all.
Following that meeting is when the work was done to put this pipe in and the downspouts were connected to the pipe.
Correct.
As I understand it. After that, you, through Mr. Tolley, received no more complaints from the Ibezims about water intrusion issues.
No,
Okay.
no.
But this was also maybe at the same time when the Ibezims may have been under the impression they shouldn't contact you at all for the reasons we've talked about.
Yeah, but contacting me is one thing.
Understood. That's not the same as contacting
Exactly.
Mr. Tolley or the management.
Exactly.
Okay. So as you reflect back on what was causing the runoff that you observed when you were out there inspecting and looking at the videos that Mr. Ibezim shared with you, is your assessment that it was the roof runoff and the drains that weren't integrated into a pipe? Or was it the fact that the swale didn't run the right way? Or how would you distill it for the jury?
In my opinion, it would definitely be the water that was coming off the buildings. If you looked at the slab issue of the next door neighbor, the water that the expert said yesterday was running under that area was eliminated. So there was no, or should be no further issue pertaining to the swell. Now I know it was mentioned today, it came out of left field, the gutter. But that's not what we're talking about here. A gutter issue is a whole different animal.
Did you ever receive any complaints, or I don't mean to make it sound pejorative, a report that there is a defective gutter from anyone in building 30?
Not a defective gutter. I know we have cut back, we cut back some trees back there just to keep them specifically away from the building, so we don't have to deal with that issue. But if there is an issue, it's just a phone call away to say, and we do gutter maintenance, I want to say at least twice a year for the entire community.
Mr. Stewart, do you have any questions for Mr. Smith based on those questions?
No, Your Honor.
Mr. McLeod
There you are.
and Mr. Dorsey?
Nothing, Your Honor.
All right, with that, Mr. Smith, now you can step down. Almost forgot this critical part. And ladies and gentlemen, we're going to break for lunch. I'm not leaving the building for lunch, so my parking spot will remain occupied. I don't drive a BMW. I drive a.
Oh, I don't drive one either anymore.
I'm a public servant, but it's staying in its magic spot. I would ask you all to try to be back. There's a clock on the wall there. It's about right. I'd ask you all to try to be back by 1:20. And I'm gonna ask the lawyer, well, I'm gonna talk to them once you get outside, but we have a few things we need to work through. So it was an hour, you had more than an hour yesterday, I know, but had I been back in an hour, was that enough time for everyone? Let's do it. So 1:20, we'll see you back here. Thank you so much. Don't talk about the case.
What should I do with all these papers?
If you just leave them right there, exactly. Thank you, sir.
Thank you.
Oh, 45 minutes off.
All right, you all can be seated. So I need to go meet with some other jurors in a different matter. When I get back, and we'll convene a little early, I want to issue a ruling on Dr. Spots and how his testimony can and cannot be used. And I'd like for us to talk about the concerns about attorney's fees, because I'm completely in the dark and Mr. Stewart seems genuinely confused as to why it's an issue. And so enlighten him, please, during the break, and then let's discuss. And Mr. Stewart, I did spend some time looking for a case with a party named Oglethorpe and Nuisance and Family or Children, and didn't find anything. I did find a good case for you on Dr. Spots with the name of Oglethorpe in it. That's not the one you wanted me to read, but it helped you. So if you could, I want to be educated on nuisance. This is my first general nuisance trial. And so you say, oh, that's how things always work. And you may be exactly right. But I need to be educated on that and not just say so. So if you want to get me the citation, I can be reading Oglethorpe, which I couldn't find, or any other case that addresses that issue of their sort of familial liability for the nuisance causer, because I don't want to foreclose your examination of your clients improperly.
I'll definitely do that, Your Honor, but I won't be able to do it next 30 minutes.
Okay.
Those are nitpicky, no lawsuits, but there are cases.
Okay. Even if you get the names of the two parties, I don't know if you've got in your binder some law you rely on. I can find it just with Oglethorpe and Nuisance and Family or Children. It didn't get me anywhere. Although Oglethorpe Power gets sued a lot for nuisances. I learned that too.
Yes.
And that's all I've got. Do you have anything you need me to be thinking about during the break?
No, Your Honor.
Mr. Stewart, Mr. McLeod?
No, Your Honor.
Okay, and you will speak with Mr. Stewart about your concern about attorney's fees. I think you had a concern about that, or is it just Mr. Dorsey?
I had a little one, but I can be educated.
Okay, you'll speak, Mr. Dorsey, with Mr. Stewart about attorney's fees.
Yes, sir.
Okay, and anything from your clients before we break? All right, let's be back at, I think I can be back by 1:05. We'll see. Try to be back by 1:05.
What did you say earlier?
So the 7th floor where the jurors meet, that's in the other building.
The general cafeteria area?
There's no general cafeteria. If there was, I'd send you there. But on the 7th floor, there's a jury. We can be off the record now. You don't have to say the magic words yet. Okay. The jury assembly room has a bunch of vending machines because there are often 300 people in there and they're made to wait for a long time. And so we give them candy. We don't give them, they pay for soda. I think there's a coffee machine in there. You can get, it's like you'd see in an airport where you can get different types of coffee. But you also can get caffeinated beverages there. They just are called Coke or Pepsi. So if you need caffeine, 7th floor jury assembly room will make you happy.
Okay,
All right? All right. I'll be back.
Correct. You want me to just take the book?
I think that's why we get.
I'll take one. Yeah.
How much money is it? Okay.
And I bother you for the new meeting. I should never say it.
Oh,
Even after.
Larry, you want to talk about attorney's fees?
Yes.
We got a
I can
case
get it
here
from Larry. I'll go on and
that
send it over.
seems
I
to
appreciate
talk
it.
about it. It's called Nichols versus Main Street Homes.
What's the issue? What's wrong with attorneys?
It says,
No, just tell me, don't try to put some detail on that.
it says the trial was bifurcated as the issue of attorney's fees. In the first phase of the trial, the jury was asked to determine only whether the Nicholses were entitled to attorney's fees, but not to determine any amount. In the second phase, the parties were allowed to present evidence on the attorney's fees issue, testify, blah, blah, blah.
What
So
kind of case is this as far as, it's what a nuisance is?
It was.
it's a water runoff case after Main Street developed a track upstream from their home. Let me give you the site.
I'm sorry.
244 Georgia Appeals, 591.
That's all.
You want the SEC? Yes, SEC second? Okay,
No, I will take the case.
well,
I'm gonna do it.
it's 536 Southeast Second, 278. It's a 2000 case, June 23rd, 2000.
We'll look at that.
Okay, why don't we just, Kevin, you task her to read that case and present it on attorney's fees issue. Is that okay? Yeah, absolutely. We read it, present it to our.
Yeah.
That's not trying to scare.
I can't promise that. I can always, like, I'm always a coach, you know, I'm a coach. No, I promise you. I'm retired, as I say, I'm gone. I'm this. I'm looking for station. I hired it through this trial. And that, and a bunch of other ones.
What was you asking us yesterday? How busy we are.
Yeah.
Actually, there's no such. Each other.
Well, not for your boss, for you there is.
Yeah, well, it flows up to me, so.
We need to coach.
Oh, yeah, nothing about this. We have nothing to do that. Go further. Yeah. Questions?
I think we have a request for supplementation in the probate court. Period, please check, period. I will try, period.
Yeah.
Yeah.
Oh, we're doing regulations now. But then she goes.
Yeah.
Gotta make a couple calls, so. Right across the street, there used to be just, little holes in the wall. He used to be so good. But COVID, like that. Yeah. Nobody's down here, so. Another, so now it's everyone goes to, so. Yeah. Yeah. She'll be back next week, yeah. Yeah.
Okay, guys, I can't help you much.
I'm good, yeah.
I'm gonna have to go. And see if I can- So cross, go down two, go across. Isn't that right?
But that's where the old Chick-fil-A, it used to be. Okay. They took it out. Okay, so only thing there was drinks.
Okay, I'm gonna go get something. Just to get the staff, so.
Yeah.
I don't miss. Would you like to do what?
Yeah.
It happens.
You were sitting there 5 seconds.
Yeah, it was one of those days. Yeah, I meant to put it in a bag or whatever.
Well, it is in your bag.
Oh, did you put it in or I just?
Yeah.
Oh, okay. Oh,
Put it all back.
Oh, okay. Yeah.
Good to go.
Okay. Look in the files, period. You will see a recorded deed into Asha's name and another recorded deed into the name of Asha and her niece. Period. Call her and tell her we have the original recorded deeds and she can come pick them up or we'll mail them to her. Look in Asha's file. Period. We have the original recorded deed in Asha's name and another recorded deed in the name of Asha and her niece. Period. Call her or email her and tell her we have the recorded deeds and she can come pick them up or we will mail them to her. Period. POA next week.
You don't have it.
Probably better to say.
Yeah, you should have. Oh,
At the end, she knew they didn't wait till they finished the work, so they just made what the last part was. It would have been said. It was the I don't know. May 8th, 2019. Thank you. Yeah. Senator. You can ask him. Yeah. People doing weird things.
Freedom, Breaker 1240 device lock links. Swipe up selected. Device locked. Device locked. Selected. Microphone 12:48 p.m. Device locked. Wednesday, February. Sound settings. Button. Window media volume controls. Volume set to 0%. Selected. Screen off.
You can't go to the box.
12:49 p.m.
I'm gonna try and figure this one thing out.
12:50 p.m. Device lock. Collapse. Open mic. Pattern unlocked.
My phone changed.
Pattern started.
Sounds like they're having trouble.
Device lock.
I'm calling.
Nice.
Come looking for me.
Did you have to go to your place?
I did. And then a little payment machine. So I was like, how do you think of those like a group of people sitting there? They were all dressed up. This thing. So I called them and charged for the call and they were like, no, they told us it was free. I was like, and I didn't exactly what the thing said, it wasn't working.
Breaker vibrate. Phone 3 bars. Battery 65%.
Turn voice off.
Phone 3 bars.
Turn voice off.
Phone 3 bars. Pattern unlocked. Pattern started. Pattern completed. Device unlocked.
Turn voice off.
Action available. Tab 3 fingers.
You can bring the lunchbox, obviously. What I'm going to do is.
Home. Button. Window navigation.
What I would normally do is settings.
Double tap to
Drink
activate. Double
like
tap to
Spark or
hold the
something
long
like that. I
press.
could just pour the water bottle.
Home.
But
Window
I
logo
didn't
app
have
launcher.
stuff. I didn't have it's my parents' spot.
Search for remove. Double tap to perform the action.
But
Item removed.
I forgot to get some for
52
them.
degrees.
I actually saw them this
Downtown,
weekend.
54 degrees.
I planned a weekend on the lake with my grandfather, and my grandpa,
Logo app launcher.
for John's.
Overview. Recent app.
Supposed to be
Full screen.
last week.
Double tap to perform the action.
You can
Calm
press.
split screen. Tab info. Close.
I told him.
Weather 14 of 14. Double tap to activate. Actions available. Use tab 3.
It's like, but.
Copy. Weather.
So if I'm coming, like, I'm gonna make it happen.
Weather. Unlabeled. Overview. Button. Photo app launch.
Yeah.
No
It only
previous.
seemed like 2 of the
Weather.
times.
14 of 14.
So I was like, oh.
Home.
And that's what
Home
we
screen
did.
1 of 3.
Literally left
Actions available. Use tab.
Saturday morning.
Home. Button. Photo app launcher. Weather.
I can't turn it, I don't know how to get it to turn it off. Well, I turned it off and turned it back on, I couldn't even get into it, it started doing this crap. The moto thing,
Yeah.
calls me back on
I did, and it was, I was locked out of it.
it. I don't know, I can tell you this, that ain't how it's supposed to work.
Well, you're a smart man,
What's
Charlie
the
Brown.
salary? 120 for hours, what did you say? 110. I just always walk out whenever she walks in, so.
I think you're right. I'm just.
Home, button, switch up navigation bar.
And I
Sound
can't
settings,
shut that thing up.
sounds. Sounds.
I can't shut this thing up.
He said the court will- Wow.
Yeah, well, that's fitting, I think.
Just FYI, this is all being live streamed and the microphone stays on.
Yeah. She was like. So it's getting this and stuff. I got it.
What you got?
Question, you referenced the case, Smith v. somebody.
It might be the one. I have Nichols.
I just heard Smith v.
But I don't think we said it on record. And Smith isn't in this case.
Yeah, it was.
I know you were referencing something related to that.
Oh, I think it was, I think Brendan may have mentioned Smith, v. CSX.
I know it wasn't real.
Yeah, it was, I think it was the Smith v. CSX case, but that was Brendan that mentioned it.
It was.
I'll check with him.
I put your name on that. That's probably.
I'd have to be a lot more intelligent to actually cite case law. I just say what comes in my head. Found your coffee? I found my coffee. Yeah. That's just. Correct. Cool. Both.
Yeah.
But this is where they decide.
Yeah, imagine some of the winners are not excited.
My wife, she does like pension plan and all this stuff. Okay. She's very intelligent. I think my son might have had some.
Yeah.
But she knows what she does. To me, I would rather strip clothes from mom. Yeah. Like, yeah, she's saying that's the word, certain way. But not work 4 hours. Yeah. But even if you just like, we with us at our first, I was like, she's super reserved.
Yeah.
I was super out. I was talking.
Yeah.
Like, we're so, she's stupid.
Yeah.
Larry, how long have you been practicing? I know you've been at it as well.
89,
Since '89, okay.
yeah.
I was trying to figure out between you, Tom, and Steve, who had the longest tenure in the practice law. I think Steve might have it.
I assume so.
I think he's got 50-something years.
Yeah, I ain't got that.
If you started in '89, that'd be, I was born in '90. so you've got
34
about
years.
33 years, 32 years.
Yeah.
That's awesome. I always enjoy working with and learning from people with a lot of experience, because that's the only way to learn.
Yeah, definitely. You learn different things over the years from different people.
Yes, sound happy.
Talking to you, on the way back or?
Yeah, I told her.
Because when we went through your test, a lot of questions are very similar. So you don't cover all the things we need to cover about her. I'll put her last. I'll put her last. She's a good, she's a nurse, relate to her.
She knows how to do it.
She deal with lawyers and people in the administration. She got to deal with a lot of situations. She's quicker on her feet, way quicker.
Take breath, think about it.
Yeah, 10 seconds, only 10 seconds, bro.
Don't get combative.
No, no.
Whatever you do, just consider me a combative. That's what going out of your pocket.
Yeah.
I mean, money going out of your pocket.
Yeah, I know that. She told me the same thing. I know. 43 years. I didn't make it 43 years old. Not being in jail, not to be harmless. I wouldn't be here.
You got any criminal convictions?
I told you I never. Nope. I told you that.
I got 100 clients. I don't remember what you told me.
Yeah,
5 years ago.
remember I told you like that.
Okay.
Yeah, I don't have no felony or misdemeanors, right? I have 12 months skills. I have a level 2 license.
You don't want to talk about that.
Yeah, but I mean, I understand that, but I mean, I'm a good citizen.
Yeah, but say, we do which ones we had guns and stuff. That would be a thing.
Everybody, this is Georgia. Everybody has
I don't.
You're
I'm not against them.
You're different. It's my right to have it, and I don't have one, especially for
I'm
my
not fighting.
staff.
See, that's what I want to do, is get combative.
No, I'm not doing that.
I wouldn't challenge it, so I don't have one.
I'm not that type of person. Anybody that knows me and whatever, I was nice enough for them to talk to me all the time. I want to be in charge.
That's good. You're trying to justify. I don't want to get into all that.
For my technical, I said that you want to do that. Try to play a role.
There should be one in yours.
So just so come and say, so like 10th, this report came out. When did y'all meet? I think the meeting was on the 11th. And I have heard talking about this since the meeting. And did you attend? Yes. And I was told not to come. But me and Tia came together. And so I heard you going to think about Randy or anything.
He also learned that condo docs. Certification. It's never that unexpected.
They lied. She's lied. Because you did it. That's even an offensive word.
Yeah, I don't do that. So you guys need.
If it says he got committed to perjury, that's fine. It's just to say he lied.
Saying that they didn't do the conduct, but it's never got the case inspected. Or take the road.
Because the evidence is. So after they did the work, 2019, the water released stuff, like there was still water coming out of the fence, went down it, and then the water come off the roof.
Every time it rains.
Did you ever, listen, we put that in the report, did you ever say something about needed to clean?
All the time.
So you reported the problem.
Many times, like I even had that, very separate, of course, I got now fixing you because the water got on.
Don't say, well, so you're trying to justify, that's great. Let's talk about the roof. So you go in the portal and have to go to Mike Tolley. How many times do you think you've reported the roof?
It got done 3 times. I reported the roof about 15 times.
15 times. I mean,
Work orders.
that's since 2009.
That's since 2018, about 15 times.
Well, did they do that even before they put their extensions on?
Yep.
Yeah, the date.
I'll give you the lease right now. They did an original account. Sean,
Pictures of the bills, a few questions. I'm gonna let you talk. Kids coming, also, I was concerned, electrical wires, stuff, for example, even though we had the signature problem, but that was some concerns. That's the arrangement, let them do that.
Right.
And I said, well, the concerned, you know, here we go again.
Yes. Every time.
It's been like since 2009, 2013, after we did the work.
I never.
He said, no, like the sheriff part, I said, but I want to come on the fence like that.
No, I think it actually made it. I feel like it made it worse because I feel like it just never stopped. So,
Couldn't tell. We talked about your deposition. Problem.
yeah.
And I'll get a contact them before. We found lots of short. Once they did the work.
And also COVID, you know, a lot of things were shut down. We didn't really know what was going on.
trees touching, there's 131, 21, 23. This one. 131, 223. And it's not in, I didn't even do this one. If you think you're doing it, I don't need that.
Water on them.
You probably didn't know I had code reporting experience.
I can tell by your demeanor, your sharp wit, it just goes on.
My father was a judge in this court.
Did they send you the meeting code for this morning? Because I don't have the new one.
I worked.
I was expecting after the conversation with the lady that she would have sent it to you, but she never did.
One summons a criminal.
To get into Zoom so we can display the
And,
yeah.
In the.
Well, they've been going into it, maybe they got it.
Yeah, it's all I was asking.
The defendant was convicted.
Passcode and stuff. I'll talk to some of the other guys, see if they got it.
File a motion for new trial. My father's court reporter quit without notice. Just didn't show up one day. She had some personal issues.
You got it.
I got it.
She was a short end. But she had the old dictaphone bells. You're old enough to remember those black bells. So everything was recorded. We went to her office. She did fake
A large amount of
squiggle.
719.
So there's no
799.
just those
The first one was
recorded there.
2009.
Father said,
July 9, 2020.
I'm not gonna have to grant a new
That's the
trial
first one.
because I can't produce a transcript.
There's more before that.
You watch this trial, you take those bells and prepare a transcript. This was in the manual typewriter. 7 carbon.
We got to sort out.
About 3 days. It took me about 2 months.
Yeah.
But I would prepare a few
Like real
pages.
short.
I was just
My
wondering.
following things. One of the lawyers was a little Bantam rooster, and he yelled and shouted. The district attorney was a Jewish fellow with a list. My father's always having to bang the drum or quiet them down. So. But we did.
That's me. Sorry about that.
Transcript, motion for new trial tonight.
We're good. Yeah.
I thought it was the same as yesterday because it let me log in, but then I realized I was the only person.
Well, you have to prove it.
That's a candy, man. It's classic.
Yes, I'm looking.
Because somebody had knocked.
Sure, of course, yeah.
But he'd sit up there with his coffee.
Of course, yeah. Sipping away.
Perks to be in the judge.
I guess so.
I can do that.
That was sure blind dog. I answered the counter call. Other lawyers, a young lady, didn't work out. She said, how long did the case take? Other lawyer said, about a day and a half, Judge. He said, you ever tried a case of Mr. Pie before?
It's like the tires.
He said, no, sir. He said, I put it down for 4 days.
Yeah. He's quite thorough.
For better or worse, he did.
Yeah. That's pretty funny though. He said about a day and a half.
A jury case. A day and a half, come
That's
on.
insane.
It was young.
I mean, good grief, just thinking about the amount of cross-examinations that have to happen and whatever, all the time adds up fast. It's tough to judge the amount of time sometimes too.
You
So,
know me.
yeah,
Had plenty, when the jury's out deliberating, I've had questions come out,
sure.
but never.
The handwritten cards. I've never seen that
And, you
either.
know, really, I guess that's a good way to get information also. That's the way to do it.
Mr. Alston, can you get us on the record, please?
And we're back on the record at 1:16 p.m.
All right. How are we doing with jurors? Missing one, good. Okay. Mr. Stewart, did you have a chance to speak with Mr. Dorsey and Mr. McLeod about attorney's fees?
Yes, Your Honor, I did that. In addition, I found the case for you for overboard.
Well, it was a very productive lunch break for you.
It was.
Why don't you give me that case first, please?
All right, it's Overthorpe Power Corp versus Forster, FORISTER, 332 Georgia Ave, 693, 774 Southeast Second, 755.
Okay, that's the case I found. And I think it has some good information for you on your expert, but it also gets into the family.
On page 709, and I can read part if you want to. So therefore, the jury are left to say what their judgment for the plaintiff ought to be in money and what the defendant ought to pay in view of this conflict of noise which the plaintiff and his family has been subject to the nuisance. And the cite to the.
Well, I'll read it now that it turns out I found the right one. I'll read that and see what it cites to. That'll start me on my journey in learning about that.
Thank you, Your Honor.
Tell me, have we, in your mind, resolved the attorney's fee situation, or do I need to get some things on the record?
Well, they can go what they plan. Well, the one case they cited, they gave to me, I don't know, they want to present it first. I can tell you what the case says. So I don't think
Okay,
it-
well, let's start with Mr. Dorsey.
Ms. Wilson's gonna argue.
Ms. Wilson.
I'll actually be arguing the motion. The case I'll direct you to is Nichols v. Main Street Homes Incorporated. The site is 244 Georgia Ave, 591. And in that case, the property owners sued the developer for damages resulting from the water runoff issue. The case makes it very clear that in terms of attorney's fees and damages, you need to bifurcate the trial as to that issue of damages. So first, the jury would have to be sent back without hearing any evidence to decide whether they want to award attorney's fees at all during their deliberations. And only after they come back with that, that's when they would hear evidence going to fees and the reasonableness of the fee. That case also makes it clear that plaintiffs testify as to what the fees are, the fees arrangement, all of that. Plaintiff's counsel testifies as to whether the fee itself is reasonable. And that's based off of, I guess, comparable fee arrangements and all of that. So
What does Nichols say about why you do this? It says what it says. I'm not doubting you, and I will look at it while we work through our next witness. But I know you bifurcate punitive damages. There has to be a threshold finding that the jury even wants to go there, because the type of evidence you can introduce during the punitive phase is very different. But if the jury decides that there ought to be attorney's fees, why do we have to drag them back in to then give them that info? Because unlike with punitives, where one thing they could hear is how much money the homeowners association has, and it's a bunch of millionaires. And so jurors could start to think, we're not going to give punitives, but we're going to really stick it to them for damages because we know how much money they're worldly worth. Attorney's fees, they're awarding them or they're not, and they are $83,000 or they're not.
yes, Your Honor, and the issue in this case is similar to punitives. In Nichols, it was about the bad faith element and whether there was sufficient evidence to support bad faith.
Okay.
So it's very similar to how you would bifurcate a trial with punitives in that way.
Okay.
And that's how they came to that reasoning.
Okay. Thank you. Mr. McLeod, anything you want to add?
No, Your Honor, I'm in agreement with all of that. I think that makes sense.
So the argument isn't, as I heard it, that attorney's fees aren't an element of damages here. It's just that we would handle them separately. A jury would first say, yes, we think attorney's fees are appropriate because there was bad faith or whatever it is they need to find. And then again, I'll read Nichols. For some reason, only later do we get into the reasonableness of the fees and the amount of the fees.
That's how I think it should go as well.
Okay.
I just think hitting the jury with big numbers of attorney fees could have some effects on deliberations that maybe they can cloud their deliberations as to liability. But
okay,
I'm not an expert on that, Your Honor, so I'll defer to you. But whenever I've been involved in it, it's always been the presentation of attorney's fees, the amounts is done at the end. Yeah.
The end meaning first a jury determined that there was liability for attorney's fees.
Yes.
Okay. All right, Mr. Stewart.
Well, yeah, I think you read Nichols, will make it clear. Respectfully, it doesn't say what they said it says. In Nichols' case, the judge ruled, I'm not going to allow you to introduce attorney's fees. I'm going to make a bifurcated. And he said, well, but we'll have yes or no attorney's fees. And he said, okay, now let me introduce how I got to there. And the judge wouldn't allow him to say reasonableness and all that. But the jury still awarded attorney's fees and damages with the Court of Appeals. And the Court of Appeals said, well, you have to have reasonableness, so we're going to send it back and redo the issue just attorney's fees because there wasn't enough evidence to support that. In fact, the judge bifurcated. That was never addressed in the case. It's something the judge chose to do. But as you stated, and I've done this dozens of times and testified as attorney's fees dozens of times, burden of proof is beyond preponderance of evidence for attorney's fees and the nuisance. It's all the damages that come from the damage claim. And it's common where I get on the stand and say why is the reason how much they are, and it's awarded. And the jury verdict form says, do you want to award punitive damage, yes or no? Not attorney's fees. Well, here the court did that. They didn't comment one way or they thought that was proper or not, or that had to be done.
All right. Well, again, I'll read the case, and it may well be that one could rely on the case to say it's not improper to do it. It would be atypical for me. I've never done it that way before. So I've either been wrong every time and no one's objected before, which is surprising because lawyers aren't shy about objecting, or Nichols merely authorizes that approach. But I'll read it and I will give Ms. Wilson the last word, unless there was more you had to say about attorneys.
The case is very good because it talks about the standard and it's 13.611, how that applies. what the plans put, and how a contingency fee like we have here plays out, and that's allowed to, and the plaintiff himself, the attorney can testify, all that's in that case.
Okay, well, sounds like it's going to be helpful one way or the other. Yes, ma'am.
And I'll agree with Mr. Stewart. It is a good case. While the issues on appeal might not have been specifically dealing with the whole procedural aspect, the court is very clear in laying out the procedure that should have been taken at the trial court level, and how the actions taken at trial were in compliance or not in compliance with those procedures.
Got it. I will read Nichols, and please, Mr. Stewart, don't call yourself until I rule on that, but I will rule at the next break, so folks won't be left hanging. I'll resolve it between now and our afternoon break. Yes, sir.
Just, I didn't know if you were about to call the jury back in. I've got the original deposition transcripts. I'd like to go ahead and give your honor, just so we don't end up in a song and dance again.
So would that include Mr. Smith's?
No, we didn't.
You have original deposition transcripts of whom?
We have, it will be Ian Silverstone, Water's Edge Group 30V6, and Tia and Chris Ibezims.
Okay. Why don't you put them on the exhibit desk area so that you all can get at them? I'm not into the ceremony of me unsealing them or anything like that.
I wasn't sure.
Yeah, you can open them any way you want. And frankly, you're welcome to use a copy. I think the days of the original sealed depositions are soon to be a thing of the past, but
And while I'm up here, just, I know your honor's already made a decision and read the law. We did have a trial brief on those spots issues, so I just like to file that with the court.
great. Thank you.
Did I get a copy of the trial?
I would like to get the jurors in here and have us move forward with our next witness. I will get on the record my thoughts about spots, but you don't need that to handle the next witness. So, Mr. Stewart, do you have anything else before we bring the jurors in?
No, yeah.
Okay, Mr. McLeod?
No, Your Honor.
All right, Mr. Dorsey,
No, your honor.
let's bring him in, please.
Yeah. Went through there for a while.
All right, adjourned.
I'm gonna say this.
Thank you, Deputy Gordon. Everyone can be seated. Welcome back, jurors. What was today's popular lunch spot?
Korean.
Publix. What was it? Blossom?
Yeah, tree
Where's-
blossom,
Where's that?
north, right by the Georgia State University building.
What kind of food?
Korean.
Oh, this is what you, so someone said Korean. Interesting. I'll have to, usually the jurors like, there's this American deli. And then after one day of American deli, we lose 2 jurors and no one else comes back. So, I'm glad that there's other options that you can get to and get back in time. So thank you for being exploratory. Mr. Stewart, still your presentation. Who is your next witness?
Your Honor, I'll call Jan Silverstone to the stand.
Mr. Silverstone, come up, please. If it's just water.
Raise your hand. Do you swear affirm that the testimony you will be able to the truth, the whole truth, and nothing but the truth will help you?
I affirm.
So you have a seat. Say this spell your name for the record.
State your name for the record.
Oh, I'm sorry, Ian Silverstone,
Can you spell your last name, please?
Silverstone.
We're going to move fast. We had you got this before. I was going to make sure. You're the CEO and Chief Executive Officer for Waters Edge Group and WEG, is that correct?
WEG being Mill Creek?
WEG, Mill Creek Lakes.
Yes, effectively. Well, I was, I'm no longer working.
Time of this plant about there's town hall and the plants, everything, you were CEO of both those companies.
Correct.
Waters Edge Group built the townhomes, WEG owned, purchased the lots, 54 lots we heard about. They, for the purchase of the lots, with the closing. Correct?
Yes,
And that closing, you attended, your attorney was there, Mr. Stevenson was there, and there were 2 children.
correct.
That took place on March 9th, 2018, that sounds about right.
Correct.
Chris Knight was your project manager during the construction of what's called, they call them building 30. Is that
Right, correct.
Director Schwarkweiler, I think he's right here, he's a partner of yours in those companies, but he's also the president of Waters Group.
Yes,
He kind of oversaw the construction, but you were kind of the supervisor, the financial manager.
yes,
And so the 55 homes y'all bought from Geo Sam, and they were foreclosure or bankruptcy, I know went through, first went through the Wells Fargo and all that, but you bought them from Geo Sam, correct?
correct. I don't believe it was 55. I think we bought 44 homes.
So 44, the 174 units, you had testimony of 120, you had 54 more, you think one had 40?
I think there was one of the previous owners might have had a builder do some units in there. I'm not sure.
All right, what year did you buy, or did, what is it? Lots.
The first lots, the first set of lots takedown,
What did you buy building 30?
2017.
When something was built, you began selling units later in that year, first of next year.
Correct.
Since bought theirs in March of 2008. Is that correct?
Yes,
Everything went fine at closing, no complications at all.
no
And
complications.
that's the time we got the 210 warranty. That's part of closing.
Correct. They also received it at the, when they signed the contract to purchase the home.
Yeah, the 210 warranty before that closed.
Yeah. You know, they should get the 210 and the covenants.
Mr. Silverstone, I need you to move a little closer to the microphone.
Sure, sorry.
That's okay. You're soft-spoken, and I just want to make sure everyone can hear you. Thank you.
The 210 warranty basically is something that Waters Edge buys, gives it to the homeowner as part of the package, you know. It's an independent company, you don't have to go office there, you have nothing to do with it, but it's a 210 warranty.
Well, we do.
The builders in Georgia are required to provide a 1-year warranty. The 210 extends that. So we work with them for the first year. And then if there are any additional issues like pipe bursting, we would have to take care of that in the second year.
Okay. But as far as the 210 company, are you on the board or officer?
No, we buy it from them.
Private company buy it.
Correct.
Does the state require you to buy it from the same part of the building company?
No, it's not a state requirement at all.
You get a warranty.
It's extra protection for the buyer so that if the foundation fails in year 3 or something like that, they can claim against the builder warranty.
But the closing documents and the warranty itself both have restrictions, what applies and doesn't apply.
Correct.
It also requires that you cannot sue for any reason, you must go to arbitration to have a dispute.
Yes.
All right, so before this house, while they're being built, what's going on? You had to get permits from Gwinnett County to build these townhomes,
Correct.
and that included responsibility for pouring the concrete for the slabs and things like that.
Yes.
Now, when you bought these, building 30 and this other, probably some other one like 31, things like that, you already heard plumbing pipes are in, the other PVC pipes, so the electrical things like that stuff. And you graded the tops for the pad ready, they call it. You already had all the ground.
Correct.
That was just ground though, it wasn't concrete you bought it, right?
Wasn't concrete, it's ground, maybe a bit of grass or shrubbery there.
Right. So when it's been sitting for how many years from the time it was foreclosed on to the time you began working on it, 2017?
I'm not really sure, but I think in the terms of the timeline that I saw, it happened 2006, so they would have been sitting from 2006 through 2017, 2015 when we started.
So this lot sat empty for 10 years or so, and things were growing up on it, different stuff. So did you have to have your workers before you pour the concrete, grade the slab where the concrete's going to go, and grade the swell in the back, grade where the patio in the back's going to go, grade where the driveway's going to go?
I think that Mr. Shankwyler should answer it. I'm not qualified to say that, exactly how that works.
Stop for a second. That's okay. 2 things. One, make sure he's done answering before you go to your next. When you say you're not qualified, Mr. Silverstone, meaning you don't know the answer because your connection to it wasn't, these are not my words, you weren't ground level seeing what they were doing. Is that what you mean by not qualified?
Yeah,
okay.
I wasn't there. I didn't participate. I didn't supervise anything to do with the construction.
Got it.
However, but you do understand that groundwork had to be done before you could pour the concrete slab, because the lots had grown up on those lots. You'd been out there, you knew that there was stuff had grown up.
Yes, you had to pour the slab. The extent of the specific extent of the work, I'm not familiar with.
You did understand that the drainage system was already installed, but the Water's Edge group had to make sure that the displacement of the water was working properly, was tied into the water runoff system in order to get the certificate of occupancy from the county, CL.
Yes.
So you couldn't just say, well, we didn't own it, the common area is not ours. Your responsibility was to prepare the backyard where the patios were poured, your company poured the patios, and you also had to prepare that swell so the drainage system worked. That was the responsibility of your company, Waters.
Yes.
Right, and so that was done, not because you're being nice, you want to be helpful, just to put that swell in. The plans required it, and the county will not give a CO or certificate of occupancy without that being done.
Correct, but the swale was already there. We did not do the swale.
Right, been there for 10 years, but you said the things were growing in, and you had to go out and refix it, regrade it, and do all that.
Your question was about the pad, not the swale, sir.
Okay, so you don't know. You know you had to do some work, regrade, put this pad in, but you don't know if you had to do any work to put the patios in the back. It's right there together.
I don't know what we had to do on the patios, no.
Okay.
Or the swale.
the water edge group actually on the flat yard of the backyard patio for responsibility for grading, preparing for and the concrete. So tell me what your understanding is as far as where does the land you own end, as far as the water edge group on the patio area and the driveway area? Was that the common area?
This is a condominium, so as far as I understand condominiums, you own the condominium common property is underneath the house and the exterior of the homes that we built. So what we did is we bought basically the rights to build on that particular pad as per the plat. And that's exactly what we did.
So does that mean, just because you're using terms with which I'm not familiar, if I step outside my back door and I'm now on a patio or a backyard, that's not what you bought because there's no house built there?
Correct.
The four corners, if it's a square house or a rectangular house, the four corners and within and whatever goes up, you bought the ability to build that thing that went up.
Right. And
that's what you're selling.
Yes. And GeoSam gives us permission to build the patio. And well, obviously we have to do the driveway. That's a county requirement.
Okay.
Like you said, they give you permission. You're the only builder that worked on their lot, correct?
Yes.
And when they built it, you had to put that driveway in, you had to put the patio in, or you never do that stiff architecture, correct?
The patio is not necessary in some subdivisions. It was part of the product that we discussed and what the house would look like that we would have discussed with the city, with GeoSam, and with the homeowners association.
I thought for a second, you just said that the drain system had already been installed, but water district had to make sure the displacement of the water was working properly, was tied into the water runoff system in order for state occupancy to be issued.
Correct.
And so therefore, for that drain system, that's behind the patio and all that.
Correct.
Swell area we're talking about, you had to do that. They would not give you a CO without fixing that swell.
I don't know if we had to fix the swell.
Well, you had to fix the drainage where the drains work, right?
The requirement during the land development phase, which is the initial phase that was done by Portrait Homes, they get an engineer, a land developer. I don't know how they did it, okay, but basically they go through all of the engineering with the city and they approve a plan that's got grading on it, what the levels will be, how the runoff will work, etc. And that's signed off by people like Dr. Spots yesterday in for the hydrology work, civil engineers for the grading, etc., etc. So there's a whole sign-off process before they can touch the lot. Then they go out and they get graders and they put all the utilities in, stormwater drains, etc. And they grade the lots so that everything flows into the drainage systems. And that's when we come in and we take we build on a pad. And, you know, you have to dig a little bit to put the foundation in. We backfill that and we make sure that the slope is per whatever the code is. So it's 1 foot in 1/8. 1/8 of an inch in 1 foot is the minimum that slope can be.
You basically took the common areas as you found them.
Correct.
Because you're purchasing the rectangle or square that the townhome is going up on, or the series of townhomes. And as I'm understanding your testimony, Portrait Homes or Wells Fargo, whoever the original purchaser is, in order to turn that into developable property, they had to do all those things you described, the grading, putting in the drainage, et cetera.
Et cetera, yes.
Okay, that was done 10 years earlier, set after 10 years, get your step go. When things are grown up in the backyard, the front yard with the bad drops gonna go, you had to fix all that. County was not gonna give you a stiff action with it. It's fixed and ready to move in, and the drainage system was properly working, correct?
Correct. I mean, as long as we have the positive slope into the grade and the inspector determines that is adequate, we'll get the CO.
And you did that. Association had nothing to do with it,
The association isn't part of that.
and the management company had nothing to do with that. That was solely Ward's Edge Group was a builder with WEG being on.
Correct.
All right. And you had control over, but you don't have 3 or 4 or 5 employees out there. And you had subcontractors under your control built the townhome.
Correct.
We already established building 30 had 6 units. Is that correct?
Building 6,
I'm sorry, building 30 had 6 units. Is that correct?
36 units, yes.
Right. He went to close on March 9, 2018. Our discussion all was there. We gave him a warranty, things of that nature. And then sometime later, you heard complaints that they're being flooded out, correct?
Correct.
When did you first hear about the fence? Was that after you heard about flooding or the fence first?
No, I heard about the fence when in a project management meeting. So that would have been end of July or August.
I think this was built in July, approved in May 2018, put in July 2018.
Correct.
About when did you hear about it?
As I said, end of July,
Now, you heard about
beginning August.
in July, you know.
Yeah,
You were told about it, but Warren's Edge Group or you yourself had no control or authority to tell the association or the management company what to do or not do about building.
correct.
We heard things about the contract didn't allow, that's their own contract. That's not a contract with you, is it?
No,
All right, so if they decide they want to go against or change their contract, say, well, we're going to have to build this fence because we think it can be, that's their decision. Either violate or change the covenants. You have no input control whether they did that.
we have no control of it. If they'd asked us, we would have said no.
If they actually said no, they still build it, you couldn't do anything about it.
No,
All right. So you heard complaints that water was actually getting inside the unit. You sent out Chris Knight, your project manager, and Trevor went out there as well. Is that right?
we sent out Trevor. Trevor went out to look at it.
And what result as part of his visit? Did they do some repairs within the unit?
Well, over a period of time, yes, there was water damage. When you get water damage, you have to take out the baseboards, the carpets, etc., let everything dry down, redo the drywall, figure out what the reason for the leak. We did find an issue in the foundation between the upstream unit and our unit. I mean, let's say the size of a fist, maybe. We filled that with hydraulic cement to prevent that from happening. We regraded everything. The buyer would not let us touch the fence. We asked him to cut the fence up to 3 inches or 5 inches.
You talk about work inside.
So you don't get to interrupt them?
That's different.
Do you mind talking about the fence in a minute, or was that?
Sure,
part
I'm
of
happy
the-
to talk.
I don't want you
I'm
to
sorry, I
change
didn't, that was his question to me.
You didn't do anything
is what I
wrong?
heard.
I think Mr. Stewart wants to break it into some pieces.
Okay,
So if you're all right with that,
Sure.
generally you get to give your answers and you don't get interrupted by the lawyer.
okay,
I
thanks.
apologize to interrupt you.
No
Right
problem.
now, from inside the house. You went out there, or Mr. Trevor did for your company, or that group. This is August or September 2018, about 6 months after they bought the house, correct?
Yeah, well, yeah, whatever March to July is.
Well, we got some photographs that were taken on August 15th. Baseboards were taken out, so about August 15th, 2018, from the
Correct.
work was done. All right, so they replaced the baseboard. Did they replace the sheet rock?
I'm not exactly sure. I mean, the sheetrock may have dried fine, and so they just said maybe I had to scrape it, repaint it.
What was your involvement? I know you're not doing the work. Were you having contacts with the plaintiffs that time, talking back and forth about the house?
I believe I started communicating with them around the time that, well, that's the reason I started communicating with them, was because of that meeting that we had in July or early August.
Had a meeting with two in July.
with our staff. Trevor, our project management team.
Okay, you had gone, but they were at three.
Yes, which is when I found out what the issues were. And because the client was a difficult client, before we take that further, we try and work with them.
Okay, we'll get to that too. So you go out there, you place the baseboard, do the work inside the house, you find a hole that's about 2 or 3 inches, and you held your hand up that had a big plug, you plug that hole, correct?
Well, in reverse order, but yes.
Okay, you plug the hole, then you place the board baseboard. And that hole was getting water from the neighbor's slab going under the fence and then going into that hole that was there that you described.
I don't think that's true.
What do you think happened?
I think that was seeping in through the foundation because the slope that we had created had been taken away. So the water was now able to seep into that hole that you saw in the pictures, because that was, prior to that, it had a proper grade above the foundation. At that point, it had been all pulled out by the water in the fence and etc. So I think that because there was a lot of water in the fence, when you build a house, you have the foundation, the house sitting on top of it. The reason you need the positive slope is so that the water doesn't seep in between the wall and the foundation.
Right, so the patio back there is supposed to have a slope 1 inch for every 10 feet roughly. That's your understanding?
I don't know what the regulation for patio is.
There's supposed to be a slope away from the house going down.
Yes.
Did it not have that at the time the whole water was going into the house?
No, there was a hole there.
There was a hole in the wall, but the water was coming the wrong direction. It's supposed to go away from the house, but it's coming into the house.
Correct.
So did y'all regrade the back patio?
We regraded the back patio. And
Patio itself.
no, not the patio. I'm sorry. We re-established the grading that we had when we sold the house back in March.
All right, let me talk about it. So the patio's there, and you're talking about the area to the right. You're standing at the back door, the grass area within the fence in that area.
I'm not familiar exactly how the grade looks, so.
Do you have any knowledge about the water coming in from the corner right side next to the neighbor? The water's coming through that fence area.
Yeah, because it's I have some knowledge, yes.
Right, so what do you know about that?
That the fence diverted the water into the Ibezims house.
Okay. And so you did that as part of when Waters Edge sold the house. That was a defect that they discovered 6 months later, and you came back and agreed to fix
it. It wasn't a defect. It was an issue of that the circumstances of the fence, in our opinion, the fence had created erosion that took away the positive slope. So that wouldn't be a defect, that would be maybe a maintenance issue, which is on the homeowner to correct, not in fact.
What about the 3-inch hole that's in the wall that's, put it ground in and fix that hole? That's a defect that exists in closing, correct?
That was a defect. We probably wouldn't know about it to this day because it really wouldn't have done anything unless you remove the grading.
All right, about that same time, this is August, so the fence had been in for a month or two. You put in a check dam about 20 rocks out in the middle of the swell. What made you do that?
Well, the Ibezims were complaining about the water coming into their house, and the water was coming into their house. So they also refused to cut their fence and refused to cooperate with us in any way whatsoever. So when we regraded that slope, we put the rock dam in to slow the water down and verified with a scope that there was positive slope into the drains.
Right, when you regraded, you're talking about regrading the land inside the fence there? You're talking about
No,
the slope itself?
we're talking about redoing the slope from the Ibezims home as it should be when we had it in March of, when the house was delivered to them in March.
It's your opinion that when they put that fence about 10 feet away from the wall there, they went and regraded the slope and make it go the other direction?
They created a situation where they were eroding the in the fence itself. They created a situation that was eroding the soil in there.
When you put the rocks in, did you do anything? The rocks are put in swell, right? To come in there.
Correct.
Did you get permission from the association or anyone else to go and do work in the
At that point in time, the association was saying it was our issue. They were refusing to cut down the trees, so there were branches. They just weren't maintaining the area, which is the reason, and we wrote a letter to them to remind them that they needed to do that. So we fixed it, we put pine straw down, ensured that the slope was positive by scoping it. And that was it.
Okay, Mr. Smith testified that he never knew the rocks that you're gonna put a check down in the middle of the swell.
We informed,
Wait till he's done with the question.
Sorry.
You never knew until you walked over, he saw the rocks within the swell area. Did you communicate all with the association, any of the 5 members or Mr. Smith, anyone else that you're going to do this for?
As I recall, we sent a letter to the association regarding everything we had done.
Had done. So after you did the work, then you told them what you
Yeah.
had done. And who actually built the rocks there? Is that Mr. Duckett, the landscaper?
I don't know who Mr. Duckett is.
Okay, who actually did the work to put in the rock there?
I don't know. Probably Trevor and our landscaper, which would have been Mickey Dutton.
Oh, Mickey Dutton. That's
Mickey.
okay. And we heard Dr. Spot says they say the rocks go the wrong way, it should be high in the middle, low on each side, things of that nature. Who actually evaluated to see that was good practice to put the check down like they did?
Trevor.
And Trevor does building things of that nature. And
Right.
was there a third party that came in and evaluated or gave recommendations? Just Trevor?
Well, the slope had already been established in the swale. All we did was the maintenance that needed to be done. I mean, it wasn't a big deal. It's just some pine straw, a couple of rocks, and then regrading or recovering the slope that should have been there from the Ibezims home.
And you have the pine straw all around the swell area.
Yeah, I believe so.
All right, and after that happened, the plaintiffs kept contacting and say, hey, we're still getting flooded out from the water coming down, things like that.
No.
They never told you there was still a problem. You said, don't contact us anymore. It's your fence unless you take.
I did tell them not to contact us. I told them how to submit a warranty claim. I also contacted the warranty company to come out and verify that we had done everything. At that point, we had completed the swale. We had some work to do inside the house. The only one I can remember had something to do with the kitchen, but there was about 5, 6 things if I recall correctly. And we sent them a copy of the report, the evaluation by the company, and what their options were if they disagreed. After that, we never heard from them.
Okay. When you did these things, were you coordinated this association? Or as the fence got to come down, we're not going to do anything more?
We wrote multiple emails. We told Mr. Ibezims what needed to be done. We did not initially say that the fence needed to be cut down. We asked that he take 3 or 5 inches from the bottom because it was sitting flush with the ground. And we felt that that might solve the problem in that the water would be able to flow through because he built the fence in the middle of the swale.
Did you talk to Ms. Smith who told you, no, the fence is not the problem at all?
I never spoke to Mr. Smith at all.
Never spoke to him at all.
No, the first I spoke to Mr. Smith was at our deposition about this.
4 or 5 things you just listed as far as the baseboard, filling the hole and putting the check down, all that check that. Where's that group did that work? You didn't turn that over to the warranty company, did you?
No, the warranty company came out, inspected it, but we'd done the work when by the time that came out.
And the reason Warranties Group did the work instead of saying go to the warranty company was because those were defects and repairs that need to be done. Because the problem existed at the time they closed on March 9th, 2018.
Is that a question?
Yes, is that true? You did the work instead of getting warranty because it was a defect that existed at the time of closing.
No, not at all. Okay, at the time of closing, there was a slope as required by the code. When we came in, that slope was not there anymore. The work that we did was to repair that slope and put it back to the way that it should be.
Okay, so you built the check down, Warranties that you about turn over the warranty, but then you said, okay, you need to do something with the fence, they wouldn't really do that. Actually said, go to the warranty because they wouldn't do what you wanted to do.
Well, yeah, we asked them to go to the warranty company because of the abuse of emails that we were receiving. We also asked Mrs. Ibezims to communicate with us versus Mr. Ibezims. And I don't want to repeat what Sean Smith said, but we had the same thing.
Okay. So you cut off Tia, did Tia ever say?
I did not cut off Tia at all. I asked her to communicate with us. She did not. Mr. Ibezims kept communicating with us. I informed him that I would no longer speak to him and that if he had a warranty complaint, he should go to our portal, put it in there. We would evaluate it and get back to them.
All right. So you did the work you were going to do. You say it's the fence is the problem. Now you're going to go to the warranty company. And you were totally out of the picture until you received the expert report from Elmino, is that correct?
We never received the expert report from Elmino. That was part of our discovery.
You didn't see the 3 reports at all?
No, not until discovery.
We heard that Douglas report was sent to you. Did you see that? Warranties?
No.
Warranties did not receive the Braves engineer report? Did not get that?
Not that I recall.
Did not receive Douglas' letter report about what needs to be done?
No, I don't believe so.
Elmino's report you never got in?
No.
So were you aware in 2019, April, they went out there and got this report, did work out there to try to fix the problem?
No, we were not.
So you've not heard about any of that?
No. We did hear from Quality Builders Warranty in May, I believe, that they were having an issue, and Quality Builders said that they were out of warranty on that particular issue.
What they said about what's wrong?
They said that they were out of warranty on the water issues that they were having.
Quality Builders the same as 210?
Yes.
210 is the type of warranty. Quality Builders
Quality
was
is
the
company.
issuer of the warranty?
Yes, correct.
You said that was May 2019, 1 year expired, so warranty time still not involved.
Correct.
And I think you said earlier, they have 1 year, and then the company gives a second.
The company, we're partially responsible for any water damage that occurs in the, well, we're responsible in the second year for any water damage that occurs in the house as a result of a pipe that bursts. But after, and that's the only responsibility we have. Quality Builder, you know, if something goes wrong, we'll take it from there. At the end of 1 year, any problems that are in the house, 99% of the time are found and resolved.
Right, so in April 2019, they started looking at these people, and they inquired, did essence things of that nature. So from the time you did your work in September, August 2018, to that time, did the problem get worse? Did they not maintain it?
I don't know. We never went out and looked at it until we received a lawsuit from you in whenever you sent it, late 2019.
In your opinion, that the association between September 2014 and April 2019 did not maintain the swell, which caused the swell to be filled with dirt.
I have no reference to, I don't know what the swale looked like or what it, except from those pictures.
Is that accurate what you testified to in your deposition, that during that 8 months somehow got filled with dirt?
That would be, if I said that, that would be based on the pictures. So the swale looked like it did in 2019.
So until lawsuit, you had no evaluation of El Nino or problems they said existed prior.
Correct.
Same with the other two experts they had, you had no opinion, information.
Correct. Okay.
Mr. McLeod,
Like I said,
just ask some questions.
I'm only answering 2 questions.
That's all you've paid for.
good afternoon, Mr. Chairman.
Good afternoon, Mr.
I'm going
McLeod.
to hand you a few exhibits. There's been a lot of testimony by emails going back and forth about notifications and complaints. And like I said, I think it's about time for the record. So
Okay.
I'm going to give these to you and ask if you can identify. These are D19, D20, D21. Sorry.
19 through 21?
19 through 21.
Okay, 21 says letters rather than emails. It's still communications, but do you agree that 21 is actually, it's a letter, not an email?
It's a letter.
Okay.
I think this has already been submitted in.
Well, it's not necessarily through you.
Okay.
Will you just take a second and see if you can authenticate those communications?
Okay. Yes, I recognize all of this.
Your Honor, I'd like to tender these into evidence. This is their objection.
Mr. Stewart, any objection to defendants 19, 20, and 21?
Oh, yeah.
Mr. Dorsey?
No objection.
All right, they're admitted. They can be published.
Okay, let's start with E19. Mr. Silverstone, would you please tell the jury what this communication is?
This is the result, I believe, of the QBW document that we received after they inspected the home to inform Mr. Ibezims that what we were going to do and that we were ready and willing to repair his home, and that if he disagreed with something, he could contact QBW and they would assess it as to the viability of the warranty.
So this email is dated September 9, 2018. This is pretty shortly after the fact, all the water issues came to light. Would you agree with that?
Correct.
Okay, and so he had sent you an email, and so you're saying, dear Mr. Ibezims, I'm writing follow-up to your email below concerning your home. We believe we've corrected all the issues. We are prepared to address all the warrantable issues at your home. In connection with the purchase, you received a warranty. You're telling Mr. Bisman that they have a warranty that they can pursue some of their claims under, correct?
Correct.
And then you specifically tell them if you disagree with our assessment and believe there are items subject to the limited warranty for which WEG is responsible, contact QVW, which is the warranty company, since that warranty has very specific complaint and claims procedure, right? You're trying to make him aware of the procedure.
Of what his options were, because in general, when we issue a warranty, we will stand up by any defect in the home. And it really doesn't matter how long the warranty lasts for. I mean, we've gone in after 3 years and replaced a person's kitchen sink. If it's something that we caused, we will correct it. So regardless of the warranty.
And so as we scroll down, and so I believe you testified earlier that you'd mentioned that you'd asked him not to contact you directly.
Correct.
Is this the communication you were referring to? You referenced that earlier.
I think this was the second time I did it.
The second time, okay.
Right.
So let's keep going down. Now, if you look up here, it says from Tia Ibezims. Was it uncommon or did Mr. Ibezims contact you from an email address that was named for Tia Ibezims, Mrs. Ibezims?
Correct.
Okay. And so when you received this communication below, your understanding was that it was from Mr. Ibezims as well?
Right.
And so let's look at that communication. So this is Mr. Ibezims emailing you. And so tell me about this email.
Well, you really want me to say something?
I do think it's important. I mean, we're early on in the dispute here.
This was the reason that we stopped communication with the.
Stop for one second. I don't understand what your question is. You're asking him to say, what do you think about this email?
Right. Well,
It says what it says.
okay. Well, okay. What was Mr. Ibezims demanding of you?
It was, I don't know if he was demanding anything. I have to read the whole email. Basically, he was telling us that he has a strong case to sue us for something.
Right. And so
No,
he
yeah,
was
for-
asking you for a settlement of the cost of his house, correct?
Right, correct.
And then he said he was going to file a complaint or a class action lawsuit, correct?
Correct.
And then he said he'd go to trial by jury, correct?
Yes, yeah, correct.
And then he was saying that was something that could have been a disaster for your company, correct?
Correct.
And so is that the communication? Is that one of the things that led you just to say, hey, I can't deal with?
Yeah, it was like there was a long series of these emails. I mean, initially we spoke. I found that I couldn't communicate with him because he always came back to something, that was threatening, angry, whatever. So I decided that I would write to him. Maybe that would work. That didn't work. So we basically told him to go to QBW, because that's one of the reasons we have a QBW warranty, is if we can't communicate with the customer, then they have specialists to do exactly that.
So you weren't ignoring Mr. Ibezims, correct?
No,
You were actually trying to resolve the problems that they were complaining about, correct?
correct.
But there is a procedure that you have to go
Now, let me
through.
object all these ladies' questions.
Is there a procedure that you have to go through to resolve all these issues they were complaining about?
In this kind of situation, yes. Well, in any situation.
No further questions about that.
And put the staple back in.
Just hold on to it.
Okay.
20.
20. Okay.
Okay, and was this another communication between you and Mr. Abizim or Mrs. Abizim?
Yes,
Okay, and I believe you also copied Mike Tolley and Sean Smith with the association and the Tolley Management Company on this email as well.
correct.
Okay, why were you sending this email to those parties and copying those parties?
I think that we were talking about the other warranty items at that time, that some of them hadn't been done. Like there was a TV cable that Mr. Ibizim wouldn't let us into the house to repair. We went out multiple times, that kind of thing.
So you were trying to resolve all of these issues.
But yeah, so we were trying to figure out what we can do.
And so in the third paragraph, you wrote, Mike, I see you were copied on this email. And you advised, were you directing this paragraph to Mike Tolley?
Correct. It must, the email below, I would imagine.
Okay. And so you were trying to advise everybody that y'all are completing all the grading work on the outside of this unit. And as far as we can tell, the drainage issues are due to fence installation. This is pretty clear from the video, including Mr. Abizim's email from that morning. So Mr. Abizim had sent you an email, a video.
Right.
Hopefully, the jury will get to see those videos sooner rather than later. I'm sure y'all are ready to see those. But again, is this where you also had your prior communication where you just said you were having trouble communicating with Mr. Abizim and that was an issue you were dealing with?
Yes, we said that in this email as
And
well.
at the very bottom, you then gave direct communication to Mr. Abizim that you were ready and able to correct any actual warrantable issues, correct?
Correct.
And then did you give them a procedure to make those warranty complaints so that they could be processed and resolved?
Yes.
No further questions about the 20? And then this is 21, it says 11, but it's 21. And I think we've seen this one before, but this is several days later, right? So this problem about the water issue lingered a little bit.
Yeah, it did.
Okay, and so why did you write this letter to Mike Collins?
Well, at this point, nobody had listened to us in terms of what we thought the problem was. I saw the Ibezims depositions. They weren't builders. They've never had anything to do with construction, yet they wouldn't work with us to help remedy the situation. I actually spoke to you about it and said that I'm going to write this letter to explain to the HOA that they need to start maintaining that area because they owned it. And we spoke about the fence and what our issues were with the fence.
So you were trying to make clear that you felt like you had maintained, maintained, not be the right word, but that you had done everything you were required to do, and that the association, anything that was left remains in the common areas for the association.
Correct.
No further questions about that. So after all of this happened, was there a warranty claim submitted by the business?
There was a warranty claim that I recall from in May that would have gone directly to QBW. They came to us and asked us, about it. And the recommendation was to do nothing because it was out of warranty. We went and looked. The fence was still in the exact same shape as it was. I don't know what we're supposed to do if we can't remedy the situation.
So you were asked to remedy the situation, correct?
Yeah.
Okay, and so did you take steps to remedy that situation?
Well, we did, but the homeowner wouldn't let us touch the fence and refused. His comment was always the fence is not the problem. is something to do with the swale, putting water down. But, as we heard yesterday from Dr. Spots, not the swale, the hill behind the house, that would have absorbed all the water, and most of the water was coming from the roof and, being washed down into the storm drain.
And so the plaintiffs actually filed warranty claims regarding the grading that was on the property, correct?
Correct.
And the warranty company denied those claims.
Correct.
And do you know if Mr. Ibezims went through the appeal procedure for warranties?
No, he did not.
So they rejected QBW's decision, correct?
Correct.
Okay. What effect, if any, did the building of the fence have on warranty?
Well, probably nothing. His behavior could have impacted the warranty, and we, gone to QBW and they had experienced the same behavior, they probably would have voided the warranty.
Thank you. No further questions.
Mr. Dorsey, do you have questions for Mr. Silverstone? Okay. Jurors, do you have questions for Mr. Silverstone? Oh, do you have any redirect? I didn't mean to cut that short, Mr. Stewart.
Oh, yeah, thank you.
Okay. Jurors, if you have any questions for Mr. Silverstone, now would be the time to jot them down. Sir. Not only do you all have different handwriting, you write in different size fonts. Some of you fit about 2 words per card, and other is about 800 words per card. Very interesting. All right, counsel, I'll see you around.
Really small. Start cutting magazine letters out. Get a little creepy for a judge to receive. Yeah. I feel like I'm not taking any notes. Got a few. Oh, yeah, that's all I got today. Can't remember what I had for breakfast this morning, so I need to write that.
You know, it's so weird. I remember like attributes extremely well. What people say, the rest of people's names, and I'm like, man, it should be easy, right?
Not that you want.
I've been watching, but you say you Atlanta?
I'm originally from Connecticut, but oh, okay, yes. My sister just lives outside of Hartford.
Okay.
Yeah.
She just actually, I just turned 94 January 24th. A couple of months ago.
Really not that much to do in Hartford.
She left Savannah, born and reared at 18, moved to New York, and never came back south. And then got married, and husband was in Hartford. So that's where.
Was he in the insurance industry? Yes.
How'd you guess?
A lot of times I guess, you know, do with a lot of people talk about insurance has to do with car.
He ended up, he's no longer with us, but he ended up being involved in state, actually local politics. And he, I guess one of the house members, Larson, John Larson, one of his friends there. I met him when I went down there years ago. So,
But I know what you mean.
she was in insurance business.
SDI. Yeah, that's super. Fourth grade, go to the, everyone goes to the Capitol for field trips. In traffic.
You enjoy this job?
Every now and then watch hockey games.
How long have you been doing
It's
it
changed a
for?
lot. I've wanted to. We spent one Christmas up in the Hartford area. That's the first time she was ever up there. And I feel
Are you typing like,
we need to go
you
spend a
type
few days
that
in
scribe
Boston
thing
just to get you
in that
before we go down there.
Yeah, Boston is really nice.
Yes.
I love Boston. Oh.
That's the first time ever there. Even though she's been all around. I wonder if she knows Boston. She really.
Oh, okay.
That's a neat place.
Yeah. If she knew Boston before
Okay,
she
you
started
correct any errors
she was
that goes through.
college.
Gotcha.
That would be a
Yeah.
really neat place to go to school.
Yes, my sister spent a semester at Boston College. I visited her a few times up there.
Plus, I don't know what.
When I got it,
Well, the name was in that, because I've always done school. I've always did Boston, all that
That's the
stuff.
Freedom Trail.
I started off with old school why it's called the Z bar.
And sort of spent a little bit of time living in Cambridge, Boston, which is the area of Harvard. And I always like to say, oh, I just went to school outside of Boston, little town Cambridge. And like, no, you would the Harvard Boston, something so pretentious.
Where it's like, it's not even a hydraulic.
You gotta use it.
Yes,
You
they drop the H wrong.
Drop it.
That was the same thing. It was a brand new car, and I was thinking, you know, V8, it's gonna have a little bit of heft to it. And it was just straight to the ground.
Didn't have a couple of something. Yes, I don't know how many, you know, it seems like we only get two.
Walk on the water.
Maybe we only get. maybe-
1 second. Silverstone, do you know what type of testing or evaluation local officials would do on graded land to determine that the water runoff management meets code?
Unfortunately, no.
It's not unfortunate, it's just not something you know. Okay.
Oh, I'd like to know as well
Okay.
at this point.
Today I'd like to know. Normally I don't,
Right.
I don't think I would, but today. Do you know how often a lot, and I don't mean just unit 5 of all of building 30, but the whole lot would be certified or licensed as being fit to build on when it changes hands? And let me put it into context. We had Portrait Homes, we had Wells Fargo, we had GeoSam, and ultimately your company bought some of that land. Does there need to be a new certificate of occupancy each time that property changes hand?
No. In new construction, what you have to build a unit, you have to submit the plans. And the final certificate, they come out and inspect your framing, your foundation, your electricity, pretty much everything. And the final certification is a certificate of occupancy, which means the erosion control guy has been out there, the electrical guy, etc.
So there needed to have been an erosion control guy blessing the plans that Portrait Homes would have put together and what they did.
And that we've created, sorry to interrupt, the slope.
But there's the initial one, but ultimately before you could sell one of the units you built, there is someone who's coming 10 years after Portrait Homes bought it and leveled it and did everything. There's someone coming effectively on the eve of attempt to sell, looking at that same swale slope and this and that, and signing off saying in 2018 or 2017, late 2017, early 2018, this grade meets code, this slope meets code.
Yeah, correct. I mean, the engineers are pretty good, that you're not going to get the slope change that much over a 10-year period.
But regardless of whether it changes over 10 years, it was eyeballed and signed off on by a county or city official, not 10 years earlier, but at the time you sought to market the homes.
Correct.
Okay. You said something about behavior voiding a warranty. Can you elaborate on that? What is it that you were thinking of when you were responding, saying, well, the warranty might have been voided? By the way, Mr. Ibezims was
because of the way of his emails, he was aggressive to all vendors that came to the unit. Some of the vendors refused to go to the unit unless Trevor was there or somebody was there to, I guess, protect them. And so that kind of thing, if we can't get into a unit, the homeowner won't let us cut the fence up, to see if that solves the problem, then there's not much we can do. And at that point, a quality builder could decide to void the 210 warranty.
You have shared your thoughts about the fence being a cause of some of the woes here because it trapped water and degraded the grade, if you will, caused erosion in the Ibezims' backyard. Is that a conclusion you reached because Water's Edge retained an expert, someone like Dr. Spots, to do measurements and whatnot, or it's something you saw? What's your basis for sharing with the jury that view?
We got various videos from Mr. Ibezims on what was going on there. Trevor went out and took a look at it. He's a builder, he understands those issues. And that was the conclusions that he came to. So we wanted to follow remedial measures. First thing is to allow the water to flow under the fence. I mean, had we discovered that the water didn't flow, or even let's say remove the fence and there was an issue, we would have fixed it. But we couldn't because the homeowner refused to work with us to fix the problem.
In one of the emails we saw, I believe it was one that you attributed to Mr. Ibezims, but it's under the name of Tia Ibezims. There was language to the effect of, Trevor told me to sell. Not your words, Mr. Ibezims' words. Is that a course of action you directed Trevor, Mr. Schonkweiler, to pursue, or was that any effort you made to get the Ibezims to sell their unit? There goes your headache is solved.
No, I think that Mr. Ibezims was trying to get us to buy the unit back so that he wouldn't have to bankrupt our company through lawsuits. And so I think Trevor was just responding to that.
Did either of the Ibezims ever share with you why they were unwilling to raise the fence, not the height of the fence, but to remove the 2 to 3 inches that you've described would be
No.
necessary? The answer was just no, not no because?
No, they never told us anything.
Okay. All right. Mr. Stewart, any follow-up?
No, Your Honor.
And Mr. McLeod?
No, Your Honor.
All right. Thank you, sir. You can step down.
Thank you. Appreciate it.
Mr. Stewart, your next witness. If you want to call yourself, I can make a ruling later, but I'm letting you call yourself, having read the Nichols case.
Thank you, Your Honor. I'll call myself as next witness.
All right.
All right.
Your Honor, for the record, we understand that counsel can testify about attorney's fees. We do not think the plaintiffs have made out a case sufficient to recover attorney's fees. Therefore, generally, we object to testimony on that subject.
Noted. And there are a variety of objections that have been made also outside the presence of the jury. Nothing's being waived. I'm tacitly ruling now, but I'll get my ruling on the record when the jury's not sitting in here.
Another exhibit.
Excuse me.
Retainer agreement.
So if you want to call a different witness right now, so we can keep moving, we can come back to you.
If you give me, now borrow one of your documents, Your Honor. I'm looking for exhibit 2.
Sure.
Three of them. I'm sorry, one, the very first one, very first. I got 2.
You have two, so you just need the one pager.
I think I just got it. I swear as a witness. I do. I do. This is a little unusual, but this way this is done in the sense that in stormwater runoff cases of this type, it's a nuisance case and we call it a continual nuisance. And under certain cases, you can seek attorney's fees, and that's what we're seeking, attorney's fees. But to introduce those attorney's fees, you have to prove, or at least carry the burden, provide evidence of how they are determined, why I charge that much thing. So the first thing I do is give my qualifications, things of that nature that qualifies for that. Well, when clients come to me to do stormwater runoff cases or raw sewage flooding, I've been doing that about 20 years. Back in 2001, a sweet grandma in my church had a flooding problem. We went to trial, got a good verdict. It went in the Atlanta Journal newspaper. And I've been getting lots of calls the last 20 years. So 75–80% of my practice the last 20 years has been stormwater runoff or nuisance flooding of this type. And so I've tried over 30–40 jury trials in the last 30 years. First 10 years, I was a defense attorney that defended cases like these or car wreck cases and slips and falls. And so that's kind of experience I've had. And I live in Gwinnett County in Lawrenceville. So within the community, I would charge, if they would pay me by the hour, $300 an hour. So my fee is now, and have to say that that's reasonable and I think below average for people my experience, whatever. But that's what the price would be. And so when client comes to me, I give them three options. One, give me a $10,000 retainer and I'll charge you $300 an hour, win or lose. And as the case goes on, if it drags on or it takes more time, then you have to pay along the way. And that way, you had to pay the money one way or the other. The other option, and I've got that for some clients fairly often that are business or commercial companies. But in this case, when you homeowners, a lot of times who are representing the stormwater type cases, things of that nature, I give them what's option, a contingency contract. And it's pretty much what you see on TV, whether about car wreck cases. You don't have to pay unless we win because we'll take a percentage of your winning. And I give them two options. The first option is whatever we recover, I get 1/3 of the money, which is pretty common in a lot of lawsuits. And and you have to pay the expenses that come due. Now, most cases, expenses come to $6,000 to $8,000 in a case like this, but in this case, it's on the bill I have here. It's only $1,900 before trial. This good court report's got to be paid. The computer expert's got to be paid. Dr. Spots will be paid. So there'll be some more fees coming this, but let's see if I got Dr. Spots here. But in this case, and I don't think I have them all because, like I say, Dr. Spots came out and he was asked a question, Mr. Stewart pay you, does his client pay you? If my client takes the option of 1/3, I advance the fees. Excuse me, my client pays the fees. But in this case, the sunken option is 40%. I'll get 40%, but I'll advance all the expenses. You don't have to put anything up. And if we lose, you don't have to pay me back. So I have all the risk, but I'm advancing all the expenses. So that's the two options. Probably about 60% of my clients choose the second option, 40%. 40% take the 1/3. In this case, Exhibit 1 is a copy of the retainer agreement. My clients, T and Chris, sign, and if they agreed 40%, and I advance the expenses. And the reason they're not all here, because I don't see where Dr. Spots was paid, but he was paid by me when he came out before. He hadn't been paid for trial yet. That's why he was asked the question, does Mr. Stewart pay you or does his client pay you? Well, sometimes the client pays, but sometimes I do pay. And so in a case like this, I advance the expenses. And then I have to submit and have Exhibit 2 as an itemized fee bill from the time my representation started. So the first time I ever talked and met with the Ibezims was August 19, 2019. And from that forward till the time of trial, and I just estimated 3 days at 10 hours a day, which is conservative. So we know it's gonna go more than 3 days, but to the date, the billable hours total up 278 hours, 0.3, $300 out would be $83,490. And the expenses today is $1,090.96. So those are the fees that if by law, if they had choose the first option, we're going to pay you by the hour. That's what the bill would have been to my clients at this time. But a contingency fee, that's not what's going to happen. But that is required by law that we tell you what it's worth. And that's pretty much my testimony.
Mr. McLeod, do you have any examination of Mr. Stewart on these issues?
Your Honor, would it be appropriate for us to reserve cross-examination regarding Mr. Stewart until a later time? Just wondering, I haven't really had a chance to look at his fee affidavit, the time entries, and really think about any of that. I'm happy to ask a couple of questions. I also have a couple of questions that I'm not sure would be appropriate, and I don't want to do anything to offend Your Honor.
You're not going to offend me, but you're not asking me questions. But let me ask Mr. Dorsey, what is your prep? Did you have questions for, because Exhibit 2, which is the fee bill with all the time entries, is not new. You've had it for a while. So to tell me, gosh, I need time to go over it, that time was baked into, let's get exhibits to everyone in advance. So I'm less interested in saying, I want to give you time to be more prepared, but I don't want you to get into areas that you think we ought to discuss outside the presence of the jury before you're comfortable getting into them. And so I heard two different things from you, Mr. McLeod. The latter, I'm inclined to say, all right, let's hold off on that. We can always get Mr. Stewart back on the stand. But let me hear from Mr. Dorsey.
Your Honor, this claim has not been presented against my clients at all, so we have no interest in the outcome of it, so we're not going to ask any questions.
Got it. All right. So this will solely be a McLeod Stewart situation.
We can move forward.
Okay. Do you want to ask any questions now?
Not at this time.
Okay. All right. Mr. Stewart, thank you. Are you tendering exhibits 1 and 2?
Yes, I'll tender them into evidence and I'll give you a back, Your Honor, because I found mine at the last minute.
All right. Any objection, Mr. McLeod, to the entry of plaintiffs 1 and 2?
No objection, Your Honor.
Okay. And no, Mr. Dorsey, this isn't an issue directly impacting your clients, but any objection to plaintiffs 1 and 2?
No objection.
All right. They're admitted. Mr. Stewart, your next witness, probably a client.
Exactly right, Your Honor. I'll call Chris Ibezims to the stand.
All right. Come on up, sir.
My name is Chris Ibezims. Good afternoon, Your Honor.
Good afternoon.
First of all, I apologize. We got some language, your name like this.
Yeah, it took me to 8th grade to learn it, so I'm not asking you to learn it in a couple of years you learn it. It's tongue twister.
So, just tell us, you like on that, or you're married to each other. How long have you been married?
17 years.
Where did you meet?
We met in New York.
And when did you move to Georgia?
About 2014, November of 2014.
You said you met something. When did you get married? How many years have you been married?
17 years. We got married the same year that we met.
Okay. And you have 2 children. What are their names and ages?
One is Chris and the other one is Kyle Ibezims. Kyle is 10, Chris is 15.
I have a person was on March 9th, 2018. So you disabled, not working at that time or what?
I was partially disabled, had a lot of health issues.
Have you recovered? Are you working now?
I went after COVID, I went back to work. I certified myself. I took a residency at the hospital. I got accepted to a residency, a surgical instrument technician residency at the hospital, Northside Hospital.
You work at Northside Hospital?
Yes, I do.
Your wife's a nurse?
My wife is a nurse in administration, administrator in the hospital.
Where does she work?
At Northside for Forsyth.
All right, let's go right up to it. You and your wife decided to move, moved to Georgia.
Yes.
What made you decide to look for a house in this continent?
We was looking around, started doing a lot of research. We just come down here to, because I had my health issues, to be honest. I had a health issue, so I came down here and wanted to better the weather, because New York was so cold. I don't know if I described this, but I have heart failure. I have the dysfunction. I have swelling in my legs, my limbs. My ejection fraction is low. Also was born with a heart defect, heart murmur.
So when you moved to Georgia, how long did you live in Georgia before you moved to March 9th, 2000?
I moved, we was here about 3 years. We was renting, trying to, it's called established residency.
So you lived in an apartment before you moved to the?
Yeah, we didn't live in a house. We lived in a house. We rented a house out before we moved to our brand new house.
All right, so the townhome you purchased, is this your wife purchased you? Was that the first home you had?
First house we ever bought. We haven't thought about buying. Yes, yes.
I'm gonna ask my wife a lot more questions about that, I guess. All right, so you buy this house.
Yes.
You move in. How does the house go?
First moved in, I mean, it was like a dream. It is a dream. We decided, we was happy. I couldn't believe we got a house. So I was like, oh, man, we got a house. And so I first moved in. I think it was like 1,700 square feet.
How many bedroom, bath?
It's 3 bedrooms, 2 bathrooms.
stories is it?
Stories, 2 stories.
Particularly why you picked this subdivision or?
I was driving around, just back then, it was more abundant to have those big signs, for sale signs. I don't see too much more in my area, so I was just driving around. And like you said earlier, it's behind the Mall of Georgia. So I was just driving around, we saw this big sign, that's right up our alley, 180,000 for a house and everything like that. So when I drove through there, I didn't see no houses. Then I just kept on driving with a dead end. So when I went down the dead end, I turned back around, came back, I seen the house. I seen the house I ended up buying. I said, oh man, there's a house here.
What attracted you to the house?
The location, the price at that time too.
The house was purchased for price thing.
Correct.
And what was the purchase price of the house?
219,000 plus tax.
What was the final amount after you had everything on?
About 235.
Now you moved in the house, you and your wife, you have 2 kids.
Yes.
And 2 dogs.
Yes.
What are your dogs?
Charlie Brown and Snoopy, the miniature schnauzers.
All right, so you move in the house, everything's fine. When did you first discover the water problem?
I would say a couple of weeks after we moved the house and moved into the house.
What happened then?
I just noticed a storm. When it stormed, because I'm home with the kids, when it stormed, I said, this rain and this water looks crazy. Looks like there's too much. Looks like I thought it was going to be flooded out. I thought the trees were going to come down. I thought the whole side of the mountain was going to slide into the house. I was very aware of like, this don't look right.
That was actually moved in before you ever put a fence in?
Excuse me?
That was before you built the fence?
Correct.
Come in evidence, off March, and May, you submit your application.
Yes.
To the fence. Your wife filled out the form.
Yes.
The house is actually in her name.
Yes.
Deed and everything in there.
Yes.
And why the 2 of you wanted the fence?
My kids, my son is still kind of a runner. My son has special needs, I think was aware. So I was worried about if I let him outside, he's gonna take off.
And had that been a concern before, the kids running off?
Yes, it happened before. My son ran off before, yes.
And so you and your wife both agreed on this fence, you went through the application process.
Yes.
Your wife put out the forms, nobody told you nothing good or bad?
No, we followed everything we're supposed to follow.
You and your wife hired Pennington Fence Company, the one that HO Association said they had to hire.
I had a little pushback with that because it was charging so much for the fence, and I knew it was their vendor. So I said, we got to pay for this fence. So we end up I asked them, do we have to? We said, yes, we have to go through their fencing company.
Okay, so you did use the same fence?
Yes.
All right, and yet after you moved in, you built a fence, so make the water runoff worse, things like that?
The fence didn't, it stopped the pine straw, it stopped the trees, it stopped the branches, it stopped a lot of the leaves, but it still will come underneath it. But it slowed down the leaves and the branches and the pine straw, it didn't slow down the water, no.
What about tap under the fence, 1 inch, 2 inch, 3 inch?
It was on the diagram, nobody brought the diagram, but we had to submit a diagram. We couldn't draw the diagram like you stated. It was done by Pennington Fence. And the diagram stated that it had to be 2 inches off the ground and have all these parameters so wide, so out far and everything. So the diagram looked like architectural diagram. It wasn't my diagram, it was Pennington Fence ground diagram that was submitted to the board.
And when it rained, it's gonna run off stuff, did it cause any problems with the fence?
When it rained, when the storm rolled up the fence didn't, in my view, the fence didn't cause any issue because what I saw before the fence was a lot. So I don't think the fence caused an issue at all. So I followed everything. I looked at the fence. When I saw the fence, when I built the fence, I thought it would protect me a little bit more. Even with the kids' situation, I thought the fence would give me a little more protection.
Right, so when you built the fence, so the 2 inch stay there, was that a problem maintaining?
It was very hard maintaining because everybody's saying with the slope. So on the slope, if you know the water's coming and it's lifting up the debris and the pond straw, it's also bringing the dirt. So constantly I'll have to go out there and shovel to make sure it was enough of a gap all the time. Because every time it rained, the water would run down and the mud would run down, the dirt would run down. So it looked like it was clogged up. It always looked like it's clogged up, but I always have to go out there and shovel before a storm and after a storm. So to make sure the water run out.
Did that, I think what I was saying, I guess, fixing things of that nature. What about water into the house? Did that happen?
Oh man, how did that happen?
When you start, what time frame?
The time frame and water in the house after I called Pest Band.
Who's Pest Band?
Pest Band is a contractor that worked with Water's Edge. Is an exterminator, and they had prefabricated the house with wires in the house. The wires go within the walls like little tubes. So if you had any extermination problem, they would press this fluid or press this extermination thing into that little hole they have. I have a little outlet, you push the hole, and inside those tubes have probably tiny little holes that if you had a termite or roach or something, whatever is in there, it would come out those holes.
All right, so you called them, they came out.
Mhm.
So that.
Okay, so the reason when they came out, they pumped the hole. They did the exterminator point. But I was still asking them about everything else, like where the termite station was and stuff like that. Okay.
We're asking about water coming to the house. Tell me how that relates to water in the house.
Okay, so after they came in the house and sprayed it, 2 days later, I started seeing a lot of browning on my baseboards. So yes, I have a couch in front of the baseboard. So when I went back there to the couch, I saw a lot of browning on the wall. So I said, wait a minute, Pest Band was just out here 2 days ago. What's going on? What's going on? So I called them. I was a little upset because now suddenly the brand new house, all my baseboard was all brown. All in the whole living room, baseboard was brown. So I said, look, what did you put in? What's in here? What's in the solution? Everything I asked them. They told me that this is standard practice. There's nothing wrong with what they did.
Okay. So what did you do?
So after asking them to come, now the manager got in contact with me. The area manager of.
Tell me what happened as far as water coming in.
Okay, Water's Edge came in after.
How did that happen?
How I get in contact? Because Pest Band contacted Water's Edge.
Who came to your house?
Trevor Shinoka, the vice president. Yes.
Okay. You and your wife both met there?
Yes.
All right. What did happen? What did he say? What did he do?
Okay, when he came in first, he did come with Chris Knight. He said Chris Knight wasn't there. Chris Knight was at that site with Trevor at my house. They came into my house. I let them in my house. Never had a problem with them. They came into my house. He saw the wall. He said, it's kind of strange. I said, yeah. I said, what's going on? He said, this is no lie. He said, I bet you $1 million there's no water inside that, behind that wall. I said, what you mean? Why you say that? He said, I know there's no water behind that wall. I said, I don't have that type of money, sir. I can't bet that. I can't cover that bet, but can we see what's going on? So as he was saying that, he said, these are special baseboards. I said, what do you mean by that? He said, these are special baseboards. These baseboards supposed to absorb the water and absorb everything that comes through this house. There's no way there could be water behind there. So I said, can you just go ahead and see what you can do?
What do you do as far as determine what's water or not?
He started pulling off the baseboards. He started yanking out each baseboard of around the whole bottom of in my living room behind the couch. He pulled off every baseboard.
Before he did that? Did there moisture testing before that?
No. After he pulled it off, he put on the moisture test there or what have you, whatever gadgets he had. And he said, yes, there's water here. He was quiet for like 2 minutes. He said, yes, there's water right here. There's water here.
Okay. And so there's water there. Who took photographs?
I took the photographs. Yes, I took photographs.
Well, we had him pull up, if you would.
So there's nothing in evidence yet, so let's not put anything on the screen.
Pretended plaintiff exhibit 12 and 13, the sheet rock and walls and that. The effect of that.
No objection.
Okay. 12 and 13, any objection to plaintiffs 12 and 13? They're admitted.
Thank you. So, here's 12, what is that showing?
That's showing probably the side behind my couch. I don't know if it's the corner or the other side, because it's a wide area that he ripped off. So I think that's behind my couch, directly behind my couch.
What kind of carpet is that?
It's a carpet they installed.
So was carpet marked when you first bought it?
Yes, yes.
So that's the baseboard, they pulled it off, that's what it looked like.
Yes.
What happened? Tell me about the water, what did you see or find out about?
Excuse me, maybe.
What kind of water did you find? Was it just a puddle, was it on the old floor, what happened?
At that time, you can't tell it's a puddle because the carpet is there. That's why we never noticed it from before. The carpet is there and the carpet absorbed the water. We don't go behind our couch frequently. So I didn't see it. So at that time, I'm pretty sure it was damp. The floor was damp and the carpet was there. So I couldn't tell, I couldn't see, but I could feel it with my feet.
Okay. So did the repair work? What all did they do?
They just did that. They left my baseboards out for like 2 months. It took them to fix that because he said it's special baseboards, so they ordered them. They didn't tell me when it's coming. A truck came, knocked on my door. A truck driver said, "I got some shipments for you." I said, "What are you talking about?" And it was baseboards. So I put the baseboards inside my garage and notified what is edge that the baseboards is at my house.
So they placed the baseboards, did they do anything with the carpet?
They didn't do anything with the carpet.
And was the water, was it a problem still?
Yes, it's still, yes,
Was there a smell problem?
yes.
Tell me about that.
The mildew is a problem. It is damp in my house, very damp.
And these photographs show that you buy these in August 2019.
Correct.
You took these photographs yourself. That's
Yes.
on your phone.
Yes,
So that's about 5 or 6 months after you moved in.
yes.
And after they did that, they replaced it. Was there any problems with the baseboard that they replaced them?
Yes, there's still a problem with the baseboards after we replaced them.
Problem today?
Yes.
What's the problem?
This same discoloration. Discoloration.
Replaced it, did you paint it?
I touch it up. I touch it up a lot. Not recently, but I still touch it up.
When it was first replaced, they put the new baseboard in. Our baseboard painted and the sheetrock painted.
The sheetrock wasn't painted, but the baseboard came one color. That's that color that it came in originally.
What color was that?
A little eggshell, probably not white, but like eggshell.
Okay. So last couple of years, it's little moisture or what?
Yeah, there's still moisture behind there.
Describe it to them.
Well, if you see that spot right there where they're supposed to, like Dr. Sparkle said, we're supposed to replace the sheetrock, but they didn't replace the sheetrock, so they didn't even paint it. That same corner still has brown and still comes out every, 30, 40 days or what have you.
How many times have you painted it over and over?
Probably like 5, 6 times.
All right, and you fixed that, replace the carpet, you did replace the carpet?
Yes.
But this was taken in August 2018, but you didn't replace the carpet until a year later.
Oh, no. You said 2000, this happened in 2000.
This picture is in August 2018, but you replaced the carpet, I think, 2020.
2020, yes. And there was a lot of things going on in 2020, as you well know. I don't want to say the COVID word, but as you know, my wife was a nurse administrator who worked in the hospital. She had gotten sick. So we didn't have too much money to replace stuff because she is the breadwinner. So we was on a tight budget. So I didn't replace it until we had enough money to replace the carpet.
Why did you replace the carpet? You fixed the problem, why did you do that?
Because it's still a problem.
As far as, what, The baseboard's there, and
Mhm.
it sweats a little bit, but it's not getting wetter.
What, the baseboards?
The carpet.
The carpet is, of course, it's getting wet. It's still moisture in the carpet. So I had to replace it because of the smell. I had to replace it because I don't think it was sanitary to leave that carpet there.
So you replace that with new carpet or what?
I replaced it with tile. I was advised to try to get what's called luxury vinyl tile because it can help with the moisture. Because as Dr. Spodek said yesterday, nobody puts carpet down on a floor back here, that especially on the floor adjacent to the patio or ground level floor. So this is a carpet. Once I noticed, I didn't see nobody else. I'm not gonna say I can't hearsay, but I don't know if I was the only person with a carpet, but I had a carpet.
All right, so replace the carpet. When they did the work with the baseboard, what type of work did they do outside of your property?
I didn't see them do any probably directly outside. No, I didn't see them do anything. He came in, he did that. Chris, there was a plug on the end of my kitchen, my island that they forgot to put the cap on. He put the cap there. Chris went behind back where the HVAC is, where that hole is at. And I don't know if he put aqua guard or something there or something. He said they handled it, they did it, and they left.
All right, so you heard talk about Mr. Silver, so they plugged a hole.
I didn't see no cement, hydraulic cement being poured. Matter of fact, Travis said you can't put hydraulic cement back there for some whatever reason. I don't know if it's the HVAC or because the hole was already there with the other concrete. He told me he couldn't do that.
All right. But somehow they stopped, no more water's coming, they stopped the water from coming into the house.
Did this stop for right now, for that then and there? Yes, for that time, yes.
What do you know about what they did outside as far as?
I didn't see them do anything. I was very observant. I didn't see them do anything.
Grade your back patio?
They didn't grade they did not grade the area that they said the water came in there. They didn't do anything to that. They just did that. They checked the rocks and that's it. They didn't.
So when you go out your back door, your patio, what do you see as far as the fence to the right, up under?
That was a whole crack. As you see in the picture, the Elmina crack was a big 4 inches, 5 inches going across all the way deep in. I could probably put my whole hand in there. Yes.
What happens when it rains?
Water would come straight underneath the crack of that slab or that foundation.
They put in the rock down, that help?
No.
Impact it all?
It didn't help. It was still like a whitewater rafting, like a flood. It looked like a whitewater. I could actually get on a raft and flood down and slide and go down the hill with it.
You heard the defense attorney say something now, when you put the fence in, you put it in because of the water coming down. You want to protect yourself from the water coming down.
So I knew I couldn't do nothing, but I was worried about the trees. I was worried about the shrubs, the pine straw. Every day, every time it rained, not every time, every day, but every time it rained, it seemed like the whole community's pine straw was in my yard. So I always had to dig it out and put it in a plastic bag, dig it out, plastic bag, dig out to make sure I still had enough water to come through. It was bad.
That's how you put the fence in. Is that the reason you put the fence in to protect from the pine straw and stuff? Or what?
No, I thought it would help it. No, that wasn't the main reason, no.
Okay. So you put in the fence and took some photographs and videos.
Mm-hmm.
When months did you take those videos?
I think it was July and August.
Of what year?
2019, 2018, I'm sorry. July and August.
All right, so you list four, you gave the dates, once you took those of your car phone videos?
Yes.
The dates were on the phone?
Yes.
So let's go ahead and just watch the 4 videos, no sound.
Let's tender them first.
And I'll tell you something to
Your Honor, 6 through 9.
6 through 9.
Mr. Stewart just said that he wanted the videos played with no sound, and I object to that. We would like this.
Okay, let's do one step at a time. Mr. Stewart is now tendering before playing plaintiff's exhibits 6, 7, 8, and 9. Do you, Mr. McLeod, have any objection to the admission into evidence of 6 through 9?
Do not have any objection to the image.
Okay, Mr. Dorsey, any objection?
I do not have any objection subject to our prearranged agreement would be played with no sound because it has hearsay and out-of-court statements. So we previously agreed that they could be played just without sound.
When you say we, you,
Stewart and I had addressed that. Yeah, I thought we were all the same. I apologize.
okay, one at a time. And thank you, Mr. Dorsey. So they're admitted. How they'll be published, we'll work through in a moment. But so the record is clear, 6 through 9 are admitted. I've got that as 4 videos. Now, the question is, how do we play them? And Mr. McLeod is saying, play the video, don't keep anything from the jury. There seems to be some concern about hearsay. Is that present in all 4 videos or just some of the videos? The hearsay concern that you've got, Mr. Dorsey?
Your Honor, it's just commentary throughout the course of the videos.
Is it anyone other than Mr. Ibezims who is providing the commentary?
In these 4, I'm not sure. I know that there was one with unidentified male speaking. I'm more worried about a continuing witness rule, Your Honor.
All right, well, that would apply if they went back to the jury and the jury could play them in an unfettered manner again and again, which isn't how that'll work. So I've got your continuing witness rule covered. Mr. Stewart, if we play these with audio, are there people other than Mr. or Ms. Ibezims who will be heard on the video?
I think only you'll hear.
Okay.
Yes, it's only us two, I believe.
All right, then you may publish, but you need to publish with audio. And that requires whoever's doing it to check the little box when you're saying share screen, share audio as well.
All right, so we're looking first at the 6, that says July. So this is 4 months after you moved in. Is that the first time you noticed water problems 4 months after you moved in?
It was before that, but it was the first time I started recording because it's hard to record a flood. That was the main issue I was having. They would say, oh, give us the evidence, give us the evidence. It's hard to catch the water because I'm standing on the ground to see it. So finally, as you see in the video, I finally took a video from the 2nd floor. I think this was from, but I'm not sure. I don't know which video it is yet.
All right, so let's go ahead and look at number 6. Turn the volume up.
Yeah, I think. Well, I've got. Yeah, I'm not. I don't hear myself.
So you need to keep your machines muted of the sound place. So someone's personal laptop isn't muted.
I'm still picking up sound from somewhere.
All right, everything's muted now.
Sounds like it's coming through mine. Let me try.
Someone's maybe it's been fixed now. You've done it. Okay. So we watched the video. Do you have questions about the video? Don't, that's not how it works. Don't change the volume on your computer that's attached.
Yeah, I'm not.
Everyone's talking to
reshare.
Okay. It's on you to get the equipment to do what it needs to do.
myself.
There we go.
Inside the house. So that's outside when I show you the water flowing. And see where the water is coming into right here. And water will keep on seeping through because the flood outside. So this was the water. What was that? Brand new house built in 2017.
Is it coming in?
Do you want to do the next one?
Yeah.
Okay.
Has nothing to do with the fence. It's raining. Yeah, the water of the flood is going right here, but it's still making its way out. One issue of being dug it out, this is what Trevor told me because of the fence is doing this. See the water coming down, this is the water right here, but this is not the fence. This is a leak. This is coming in my house. More water will flow like into the house. Of the base where the leak is at. This needs to be more concrete down. And this is where the leak is at. The water is eroding. The fence has nothing to do with the fence I built. This is the fence that's already here and it's eroding. It's going into the foundation. That's why I have a flood in my house. I will continue to have a flood in my house. This is the original fence. Not an aftermarket fence. The source of the leak. I don't know how the foundation looks already now, but it's a major problem.
Picture right back in 2018. What is there now? You look right there on the.
Sandbags. I put sandbags.
Sandbags.
I did.
Did they help?
Not really. Just I was protecting my HVAC. Nothing I can do about the foundation in the house right now because it's more money to eye. But I was just trying to protect my HVAC so I can at least have heat.
And nowadays, is there a board there?
They put a board to cover it up. Yes.
We'll talk about that in a minute. Spread them on at 9.
They put all that hay down to cover it up and made it worse now. The hay wasn't there before. Without no, I had no way. Look at that puddle right there.
That's the rock dam?
That's a check dam they put down. The rocks is trying to slow it down like the crap path, but it's making it worse. It's still not going anywhere. Slow down a little bit, but.
Now that's
That is not the gate that's doing that. It's the hay, all that hay that's pulling up to the gate that you can't even vent the gate now. Because they put so much gate.
There's some hay right there, see over there?
Yeah.
There's so much hay over there, it don't make it. It don't make it
They just
happen.
covered it up.
Ain't nobody else.
Nobody getting that water. That's why this shit was undersold. Somebody probably foresaw all this. Because look, they're not going to get it because it's on the side, so they can't really.
All right, so more videos as far as.
Your Honor,
1 second. Yes, sir.
that's not the complete video.
Yeah, actually, it's trying to reconnect to the Zoom meeting for some reason. I'm not really sure if I got disconnected completely or there. Yeah, I'm reconnected again.
Well, we don't have to do the whole thing, but we could move forward however far, roughly how far we've
I'll
got.
pick up from where we left off.
Great, thank you.
I might have forgotten to share with audio. Give me a second. There we go.
Everybody's slab and patio's bone dry. Everybody patio's bone dry. Our patio is halfway invaded because it's unleveled. This house is unleveled because if it was dropping down again and was on a right slope, that house would have more water draining down. This house is sunken in, and the between of these two houses making it all the water sit right here. It's uneven. There's no slope.
Mr. Ibezims, these videos were taken in, I think you said July and August of 2018. Is that correct?
Correct.
All right. Is your unit physically connected to the adjacent units?
Yes.
Or could you, like, someone could walk between?
No, they're connected.
Okay. The downspout work that we heard about, that changed the downspout so they actually go off the slabs and into the ground, that had not happened at the time of these videos. Is that correct?
That's correct, Your Honor.
Okay, thank you. Mr. Stewart?
Thank you. Okay, about that same time, some of the same thing, just still photographs. So tendering the evidence, 21 to 25, 5 photographs.
Mr. McLeod, any objection to 21 through 25?
No objection, Your Honor.
Mr. Dorsey?
No objection, Your Honor.
They are admitted.
We talked a little bit about what we saw. I saw a shovel in one of those.
Oh, yeah.
Is that where you normally kept it?
Yeah, right there by the gate, because that's like, I always had to dig it out. I always had to shovel it out.
What are you shoveling out?
To make sure it has enough gap, the pine straw, like I said, the debris, the branches, whatever flowed with the river.
All right, so let's go look at some photographs. Go to 22. Not too much we saw earlier. Look for orange arrows. What are they pointing at?
To the concrete slab that's has a hole in it. And see the hole. I don't know if I could circle it. You can see the hole right here.
That's the next door neighbor's house.
That's the next door neighbor's slab.
That's your.
That's my HVAC, which was underground when I bought it. That metal thing was underground when I bought it. I had dirt over that.
Another thing you talked about.
I don't know if the electricity that goes to the HVAC.
That's how they go show up.
I won't. I just touch screen.
It will, if you tap the screen, a little pencil icon should show up in the lower left-hand corner. Lower left-hand corner.
All right.
Is there a little pencil icon?
No, Your Honor.
What are you talking about? See the blue base of the AC unit? What are you talking about?
Okay, you see the two arrows. These are two arrows. All right, right directly underneath that, there's a metal rod or pole that connects to the AC unit. I'm not sure the two arrows that's talking to it, looking at that was buried. I didn't, when I first bought my house, you cannot see that. You know, that was supposed to be exposed.
So That was underground, you first caused it, now it's the water.
And erosion, now you can see that's now is above ground.
Is there some problem worried about electrical wire, is that what you're talking about?
And the electrical wires, the whole, there's wires there.
I'm confused because there is actually siding of your house there. What is it that would have been underground? Because your siding wouldn't be underground.
Not my siding, but Your Honor, we could see the other pictures from El Mino that this was not exposed like this.
Okay, the area sort of up against
Yes.
the cement.
Yes,
slab.
yes, yeah, the
Okay.
slab, yes, Your Honor. And there's also another black wire behind the electrical wire, it's thicker, it's a thicker black wire that I guess goes into the ground for your electricity from Jack's EMC.
So what you see there as far as around the exceedance, does that change? It's pretty much the same today.
It got worse.
You got grass now?
No,
Have you ever had grass for 2018 as the president?
no.
23. All right, 23, what is this?
I had zoomed in.
What is this here?
That's the that big black wire I was talking about that I saw it was under not deep underground, but it was shallow. I didn't see that. So that's the black wire that you see, or it might have been a pole, but there's that. Yeah, that's the silver line. That's the pole, the wire for the HVAC or electricity.
So where are you shooting this picture from? Where's
I'm standing directly. I come out my patio. I look straight directly at it. I zoomed in, came up closer, zoomed a little more, and put my phone right there so you can see how big the hole was.
So the air conditioner, your house will be over here.
Yes, my house is right on the side of the wall right there.
I see you.
It's right here on this side of it.
324. Right. Look at that. What is, how close is this concrete slab next door to the fence in your?
It's right there. It's right the adjacent behind it. It's right directly behind it.
Is that the black wire you?
Yes, yes, yes. Now you can see more exposed here.
How deep is the concrete slab?
From there, probably like 10 inches, 12 inches. More than that.
All right. So that's the same way we've been looking at.
Yes.
Looks wet at that time. Rain, what was it wet?
It's always damp there. After the rain, probably rained a day or two before, but it's always damp.
Let's look at 25. Like I saw the video a little bit. Where are you standing when you take this picture?
If I'm on top, I went to the second floor again.
So you're inside the unit looking down?
Yes.
This water, where's it coming from?
The hole, you can see the stream coming down. It's coming from that hole coming down into the yard.
So we know they said it came out. We know this is work. They're tested and counted and what's affected. Like you're working that slab?
They just covered it up. They didn't do any work on it. They just try to, so nobody could see my issue no more. What I was complaining about, they just put a slab over that space. It was a 2x4, a 2x6.
Let's look at picture number 21. So is this the same black wire?
Yes, yes.
Why's the color change?
I don't know what they did. They just threw it on. They didn't care. I don't know why it changed. I don't know it's from the concrete. I don't know where is it from.
Like we said, who came out and did some work?
There was preventive maintenance. It was the HOA.
Is this the same people did the work for Omino?
Yeah, yes, yes,
And this 2x6 board you're talking about,
yes.
did that help?
No, because water's still coming underneath that 2x4.
When they came out, who all came out with?
I seen it. I took a video of it. I didn't see anybody at the time, but the guy was acting kind of strange. So I went up to the fence And I saw Sean on the other side of the fence, like he said he always does, he's ducking down and doing all that stuff. I took a video of him being there, and then I turned back around and started having the same conversation with the guy that was doing it.
So was Sean there?
Yes, he was there.
What, did they tell you at all why they're doing this?
He didn't tell me, he just said, I'm trying to avoid the problem, fix the problem. I said, this is not fair. He said he would have tied up his builder if this would have happened to him.
All right, so when was this? This was after the El Nino report?
This is after.
We know that was in June 10th, 2019. So how long after June 10th, 2019, El Nino report was done?
I think this was what, the July? No, after this is a day after they came. This is like 2 days after they came. I did this this picture. 2 days.
Day after they came for what?
They came to supposedly put the drain pipes in or the downspouts in. They put the downspouts in. I watched the whole thing. They dug everything up. People didn't look professional at all. And I was kind of worried about it. I said, I have concerns about this. They asked me to open my gate. They said, everybody say that I'm not cooperating, everybody. I'll open my gate so they can do this. I said, I don't want you doing this. I said, I'm gonna let you do it, but I really don't want you doing it because I don't feel comfortable about it because this is not what I discussed with the board. He said, well, I'm gonna do it. It should fix your problem. And that's when I said, he was acting kind of strange. So I took my phone, went inside, like I said, went around the corner. I saw Sean doing this ducking thing like he always does. He already testified. He'd come out there 30 times, 40 times. He had some issues and he was behind the fence, instructing it and watching what's going on.
All right, so they did this work in July 2019 or so.
Mm-hmm.
The water flow that comes out of the drain has a change of law.
No.
What about the fact that through the drainage ditch, does that help?
The drainage?
The pipes come down.
Oh, that's made it worse. It made it worse because like he said, that's, I'm not sure, or the jurors was here. It's not hearsay because some of them was here. The lady said she had to change that pipe a couple of times. That's what I think is gonna happen here because that pipe is not big enough. So when it drains, when it rains really hard, the water backs back up into the roof of the house, and it's now look like it's a waterfall or a gazebo or a garage or whatever they call that, and there's a waterfall coming down to my house, making the problem even worse with the water coming from underneath and now on top directly on it, not just coming off the groundwater.
Like you said, John Smith said that after you shut off whatever, that you did silence, you had to contact the HOA and association off. Have you complained at all or?
Yes, I have a lot of work orders. Yes.
Say the portal, just go to the portal.
Yes.
Just letter you sent it.
Yes.
How often have you done that?
I did about 4 or 5 times through the work portal, work order portal.
And we're complaining about the roof.
I'm complaining about the, yes.
Have they fixed that problem?
No.
Have they come out and clean it and come back or what?
Then they was trying to get into my house. At that time, we had a lawsuit going on. I didn't feel comfortable being at my house.
What going on?
The lawsuit was tendered at that time. So I didn't feel comfortable because they had told me that they don't have no preview in my house because of my covenants. They can't come in my house or fix anything into my house or make any repairs because they're not gonna pay for it. So it was kind of odd for them to come back out saying that now we can come into your house. And that was the last time I filed that portal was January 24th or something like that.
Do you have on your phone?
Yes. Yes. Yes.
They want to cross.
Yes. Yes. Yes.
And you also taking videos showing this water?
Yes.
We met their trial last Friday. I said, we had to give some recent videos. Did you show me some video?
Yes.
I told you it's too late to.
Yes.
Is that on your phone?
So stop asking questions about stuff you know you can't introduce because it would be late discovery. Let's not explore that. Okay, next area.
Okay. Let's talk about how you mistreated everybody. Go ahead.
Of course.
Some people said it must be.
Yeah, of course, right? I was told and I was heard, so I can't say that. So, but I think you're well aware what's going on. I mean, when you talk too much or when you say too much, they're gonna try to silence you any type of way. How they silenced me, I know I'm going a little off the subject, off the topic, but I'm gonna let you know. Was not told accurately. I can't call nobody a liar, but at that meeting that we had, and I discussed everybody what was going on, I
The
said,
one at the
look,
fire station?
no, we had an HOA meeting prior to that.
This was the annual meeting?
Yes, this was the annual meeting. I stood up, I said, I'm new here. Hello, everybody. This is what's going on. I told everybody what's going on. It said, he stood up, Sean was with him. Mike Tully stood up and said, you built an illegal fence. That's why you're having that problem. Mike Tully in front of all the rest of the homeowners so they could divide and conquer, divide and make sure I was the bad guy, put me in the corner and not say anything else. Don't listen to that guy. He's wrong. And he's the one that signed off on it. So how can he say that I had an illegal fence and he signed off on it? Because he didn't want nobody else to know the issues. Nobody else was contacted. Nobody else in the community was going on. We had a lot of conversation with Sean. He started acting like that when I asked him about what's going on. You promised me that you're gonna fix it this way, and you didn't do it. You did not do it. You kept on telling me to wait. You kept on telling me to hold on. We're gonna take care of it. And he did not take care of it to the right measures, because that's not what happened. And that's exactly what happened at the meeting. So when I was going door to door, we had a lot of issues in our community. When I was going door to door, it didn't work out for me because he already told them I built an illegal fence and I'm doing illegal stuff over there.
Heard that the June 10th report came out.
Mhm.
And then they gave you a copy to review it, and give input at the firehouse meeting.
No, we had a meeting on that day, July 10th or 11th. No, that day, July 10th, she contacted my wife 2 hours prior to their meeting. So I said, babe, they email me what happened? She said, oh, we about to have a meeting at the firehouse. Can you come? Can Tia come? I told my wife, I said, she said, can I come? Can they come? And they said, you can't come, Chris. They said, you can't come to the meeting. I said, they just told you about this meeting 2 hours before that? I said, babe, I don't know who could cover for you. Can you have the CEO cover for you? Somebody to cover, but we have to go to this meeting. They just told her on the spot they're about to have a meeting. They didn't have no advance notice or anything like that. They said they're having a meeting 2 hours. Can y'all be there? I said, babe, I don't care how much you're losing. Let's go to the meeting. Let's see what they have to say. We could finally get this fixed. And I went to the meeting. They told me I couldn't come to the meeting. So my wife said, how can I come without my husband? That don't make any sense. So I said, I'm going to the meeting. Let's go to the meeting.
This is talk about the meeting on the report.
Yes.
Now, the meeting, did they decide and tell you what they're gonna do?
No, did not decide. That was inaccurate what Sean said. They did not decide at that time. And they didn't give us the report. I asked for the report at the meeting. Mike Tully told Sean, I can't have the report there at that meeting. He just looked at the same thing they're doing here. They looked at the report. They didn't have the engineer there, because me and the engineer had a good conversation. They had nobody else there. They just had them there. And Sean was reading off of it. And Sean said, can I give Chris the report? Mike Tully said, no, he can't have the report. I said, why? Why can't I have the report? I said, fine, can't have the report, no problems. A day later, that's when June 10th or June 11th, he filed that order of restraining order. The day after that meeting, or that restraining order, he filed it. So I think it was conjunction to that for some reason. But he sent the email, finally, Mike Tully sent the email June 12th or 11th saying that this is the decision the board made, we're going with this option.
Okay, so part of that, Mr. Stone told you, go to warn people, don't contact me. And Mr. Smith, did he tell you not to contact him as well?
Yes.
All right, let me see the work they did like that. And the problem continued.
The problem still continuing to this day, correct?
All right, that's when you filed your lawsuit.
In Gwinnett County.
Did you build a lawyer?
I did it myself. I didn't have money for a lawyer, so I went to the law library. I took off. My wife took off, and I went to the law library. So I tried to study how can I put a complaint together. I was trying to ask for help. Nobody could give me no legal advice, so I just found a document and started filling it out the best of my abilities.
All right, so who did y'all name the lawsuits?
I named Mike Tully, Sean Smith. Those two.
Did you sue Waters Edge?
No.
Did you sue any of the third parties? As far as those two, but as far as any other companies that by related?
I believe so. I'm not sure. I remember. I think so. I'm not sure.
All right. Other questions?
We're going to take our afternoon break, ladies and gentlemen. Try to keep it to about 10 minutes. Don't talk about the case, no outside research. I heard that the jury room is cold. So it's all about balance. We can have, this is the old building, we can have a sweltering courtroom and a temperate jury room, or we can have a chilly jury room and a courtroom that isn't quite as hot. You guys discuss and let me know what you want, and we'll tell the HVAC people to work their non-magic. Enjoy your break. All right, Mr. Ibezims, you can go back to council table. Thank you. We need to get back on the record. I wasn't ready to get off. Sorry about that.
Yeah.
You all can be seated. All right, Mr. Pye, hold on. We're not on break yet. First, I should have made clear before, all of the cards submitted by jurors will be made part of a single court exhibit. Court exhibit 1 is going to be the entire universe of cards submitted by jurors. Number 2, I need to get you all the ruling on Dr. Spots. I find that, and I think that both Mr. Kyle and Mr. Dorsey acknowledge, I guess it was Ms. Wilson. No, you didn't argue. You argued the attorney's fees situation.
Yes. That's
Okay, so Dorsey and Kyle were arguing the 702 issue with Dr. Spots. I think we all agree he was qualified. The concern for the third-party defendants was reliability, and I think Mr. McLeod joined in, but didn't make much argument other than to send me to the CSX case that I'll talk about in a minute. I find that Dr. Spots offered a couple of opinions. One was about the proper alignment or capacity and performance of the swale, and the other had a lot to do with the concrete slab. My ruling is based on Dr. Spots's testimony that we're done hearing about his views on the slab. It's actually nothing that was in his affidavit. And a lot of what he had to say about that flowed from, no pun intended, his assessment of, I think the soil was damp, and in particular, photographs that weren't contemporaneous with his inspection. They were photographs from the El Nino report, which was 2 years-ish earlier than when Dr. Spots was present. I do think that his opinion about the performance capabilities of the swale, that it was shallow, it wasn't steep enough, and that if it were realigned to go around the fence, that it might have had a salutary effect on the water flow problems he is able to give. His opinion is not totally based on speculation or conjecture. The fact that it may be partially speculative because it's not the product of getting out some of the tools that he could have brought with him doesn't disqualify it. That goes to the credibility of the witness and the weight of his opinion. And I draw that directly from the Oglethorpe Power case that Mr. Stewart cited for a different proposition that we'll talk about at another time. That's at 332 Georgia Appeals 693. I also find support for my ruling on allowing Dr. Spots's testimony about the swale to be something that can be argued to the jury, that it gets support from the case of Wilson versus Redmond Construction at 359 Georgia Appeals 814. And what that case tells us is that trial courts may not exclude an otherwise sufficient expert opinion simply because the court finds that the opinion is not particularly strong or persuasive, because here the tools weren't brought, the camera wasn't present, so there aren't pictures like the sarcoma that another expert could look at. But in the end, the weight to be given this testimony is a matter for the jury. And I do find that based on Dr. Spotz's expertise, and there's no challenge to that, he relied on sufficient facts, i.e. his visual examination of the swale and the grade and the shallowness of the swale, et cetera, coupled that with principles and methods that are known to his practice, i.e. water flows downhill, the rate at which water flows, et cetera, and makes it a sufficiently supported opinion that should Mr. Stewart want to argue to the jury, well, Dr. Spots told you the swale wasn't ideal and it could have been redirected and that would have remediated the problem, he's free to do that. But Mr. Stewart, you may not argue to the jury what Dr. Spots had to say about the slab, in particular about the runoff with the downspout, because of course, when he was there, that's not even what it looked like. And his opinions that he shared with the jury were based on the El Nino photos, which we've now demonstrated through other witness testimony, don't show what the situation was like when Dr. Spots was there. Any questions or objections to that? I'm going to start with the movement. So that's Mr. Dorsey.
We would rid of our objection to this testimony being admitted.
Okay. I guess I'll also note for the record that I had addressed some concerns about Dr. Spots's affidavit, entered an order on that. I'm not reassessing that at all. I think that was the proper ruling. This 702 objection, it's not untimely in the sense that you can object when you want, but certainly the Daubert-esque concerns that were raised, I think Mr. McLeod hinted at it before we started trial, but the eve of trial, and then Mr. Dorsey brought things up after Dr. Spots testified, take us outside the Daubert framework of I need to enter a written order before our final pretrial conference, because of course the pretrial order had already been entered and we were well past the time for dispositive motions. That deadline had passed. Mr. McLeod, anything you want to add as a joiner into the motion?
No, Your Honor.
All right, Mr. Stewart.
Do object, saying that cannot talk about the slab at all. His testimony was he personally came there, he looked at it, he reached down to the ground, got down and saw the hole under the slab, and that'd be the place for the water to run out. That's just flagging out personal attention from an expert. Go to the way of the evidence where he should have maybe took a photograph if you think, whatever. I do agree that the spout is wrong, but that's a solely separate issue, that the spout coming down with 2/3 of the way, whatever. That's not the same as from the plaintiff's fence there, when you reach underground and the water and the concrete slab is not working.
Okay. Mr. Kyle.
Your Honor, I rise for the purpose, singular purpose, of pointing out to the court. I'm rather new to this litigation. And then I think I found notice of appearance of the month. Deposition of Dr. Spots was not taken. I don't know why it wasn't taken, but it wasn't. Therefore, it's difficult to anticipate and file a Daubert motion when you don't know what the witness is going to say. And
right, but that problem is which set of attorneys' problem?
well, it could be any of our problems. But having said that, I don't know if that prevents an attorney or a set of attorneys from filing the Daubert motion after the testimony has been given, since they didn't have an opportunity to know ahead of time. Could they have known? Perhaps.
Right. They had the opportunity. They elected not to pursue it. So I want to be clear. I've analyzed this under 702. And I think the framework you described is the proper framework. I was merely noting for the record that no Daubert motion was filed. You've helped expand that record by observing that the objecting parties, defendants and third-party defendants, never sought to depose Dr. Spots. And so it's that deposition that might have put them on notice or armed them with an ability to further cross-examine, impeach, and attack the credibility of Dr. Spots. But for whatever reason, that's not a step that the defendants or the third-party defendants elected to take. So we are where we are based on those choices.
But we appreciate you considering the fact under 702.
Last thing I want to add to that, I did look at Smith versus CSX, which is a case Mr. McLeod had flagged. And I think it's distinguishable. The expert in Smith versus CSX had to, it's a state case, but it was under a federal law and injuries that occur in situations that implicate some federal law. And the issue that the court found there, an expert who had been excluded in a federal case as well, was that the expert, a medical doctor, failed to use any reliable methodology, and there wasn't evidence that what he did was reliable. And what we have here is a different situation. No one has challenged Dr. Spots's visual of inspection of the swale. And that's why I think, because of his expertise, he's in a position to opine on the state of the swale and the impact of that, as well as the impact of remedial measures on the swale. And there was testimony that the swale now looks like it looked when he was there, looked like it did during the El Nino photos, which is in marked contrast to this hole under the foundation. In fact, we know it had to have looked different because we now have in evidence pictures that it looked different, pictures admitted by the plaintiff. So the El Nino picture is fundamentally different from how it would have looked when Dr. Spots was there because of the preventative work or the remedial work that, I don't remember the name of the vendor that was hired by the HOA because of the El Nino report, that board that they put in and the hydraulic cement that was put in, all that occurred post El Nino photo, upon which Dr. Spots based 99.9% of his testimony. And yes, Mr. Stewart, he did say, well, I stuck my hand under there too. Wherever he was sticking his hand was in a completely different situation because the board had been installed, et cetera. And for whatever reason, Mr. Stewart, you declined to urge Dr. Spots to memorialize his inspection with photos. Very different from the swale. So I want to give you guys at least 2 minutes for your own break. If you want to eat up those 2 minutes, Mr. Dorsey, by litigating this more, you can.
It's actually a separate matter. I will say that discovery was reopened only as to third party and plaintiff and third party defendants case. So it was our perception that that expert fell into that initial case,
right,
with purposes of deposition.
So you wouldn't have been able to depose. Mr. McLeod could have during regular discovery. You wouldn't have been able to. Okay, fair point.
Just for the record, the next point that I did want to address is there's been ample testimony on the stand about what could and couldn't afford, but the hardships from jobs and all those things. I think I'm honored to address that with the witness, step back and not object to that. However, their financial circumstances are highly irrelevant. These guys are in the face of the wall, and so I'll just ask for Your Honor to address that before we get back in front of the jury.
Okay, I will, but it's not my job to object for you all. I heard it and also heard crickets because there were no objections. So you're objecting now, and I'll let Mr. Stewart know, but it's not proper for me to police things for your case or Mr. McLeod's case. I agree with your observation, but in both ways. One, it was objectionable, and two, you didn't object.
Correct.
And I need to not insert myself in a way that would seem like I'm trying to support one side or the other, any of the three sides.
I agree, Your Honor, and it is our job to object. And I'm not suggesting otherwise. I, for efficiency purposes, have not, because I didn't think that we crossed the line because that we couldn't come back from.
Okay.
But I'm just asking for it to be addressed now, so hopefully we don't have to interject and don't have to step into that.
Okay.
If we can be in.
Got it.
Try to address it on the forefront before we keep going.
So, Mr. Stewart, I'll let you respond to that, but let me preface your response, if you've got one, with certainly you can ask your clients what financial impact, i.e. what did you have to spend to fix it? Did you had to put in tile instead of carpet? Perhaps Ms. Ibezims had to take time away from work to go to these meetings. Those are all financial impacts. But I'd ask you to stay away from questions that would lead your not lead, because you're doing a direct exam, but would prompt your clients to say, and by the way, we don't make a lot of money and it's real expensive to homeschool, et cetera, because those are the same kind of worldly means that you wouldn't be exploring, I know, with, well, gosh, how much money do you make each year, Mr. Tolley, through your Tolley management? Okay.
I will instruct my clients not to bring up anymore and not to do that. I didn't want him to do that.
Okay. All right. Anything else, Mr. Stewart, before I give you guys a couple minutes to refresh?
No, Your Honor.
Mr. McLeod,
No, Your Honor.
Mr. Dorsey. All right. Now we can go off the record again, Mr. Alston. Thank you.
We're off the record.
22. Eight. I don't need his deed, which is, you're gonna do it on this. Yeah, so, yeah, his deed is 14, okay. Okay. 14, 22. Okay. 22, 37. 14, 22. Let's see. Twenty-two, we're doing 22. 23 through 30 are letters. Yeah, just long. Actually, it's 22 through 33. 23 through 30. I may not be able to identify some of this. This is just the way I have it. So if we don't. Let's just put them there and if I don't skip them, I skip them. 31 through 33. Right. 31 is the association payment bill. That would put that there. He won't be able to do that. Yeah. Oh, yeah, yeah. Sorry. Yeah.
Well, now we don't have to.
I don't use, so I've got my compass mark. From the original. Get to the 12 minutes.
Actually, the issue.
Welcome to order, Mr. Massey.
Now we're at. Right now. Let's show one of them.
Which one? All right, we've got everyone in here. Let's go back on the record, please.
Your Honor, maybe address.
Hold on, we're not on yet.
Back on the record at 4 o'clock p.m.
All right, Mr. Kyle.
Your Honor, during the direct examination, the plaintiff testified that he had videos that he had taken, and then opposing counsel, the plaintiff sort of said something about, well, I told you to take them, but you can't produce them because the discovery's in it. The jury's been told all about that stuff. May we see the videos outside of the scope of the jury to see what they are? You don't want to ask to see what they look like unless they find they're damaged.
So you can talk with Mr. Stewart about that, and if he wants to share them with you, he can. You may want me to instruct the jury about the impropriety of that exchange. I cut it off. I was surprised that 5 lawyers didn't jump out of their seat with their heads about to explode, but it hit a tripwire of mine that was stronger still than talking about how I don't have a lot of money and we couldn't do this because of COVID. That is objectionable. If someone objects to it, that was objectionable, but problematic because it's throwing in front of the jury something you could never get your hands on. So we are where we are. I'm not going to direct that Mr. Stewart hand something over, but I'll be open to any kind of curative instruction or jury instruction now or at the time just before closings or when I give my charge. I think you've got a number of options you could work with if that's something that you want to do. But I'll say this, at a minimum, Mr. Stewart won't be sharing with the jury. You know it's a continuing problem because there were videos of the continuing problem. The only evidence is that right now, and I assume Ms. Ibezims is going to say the same thing, but Mr. Ibezim has said it's still a problem. That's one source. Maybe Ms. Ibezim will say the same thing, but certainly no videos.
You would ask for a curative instruction.
To share with the jurors when they come back out now or at a later time or both?
I would prefer you do it right now while it's fresh on the mind.
Okay. And you would want me to say something to the effect of, you heard testimony about videos that were taken more recently. You don't know what's in them. You should assume that if they, they shouldn't assume anything, but they should disregard any mention of those videos and that was an improper exchange or?
Yes.
Okay.
To that point, Your Honor, I know your honor's gonna have it memorized better than I do. Is there not a jury charge that in essence says that if evidence is available that benefits your case, that you either bring it or the jury can assume that that is not beneficial to your case?
So I was about to go there, but the issue we've got is, let's say there's a video Mr. Ibezim took yesterday. It was raining and there's water coming in his house. He couldn't, it's after the discovery period has closed. And so I don't think it's an appropriate instruction to say, you need to assume that it's not helpful to the case, because we those two principles collide. And so to Mr. Kyle's point, maybe you want to look at them and you may look at them and say, this shows that it's damp outside and no water in the house. And then you'll let Mr. Stewart admit them, but you haven't seen them. And so I don't want you to have to guess what's in them. The most immediate relief I can afford is to tell the jury that was an improper exchange. They shouldn't consider that the videos exist or what they would show, because they're not properly before you. I don't think it's appropriate to say, actually, there's a presumption that they're not helpful to the plaintiff's case, because they could be powerfully helpful. But to Mr. Stewart's point that he tried to make in asking, it was like, but we can't use them, right? Because you made those two recently. And that area should not have been explored at all, which I think is why Mr. Kyle brought it up. Mr. McLeod, anything in addition?
Not on that subject. May I address the exhibit issue potentially?
Not yet. I want to close the loop on that. Mr. Stewart, anything you want to add on the exchange you and Mr. Ibezim had about more contemporaneous videos?
No, other than I didn't ask him to take him, he just Friday said, oh, it rained last week and I got this new video. And I said,
okay. And I will be careful not to ascribe anything to you in particular. I'll just say there was testimony about, and that needs to be disregarded. Okay. Mr. McLeod, different issue.
Yes. Regarding the prior lawsuits, I'm just trying to, is it okay if we admit the complaints as exhibits? There's been a lot of testimony about who they sued, which were parties, and they weren't sure. I think we need to introduce these lawsuits.
So I think that it is legitimate to clarify who the parties were. I don't know that I would be comfortable, one, admitting them into the record, so they're made part of the record, and two, publishing the first page, because that's going to say who is suing whom. I don't know, though, that it's relevant what the allegations were beyond that. These were claims that were withdrawn, et cetera. Will that address the concern that you've got, or you're itching to get to page 4 to ask Mr. Ibezim, well, why did you say this happened?
Well, I thought that we had argued earlier that they were allegations for admissions against interest. That they were claiming the same thing against the other defendants, third-party defendants. So is it okay if we at least explore those allegations, specifically addressing what they alleged in the complaint, even if we can't publish it?
I think that's fair, because it's part, this we discussed before, part of the ways in which the Ibezims sought to remedy their situation and seek relief is that, and now we've heard, because their worldly means they couldn't afford an attorney, then Mr. Ibezim went to a law library. Ms. Ibezim maybe had to take some time off in connection with that. We don't need to reiterate that part, but that they thought long and hard and took the following steps and made certain allegations. And so I think you can explore that with him. I'd ask you not to get into specific language. You can refresh his recollection with it. I don't think that complaint is going to be something that goes back with the jury, but you could certainly refresh his recollection so he could say, yeah, I sued Mike Tolley and not Backyard Realty. I sued Sean Smith, but not as the president of the homeowner. It says what it says. I don't know.
Right, but with respect to the admissions against interest in their allegations, is it okay if we specifically reference what they alleged?
Give me an example.
Okay. So an example would be by Tolley Community Management, Mill Creek Lakes HOA failing to get inspections for the association responsibility items on completion, not properly maintaining common area, resulted in damages to subgrade soil underneath the foundation, water seepage, damage to the foundation walls, baseboards, and
Okay, so who is admitting what against whose interest through that statement?
I think that the plaintiffs are admitting that they think somebody else was liable for their damages.
Okay.
Us.
All right. So you can ask Mr. Ibezim about that. Why did you sue Mike Tolley? Why did you sue whoever he sued? And he's going to give you the answers. But that was withdrawn. The case law I have found is that if the admissions are not withdrawn, they can be used against the admittor. So they can't be used by the admittor. Hey, in my complaint, I verified this. And so that's.
You can't use that to defeat summary judgment.
Correct. But the case law is clear. You can use a non-withdrawn admission against the admitter. And so that's why you're saying, I guess, admission against interest. I don't think it's an admission against interest. It is a claim, but here it's been withdrawn. And all the case law is, as long as it has not been withdrawn, you could, in the context of summary judgment, say, look, this is what they alleged.
Perhaps I misunderstood that. If they had not withdrawn it, it would be an admission that's conclusive, correct? But even if they had withdrawn it, I think it's still an admission. It can be used. It's just not conclusive of the proof. It's something that the jury would get to weigh. That was my understanding.
Okay.
Of the case, but I could be wrong.
Well, we both could be, because it's a new area for me as well, like about 85% of this case. But what I am saying is, I believe, but I'll hear from Ms. Wilson on this, that it is, you may ask Mr. or Ms. Ibezim, hey, you sued someone else first. Who was that? And if you need to clarify it by showing them the complaint, and why were you suing them? And then let's see where that goes. Okay. All right. Thoughts?
Yeah. Those complaints are not a statement against interest. Plaintiffs were making those assertions against third-party defendants. We made no statement by them filing any kind of complaint against us.
Right. I don't think they're statements against interest. I agree.
And this was the same kind of, I guess, concern that we want to address with our motion in limine, the first one, about excluding mention of the Gwinnett County lawsuit. And I understand that we've talked about that, but Your Honor already ruled before, when we addressed this issue previously, that the complaint and those reports, like the reports that we talked about, those will not go out with the jury. They can be admitted to the record for purposes of appeal and things of that nature.
Sure.
But we've already addressed this. The complaints are not going out. And at least one of those complaints in particular contains improper exhibits, print-offs from the internet, emails, all kinds of crazy things.
You're talking about the Gwinnett complaint.
Yes.
Okay. And I'll repeat. I don't think that the Gwinnett complaint will go back with the jury. I think we ought to make it part of the record because it has been a source of debate and motions. So it ought to be made part of the record for the proceedings. And the only way that I thought it would be shareable with the jury and the way they'd see it would only be if showing the style of the case would help get to the point of who were the named defendants, because there seems to be a little confusion. But I think that also could be addressed not by publishing it, but by presenting it to refresh the recollection of the person being questioned. Who'd you sue? Because the testimony so far, I find, was that Mr. Ibezim, I don't blame him, he can't remember exactly how he styled it. Did he sue just Mike Tolley and Mr. Smith, or was it Tolley and Backyard Realty? And there's a knowable answer by refreshing his recollection. I think you can refresh his recollection with your own handwritten notes. So you certainly can refresh his recollection with the complaint, but I will make it part of the record. It won't go back with the jury, and the more we discuss it, I don't think it needs to be published in any way either as somehow a demonstrative.
Your Honor, I agree with what you said. There's a lot of stuff attached to the complaint that probably should not go back. So if I'm comfortable with the first page showing the parties are.
I don't know that we need to do that, even though
We can ask them about it.
Right. Let's do it that way.
Make it part of the record, just not.
Right. So you'll need to introduce it during your examination as whatever exhibit is. I'll make it part of the record. And then you can use it to refresh recollection.
Thank you.
Okay. Anything else?
Just to be clear, we're not showing the styles or anything like that on the screen. The juries aren't seeing the jurors are not seeing the complaints.
Correct.
Okay.
All right.
You.
All right. Let's bring the jury in, please.
All right.
Straight out. Don't go on. Or ending, just keep short.
All right, adjourn. I guess I was thinking the phone in reverse, so I guess all.
Great. Mr. Pye, you dropped something on the ground there. All right, Mr. Ibezims, if you would take the stand again, Mr. McLeod. Mr. Pye, your witness.
Been here 3 days, allowed me to say a word or two.
Uh-oh.
Before I begin, I have to do this to give counsel and share the court and the court report.
Thank you.
Mr. Beasley, I'm Tom Pye.
Good day, sir.
I am assisting Mr. McLeod in defending your lawsuit.
Thank
We
you,
have
sir.
met before today.
Mhm.
If I ask you any questions that you don't hear or don't understand, will you let me know?
I will let you know, sir.
And if you do, I'll do my best to clarify.
I appreciate it.
You have described, I believe, how you learned about the unit at Mill Creek Lakes Townhouses. Did you say when it was that you actually drove around and saw a for sale sign?
I never mentioned the date.
Well, you closed in March.
Yes, sir.
Do you remember how long before that it was you entered into contract?
About 21 days, 28
Right.
days.
And how long before that did you see the unit and for sale? And I think you saw it, said it was beautiful.
Yes, probably as soon as I saw
Back
it.
into December or?
No, it was this, if March 9th, what's before March? February. So it had to be like towards the end of February. I put earnest money down. As soon as I saw it, I put the earnest money down the same day.
Okay, good. Did you have a real estate agent assisting?
No,
When you drove by, of course, you saw it, a unit was for sale.
correct.
Were you allowed to go inside at that time?
No, I went to the leasing agent. And when she said, somebody tell you about this? We just listed it again. I said, what do you mean you just listed it? That's the only thing I said.
Okay, so the listing agent was representative of the seller. The owner.
I'm not sure. It was a housing offer, it was a model house, and that real estate lady was already in there. So when I went to go in there, inquire about it.
And I'm in my 51st year of marriage.
Okay.
And I can guarantee you, as a married man, you went and consulted with your wife.
When I told her I saw the house, yes, I called her and told her, yes.
Now, was she here in Atlanta at the time?
Yes, sir.
And at some point, you and your wife went and looked in the unit, right?
Yes, we did.
How long after you first saw it and talked to the listing agent?
I believe probably was the same day.
You went through the house, top to bottom?
I went to upstairs, downstairs, yes.
Okay. You looked in the front yard,
Out
the front door?
There's not really a front yard. So I didn't look in the front yard really. I saw the landscape, I saw the bush, and I saw the front entrance.
Looked in the, what I'll say, the backyard, back area outside the rear of the home.
Yes.
Okay. And at that time, you did not see any evidence of water intrusion in the home, did you?
At that time, no, sir.
Okay. Now, how often did you inspect the property before you entered into contract? How many times?
There's only one time.
Only one time.
Only one time.
You entered into contract that very day?
I put not the contract, I'm not sure, because I'm not the one who bought the house, but I put the earnest money down the same day.
Same day, okay. And you closed, did you say 21 days?
It's like, I don't know, it was like a month, just like, because we wanted to, about a month.
And during that period of time, a month, did you inspect the property again?
No, we didn't need an inspection.
Now, the title is in your wife's name.
Yes,
But you all buying it together.
yes.
And I assume, like most of us, you got a mortgage to buy the property.
I would assume so, yes, we have a mortgage.
You understood that the mortgage company would do an appraisal and an inspection of the property?
No, that's not true, no.
No?
No.
They just,
They said because it was a brand new unit, it wasn't needed, inspection wasn't needed.
at any rate, by the time that you closed the deal, you had gone in the property one time?
About, I would say two times, about two times.
Now, a lot of new home builders have a pre-closing walkthrough procedure.
Mm-hmm.
Because the house may still be in the process of finishing out.
Yes, sir.
When you first saw the property, was it complete, with the interior completely finished? The lighting, the carpeting, the plumbing,
When I first saw the property, no, he said he had to do something about the door, because in the garage, Chris Knight said it was an extra door in the garage, an extra door frame in the garage. So I asked him what that door frame was. He said he had to replace it for some reason. I don't know what the reason was, so it wasn't completely done, no.
but the plumbing fixtures were installed, the lighting was installed?
Yes.
The floor covering was installed?
I saw that, yes.
Okay. Now, did you do the pre-closing walkthrough?
Pre-closing
Walkthrough and
walkthrough.
inspection?
Yes, yes.
Okay. Now, frequently that results in what I've heard called a punch list. There's you need to paint this door frame. You got a glitch here, a glitch there, a punch list. That is a list of items that need to be done before closing. Did you have a punch list after your walkthrough?
I will believe so. I'll give benefit of doubt, believe so, yes.
Okay. And I'm assuming that punch list got satisfied before you signed the documents and paid up, got a deed.
Punch list concerning inside the house? Yes, the inside of the house, yes.
Okay, all right. So, still, by the time of closing, after your initial inspection, after your walkthrough, after the punch list, you saw no signs of water intrusion in the house?
No, not at that time.
Did you understand that the house had been substantially completed in construction by the end of the previous year?
No, I didn't know, had no knowledge of that, no.
It was just in a state of complete construction by the time you.
Yes.
Okay. So by the time you closed, let's get your deed there.
Okay.
Let me show you. Exhibit D14. Pardon my slow.
That's all right, sir. No, sir, no
I've
problem.
got an old man.
Okay. I hope I get to your age.
Okay. Now this, exhibit D14 is the deed to the house, right?
Yes, I'm not familiar with it, but it says limited deed, so I believe it, yes.
I bet you were close.
I was at the closing, yes, I was.
The title is in your wife's name.
Yes, it is.
And as you said, you were buying this together.
Yes.
Okay. And the date of that deed is what?
It has a stamp, it has a couple stamps on it, so let me see. We're referring to. It says, it's stamped, it says, on the stamp, it says filed and recorded clerk Superior Court on that county on March 13th, 2018 at 2 p.m.
And that's the date it was recorded with the clerk.
Yes.
The date on the first line of the printed form is March the what?
It says in the signature made March 9th. Yes. Okay, yes.
So, as you say, as of that day, no evidence of any water intrusion.
On that day, no.
So whatever the condition of the swale behind your unit, up until that time, so far as you know, the condition of the swale had not any effect of intruding water into your house.
At that time, I didn't see it.
Also, so far at now, you've been in Atlanta, how many months? So you came down from New York?
November 14th.
So you've been here 5 months, but you've been here.
That wasn't 5 months, that was years later.
You came in 2014.
I came in 2014, yes.
2014?
Yes.
Oh, excuse me. You've been here since 2014?
Yes, correct.
Oh, several years. And of course, you've been here continuously since then.
Yes, correct.
And you know we get rain in the winter in Atlanta. Maybe not the heaviest at any particular time, but we get rain in the winter.
I wasn't particularly worried about the rain. I was particularly worried about the snow where I'm from, so I didn't really pay attention.
In the time period leading up to your closing.
Yes, sure.
That house has been rained on then.
If it rains, I assume so.
That swale had been rained on then.
I would assume so.
Okay, and whatever waterfall fell on the roof and may have come off the roof onto the property, it hadn't gotten into the house so far as you could tell. Had it?
No.
Okay, and whatever water had been coming down that swale, whether it was a flood or a trickle, it hadn't gotten into the house.
No.
Okay, so that takes us to March, when you bought the property. Now, if I did not previously offer a defense 14 deed.
Any objection to, it's gonna get a little complicated, Mr. Pye, because Mr. McLeod has his own exhibit list that we've been calling defendants exhibits. And I don't know if he's gonna be doing a 14 also.
It's the same exhibits.
They line up one for one?
They line up. So his D14 is
D14, great.
One set of exhibits.
Okay. Any objection to defense 14, Mr. Dorsey?
There you are.
Mr. Stewart?
Oh, yeah.
It's admitted.
Thank you. Now, looking at that deed.
You may.
I know this is not your deed, this is your wife's, but you all are a unit for these purposes, right?
My wife, yes,
Your partnership.
that's my wife, yes, correct.
Do you see the language in the, I guess you call it the third paragraph?
Which one does that start with?
I'll start reading it. Being condominium unit 2, building 30, phase 20. You see that language?
Yes, correct.
And it goes on to say that that it describes the declaration of condominium, Mill Creek Lakes condominium, which is often referred to as covenants. Declaration of covenants. And that's in the next paragraph that starts out, this conveyance is made subject to the declaration, which I just referred to, and all matters referenced therein. Now, I know you're not a lawyer. This is the first home you've ever bought. But you were aware, were you not, that by buying in a condominium or a townhouse development, there was something called covenants for that development that created an organization that took care of the common expenses of the home ownership organization. You generally were aware.
I was not aware of any of that. I didn't know about no HOA. I didn't know about any of that.
Okay. There's no reason you could not have been aware, was it? I mean, the documents are recorded at the courthouse, if you wanted to do that.
I wasn't aware of any of that. I just wanted to get a house. I never knew about HOAs. I never knew about the covenants. I had no clue. I had to educate myself.
Right. And I'm sure by this time you've become overly educated. And you are aware now, if you were not aware then, that the homeowners association is created by the covenants, and it's made up of representatives from the homeowners. They collect dues or assessments to pay the common expenses of the unit, of the development. And that would include the common areas such as streets and sidewalks and drainage swales, right?
Yes, sir.
So no question that when you bought the property, it was subject to the covenants, as you now understand.
Yes, as I now know. Yes, correct.
I won't bother you with all of the papers about covenants. Now, were you aware that the swale at the rear of your property was owned by the condominium association?
I was not aware of that.
Where did you think your property line ended? If you walked out your back door, what was your understanding of where the edge of Ibezims land ends and something else starts?
I thought we just owned the inside walls. I never knew we owned outside.
I'm not saying you do. So your sense was like that patio slab, not yours.
I thought it wasn't, no.
Okay. And it may not be. I just wondering what your perspective was.
So you own in the box.
That's what they said, the 4 walls in the condominium.
And the patio and everything beyond it, you did not own.
I thought it was common area. I did not think I would.
Or you may have owned a fractional share because you're one of 100.
Yeah, I learned that later.
And you also learned that actually the patio is referred to as a limited common area. It's owned by the association, but you have the use of it because it's with your unit, right?
I'm learning that now. Yes, correct.
All right. Okay. So but you did not have any expectation that you would be required to maintain the swale.
I had no clue what a swell was back then.
And you knew that WEG Mill Creek, we deeded the property to your wife, that they no longer own that unit.
They sold it to my wife, correct?
Sold it to your wife, and therefore they no longer own your unit.
My unit, yeah, because they sold it to us, of course, yes.
Right. Okay. If they didn't own it, they wouldn't have any expenses beyond, any responsibility beyond being responsible for what they've done up until that time. Not anything in the future. Because they didn't own it.
Because they own it? If that's what you say, yes, I guess I respect it.
I thought you agreed that when they sold the house to you, you now owned it, unit one, and they no longer owned it. And being no longer owners, they had no responsibility for anything after they sold it to you.
That's not what I understood it.
Do you understand that?
I didn't understand that, no.
Well, okay, let's go ahead a little bit. As a part of the deal, my client gave you a builder's warranty, correct?
Yes,
And you understood that the terms of the warranty, which are a booklet, which are multi-pages,
yes,
that would be their responsibility to deal with after the closing.
okay, yes,
And that warranty provided for filing a claim with a warranty company, which you eventually did.
correct.
Okay. And I'm going to show you Exhibit D-22. Now, do you recognize Exhibit D-22?
Yes, I do.
And what is that about?
This is, look like the warranty that got sent back to us, the inspection.
Okay. It's addressed to your wife, but then it's addressed properly to Mr. and Mrs.
Correct,
Okay. And this is from Quality Builders Warranty.
correct,
And it tells you the result of your warranty application
yes,
and gives you information as to how and when to appeal from that, correct?
it gives you information, but the information is not valid.
I'm sorry,
It's not valid,
it's not valid.
correct.
Says who?
It's inside this, if you read this warranty, it says that none of my concerns warrantable, they're not warrantable items.
You mean their decision was incorrect?
On this
That's what you
paper,
mean by not valid.
they said that the concerns that I had inside the warranty, when I asked them to come for the inspection, the inspector's defect inspection, they said it wasn't warrantable. Those are non-warrantable items.
All right. Offer defendants 22.
Mr. Stewart, any objection to defendants 22?
Yes, I object. That's a contract. It's not an issue in this lawsuit. It should not be clouded from the jury.
So is your objection relevance?
Yeah, relatives and prejudicial.
Okay. Mr. Dorsey?
Mr. McClellan, I agree that it can be into the record, not published, and not sent back, so subject to that perfect fine.
Okay, I think it is admissible. It is relevant. The jury will decide how prejudicial it is or it isn't. I won't rule yet whether it goes back with the jury or not. I'm less familiar with this document, but it is at a minimum in the record.
and sitting in front of Mr. Ibezims, so you can ask him questions about it.
Mr. Besom, now this letter from the Quality Builders Warranty,
Correct.
and just to flesh that out a little bit. Part of your deal with the builder, my client, was that they in effect bought a warranty product for you from Quality Builders Warranty. So that this isn't a warranty by the builder, this is a warranty by a third party, Quality Builders Warranty. You understood that, didn't you?
Understood that now.
Okay, all right. Part of your claim under this warranty was the water intrusion issue, correct?
Part of this warranty, I made a claim. Let me see, let me go back. It was part of what, excuse me again, I'm sorry.
Part of your claim.
Yes.
To Quality Builders Warranty.
Yes, yes.
Was the water intrusion.
Part of the claim was, yes, it was many of them. That was part of it, yes.
Any issues, including the water issue.
Yes.
And Quality Builders Warranty, look at page 2, please. You put it up first, Brent. Hey.
What we were having a discussion.
We're on D22.
Well, I know what we're on. Do we need to publish it, or is it something that Mr. Ibezim can look at and you can ask him?
It's short, so I'll just ask you.
Okay, let's do that.
Looking at page 2, the middle of the page.
Yes.
A little short paragraph that says builder responsibility.
Mm-hmm.
Okay, and the response to whether the builder responsibility was applicable to that issue was no evidence that water is ponding at the rear of the house. Now, you thought that was an incorrect.
It was very incorrect.
Okay, now, going back to the first page, middle of the page, after the bold letter paragraphs. And let's fill this in. Items 14 through 16 of your
Yes.
warranty claim. Builder has repaired or make, or has noted they intend to make repairs. So some of the repairs, some of the claims under the warranty were agreed to by my client, right? And this says they agree to make. I don't know that we need to.
Yeah, I would say yes.
Agreed to make some.
Okay.
But some they did not agree. And so the Quality Builders Warranty says, please note, if you disagree with these determinations in the letter, you must notify us within the next 30 days of your disagreement. Your next step is to in the warranty process is to proceed with arbitration for outstanding items. So you understood, you and your wife understood that if you wanted to pursue your warranty claim, you needed to let Quality Builders Warranty know that within 30 days.
That's correct. I said that on
You
paper.
decided not to pursue the warranty.
Is an and or on that. Like I said, this wasn't, the items that I needed repaired was non-warrantable, like they said. So only thing that was warrantable was the, let me read this, I remember, but I still remember, was the soil.
Well, for instance, this letter says they didn't find any evidence of ponding water around the house.
The ponding
You
water.
had a picture as of September of 18 of ponding water. You could have presented it. I object to this finding. Look here, here's a picture.
I sent Ian pictures of the house. He said that wasn't his property. Ian Silverstone.
And he's not with Quality Builders Warranty.
He governs them.
He testified he did not.
He does so govern them.
He buys a contract.
Okay, I'm sorry.
As a sales incentive.
So you need to ask questions and not testify, and you need to not interrupt, whether it's testifying or questioning. I'll manage it if it's testifying. Why don't you ask your next question, Mr. Pye?
Okay. You decided, for whatever reason, not to appeal the decision of Quality Builders Warranty.
I decided not to, yes.
Now, this was 4.5 years ago.
Correct.
If you had appealed and there'd been an arbitration as suggested here, this case might have been over 3 years ago.
No, yeah, no, sir. No,
But you decided not to pursue the warranty claim.
there was nothing to pursue, sir.
But the builder, my client, Waters Edge, did come out and do some work in your house as they had represented they would do, didn't they?
They did what they wanted to do. They pick and choose what they wanted to pick and fix.
But they did something.
It only did two things. Place the, if you want to be transparent, you can read the whole thing up of the warranty. You know, I asked for the soil to be checked. It said to be determined.
Now, you have testified that after moving into the residence, you decided to construct a fence at the rear of the property, right?
Constructed the fence, correct.
In fact, you did have a fence constructed. You
Correct.
hired a contractor to construct.
I didn't hire anybody. I went through the HOA, the portal, and necessary steps, because I don't own back there.
Who paid for the fence?
I had to pay for the fence.
Then my suggestion is, even if you didn't hire them, if you paid for them, you hire them. But that's just me. Up until that time, you had not had any water intrusion in your house that you knew of.
At this time,
Up until the time you chose to fence in the backyard, you had not had any water intrusion in the back.
at that time, no, because I couldn't see the backyard.
And so when did you decide to put the fence in?
On the day it got put up, I forgot that date. I know when I got permission to do it. I forgot what exact date it went up. I had videos.
Let me find, and I apologize.
While you're looking for that, I need us to take about a 4-minute break. So jurors, if you want to go back to the jury room, that's fine. You're welcome to stay right at ease, but I'll be back in about 4 minutes. Mr. Pye, you should have that document lined up, okay? And Mr. Ibezims, if you want to step down, you can.
Okay, thank you.
It's to be super short.
We're good. Okay.
All right, to the jury.
I gotta go to the restroom.
The seats are way more comfy.
We definitely want the ones that right at 400 words. I'm not looking at this. I just see this up.
Riveting, huh?
I got big watching. It's all in caps.
Are you gonna need me to swing by tomorrow morning as well? Okay. My hiccups apparently. Yeah, that's the last one.
So one of the witnesses mentioned a Nikki Dunn.
Nikki, I didn't hear a word Nikki. You're talking about landscape first, Mr. Dutton. Maybe Mr. Dutton is the Nikki.
Dutton to UTCO.
You asked me right there.
I could have sworn maybe you would feel fast. That's all right.
Okay.
You know, his pockets, I'm trying to find my purse, I don't know exactly where my phone is.
Got my card next to me.
Yeah, 4 minutes turn to 10 minutes.
You're gonna be in contempt. You don't mess with the judge. We do a lot of things. I'm trying to get you to your party. The man got a lot of, he got a lot to manage when you're managing a courtroom, and it's a lot. It's a whole lot.
Air Force. Here's yeah, 6 he would be deployed to Europe and leave his life in 600. He would come home. He was used to being in charge. He learned really quick. Not in charge at home. Mama is in charge of
Yeah. You learn that real quick.
Came home to the captain, right?
Wow.
Yeah.
Who are you?
Yeah.
Oh, Lou.
Yeah, my father was in Vietnam shortly after I was born. My mother said when he came back, I didn't want to have anybody to do it. So I didn't. But, yeah.
Tough being in the service.
It is. I never, I spent 20 years, I never got assigned out of the United States. Not that, I wouldn't call it deployed, I went to Tokyo. For training. So I was, I wanted to go to other places. I got some good assignments.
Here it comes.
Court come to order, remain seated.
Whoa, new deputy. Right? That's the kind of voice I like hearing.
Yeah, it's fresh.
All right, everyone can be seated. So I need to know how late you all want to go. It's almost 5. We're not going to go way past 5. We'll get to a natural break point of the one that I artificially created because it's something I had to deal with. 5:10, 5:15, 5 o'clock sharp. You're done. Seems like we should do a few more questions since I made you sit around for these minutes. But I don't know if people have childcare issues. I'm getting a lot of nodding as in.
5 o'clock sharp. Sounds good.
Okay. So I bet it's not childcare for you, but
And he was eating.
it's going to be snack time. Right?
You owe him because of the snack.
We'll stop as close to 5 as we hit a natural point. It won't be many minutes past. So it's 5, all right? Just let's keep going, Mr. Pye. On point. Have those exhibits ready. It's a lot of paper shuffling. All right.
Mr. Beeson, I put a paper in front of me.
Yes.
Exhibit D15. That is the letter from the warranty company to your wife, and you denying the claim, correct? I beg your pardon, I got the wrong. This is the letter from the Homeowners Association Community Manager, Mr. Tolley, granting your application to put in a fence.
Yes.
And this is dated June 18, 2018, which is about 3.5 months after you bought the unit.
Correct.
Your application was made a week or so before this.
I don't have the application in front of me.
How long did you wait before you got the green light?
Before I grant, we didn't get the green light right away. We had a lot of back and forth with Tally management.
Okay, so my question was, if you got on June 18th, the approval letter, was that a month after you requested to build a fence or a day after you?
It was probably a couple months.
Couple months.
Yeah, about 2 months.
So you requested to build a fence back in April, like soon after you moved in?
Yeah, about 2 months after I moved in.
Okay.
2 months after.
As a matter of curiosity, was there any reason why you did not include a fence in your contract to buy the unit and have the builder build a fence?
I wasn't aware we could have a fence.
Wasn't aware that what?
We could have a fence. I didn't know.
But somehow you found you could have a fence, but it had to be approved by the architectural control committee.
By the HOA, yes, correct.
You remember how you found out about that? Were you given some sort of welcome to the community packet by the HOA when you bought a unit, or they gave you some rules, procedures?
At the closing, I think he gave us a packet, but we didn't know who the HOA was. They never introduced themselves and never came to us.
You knew you had to request permission. You did request permission and
Yes.
granted permission.
Yes,
And this letter is that granting of permission.
correct.
Offer defendants 15.
Any objection to defendants 15, Mr. Stewart?
Oh, yeah.
Mr. Dorsey?
No objection, Your Honor.
Admitted.
Looking at the first paragraph, it says, owner is responsible for maintaining the fence. You understood that, didn't you? You paid for it.
Yes,
And homeowner will be responsible for upkeep of the backyard. Now, in this case, that's the patio, right?
he said if the gate was be locked, my gate was never locked.
Or, excuse me, should the gate to the backyard be locked, homeowner be responsible for upkeep of the backyard? Who do you think's responsible if you didn't lock the backyard?
The HOA?
HOA. You keep the gate locked 24/7?
No, I don't keep my gate locked at all.
So the HOA's been responsible for you, for the patio, pretty much since you bought the property, except when you're locked?
My gate is never locked, so I have a camera back there. I don't keep my gate locked.
Okay. All right, so you had the fence installed. And I took some notes of your direct testimony. And did you say that the fence company gave you a drawing of the fence? Not maybe exactly accurate, but a drawing of the fence that they wanted to install.
What I gather, we had to get the stipulation, we had to make the request, but we also had go with Pennington Fence. We had no other choices. We didn't have no say in the matter. So I contacted Pennington Fence and I said, look, I have a fence back there. He said, I'm not too sure about your property or how it is. He said, what's your address? I gave him my address. He said there's somebody with the fence 2 doors down. So we can probably copy off of the schematic. So I guess he copied and pasted off of the same thing they did 2 houses down for me.
Did that include a drawing or sketch of the fence?
Yes.
And did you say that that indicated that there would be a 2-inch clearance?
Yeah, yes.
Bottom of the fence?
Yes.
Okay. Was the fence installed with a clearance at the bottom?
Correct. Yes, it was.
Did you measure it, see if it's 2 inches?
I was there and I asked them actually to think I was there. I think I actually needed to put it probably where I was here in grade level. He said you could not do that. It was illegal. You had to have so much a gap underneath the fence for it to be.
So it was installed with 2 inches,
Yes,
but that wasn't enough gap, was it?
it was sufficient at the time. If I could see through it and put my hand through it, it was
Didn't
sufficient.
you testify earlier that leaves and pine straw jammed up against the fence?
I also said that. Also said the ground
Couldn't get
moves.
through because of the debris packed up against the fence, and you had to get a shovel and shovel it out.
Correct.
Didn't that tell you that the gap at the bottom of the fence was insufficient to allow water to flow out of your backyard?
No.
And if water couldn't flow out of your backyard, it would pond in the backyard.
No.
And are you telling this jury that even though there was pine straw and leaves and mud and dirt that had to be shoveled out, that the lack of gap at the bottom of the fence was not the cause of water?
No, that wasn't a fault.
Are you gonna ask more about the fence or something different now?
It's gonna cover something.
Great, then that'll be our break time because the jury spoke through body language and words that 5 is when they would like to stop. And so there's a natural shift in subject. Ladies and gentlemen, it is Wednesday night. Enjoy your Wednesday night. No outside research. Don't go see how much you can fit under the 2-inch gap of your fence or anything like that. Don't talk about the case with others. We're gonna start at 9 tomorrow, so please be on time like you have been. Any logistical questions? Yes, ma'am.
Do you still think, Judge, that will be done by Friday?
It's a great question. Mr. Stewart, do you still think that we'll be done by Friday?
I plan we'll rest tomorrow morning before noon. That'll be up to the defense and the third defense, I guess.
Way to pass the buck, Mr. McLeod.
Very quickly, Your Honor, we're only likely going to call 3 or 4 witnesses, and we're going to move as fast as we can.
All right. Well, hopefully we can use that adage that past performance is not a guarantee of future performance.
I understand with a couple of questions.
Yeah. Mr. Dorsey, your thoughts about timing?
Your Honor, I will have 2 witnesses at absolute most, so we should be in and out pretty quickly.
Okay. And it may well be that some of the witnesses are recalls. In other words, they're witnesses we've heard from, so it'll be all the more streamlined.
Right.
Okay, great. So maybe?
Maybe.
All right. Thanks, everyone.
All right.
Have a good night.
Bye.
Yeah, they won't. Yes. All right, you all, please be seated. Mr. Stewart, anything we need to talk about before we go off the record?
Oglethorpe, we submit that and you're gonna look at that and give us some kind of feedback on about.
I think it stands for the proposition you said.
Okay, thank you. I didn't want to.
Sure. Mr. McLeod, Mr. Dorsey.
No, Your Honor, only the witness is still on the stand, and that obviously there's no direction or consultation with counsel permitted, given that he's still.
Sure. So you don't have to spend the night sitting right there, but you and Mr. Stewart need to not talk about how your testimony has gone or what might still come, because you're in the midst of that examination. Sort of like there's no coaching in the middle of that. So you and Mr. Stewart may talk about the case, but please don't say, how have I been doing? What do I do when Mr. Pai asks this next question? That's off limits.
I totally understand. Yeah.
Excellent. Glad you do. Let me think if I have anything else. Poor Ms. Niles has been working hard on the jury charge. No one made it easy for her. And there are also some issues that are still trying to figure out apportionment, contribution, indemnification. It's murky. Continuing nuisance versus the other forms. And I'm not quite sure what the draft charge is going to look like. It may have a bunch of, or we give this, or we give this. But we do need to have a charge conference, and I've got a sneaking suspicion that none of you will make that a quick charge conference. So we may work late one night, and you can decide not to take the charge conference down, or we'll have a court reporter here for that. But we will take care of the charge conference at a time outside of 9 to 5, because I am anxious, like that one juror, to try to keep us within the time frame that you all suggested.
So, Your Honor, that'd be probably tomorrow night, hopefully.
Well, that will make Mr. Kyle sad. So I don't know that it would be tomorrow night, but I don't know that we have another option, because it's not going to be Friday night. And it's not going to be 6 a.m. Friday morning. So it will likely be tomorrow night. I have to go through it first. Poor Ms. Niles hasn't even gotten me the draft. So I will go through that and then we'll talk. Of course, if you all rest at 3 tomorrow, then it would be that we start at 3. But somehow I don't see that happening. So be at ease for the rest of the night. I don't see that there's anything pending right now that we need to discuss. So if you all could be here by 8:50, 8:50, just in case you come up with something overnight,
we can work through that. You know what, Mr. Kyle, I forgot to talk with the jury about the exchange about, hey, I do have these more recent videos. I'll make a note to do that first thing in the morning because we still have Mr. Ibezims on the stand. If there's any particular language that you think ought to be woven in, please email it to Ms. Niles and all counsel. Otherwise, I'll craft something that generically says that you need to disregard that. It's not before you. It's not part of the record in this case.
Judge, I believe there's a uniform charge on that. Party has a document to repel a claim and does not.
We've already talked about that, and that doesn't quite fit this scenario because we don't know what those videos show. And Mr. Stewart's observation on the record that, yeah, but we can't really use these is accurate. I mean, you would be able to say you can't use it because this is late provided discovery. So, but I will talk with the jury about that. I'll make a note I can't miss. So I think that's it. Thank you, everyone.
Thank you.
Your Honor.
Shall I leave this here, Your Honor?
Yep.
Yeah, hold on, don't leave because Mr. Alston needs to ask you each the standard question. You're good.
Mr. Stewart, would you like to transfer this?
Not tonight, no, thank you.
Yes, sir. Mr. Dorsey, would you like to transfer?
No, sir.
Mr. Cloud, transfer. And Mr. Pye. We're off the record at 5:09 p.m.
Mr. Alston, you are not back tomorrow, is that correct?
That's correct, Your Honor. Vertex will be sending another,
But it'll be Veritext.
unless your office calls another agency. I've already.
I don't
let
call
Veritex-
anyone.
Well, yeah,
It's-
that's right, it's counsel.
Yeah.
But I told Veritex, first thing this morning,
Okay.
and I sent them the draft order that you, not the draft, order that you wrote up.
Get
for us.
people in early, yeah.
A copy of that, so
Good.
they should- and they said they were going to do it.
Okay, good. Well, it's been nice working with you. Thanks for your time.
Thank you.
Have a good day.
No, I'm good. Thank you. I appreciate it. Yep, I'll be strong.
I'm not gonna be here tomorrow, but yeah, another. I'm gonna leave the exhibits where they are now. Okay. I'm also gonna leave the exhibit list that I have, and I'll get cards.
Thank you, sir. I appreciate the exhibits on the judge's desk.
I will, but that person's coming in early, I don't know if they'll know.
But if you leave them, just give them to me right now and I'll keep them up here. I'll make sure that they get back to the exhibit bench. They'll just be less apt to wander away.
So cleaning person inadvertently takes.
Yeah. Thank you, sir.
I was about to say, all these lessons normally come from something.
Wind it up. And special damages.
I think this one is actually supposed to stay up there.
G14, okay.